Life will write very interesting stories, which is actually the beautiful thing about creative life overall. Learning can never stop. There is always something new, and I learn from my patients. And each one of us will use that choice based on the use that you have to put the technology to. The first thing that so see how a human story and politics. One of the a person may have a very average time and extremely successful, but it's not supply chain supply chain. And I'm happy to announce that we are still in the pilot stage and the discussion is going on. Some supplement, I will ask people to get borrowed from Confident because for the speaking of us, we have shown that it becomes smart and different. So very good morning, ladies and gentlemen. Before we proceed, could I please request everyone to kindly put their mobile phones on silent or vibrate only mode? A very good morning, ladies and gentlemen. It is my pleasure to welcome you all to BW Legal World Annual Legal Leaders Conclave 2023. BW Legal World Annual Legal Leaders Conclave and Awards is a conference to recognize the advancement and development of the diverse facets of legal industry. The theme of the conclave this year is Top Indian Lawyers Navigating the Ever-Changing Legal Landscape. Well, my name is Sahib Jeet Kaur and I am glad to be a host for the day. We are joined by around 100 amazing lawyers and academicians who are stalwarts in their respective domains and will enlighten our minds through their time and experience in the legal industry. During the day, we will witness experts speak in panel discussions on various topics of the law. In the evening, we will be celebrating and awarding 30 under 30 and 40 under 40 lawyers and legal influencers. If I may please request everybody's undivided attention towards the big beautiful screen, I would like to play for event AD. Launched in 2018, EW World is a community of EW business world, a 4-decade-old publication that has since consistently ranked amongst India's largest and most respected business magazine. Before moving forward, let's quickly take a look at the EW World community overview. Travel business were led by Dr. Imran Putra, Chairman and Editor-in-Chief, Travel Business World and Exchange for Media Group, is the fastest growing business media house in the country. With a network spanning across 25 niche business communities and 8 magazines, W Business World is proud to be entrenched in various verticals in the domestic as well as global business ecosystem. With changing times, PW now has a massive leadership in the digital space as well. PW in its portfolio has 24 regional communities that organize conferences and forums to facilitate interaction between sectoral business leaders and create a conducive environment for collaboration. Stay updated on developments by subscribing to the magazine within the Business World Group. And once your professional journey with knowledge and insights, special offers are available for the attendees. Our latest issue brings in one stop these schools and looks at how management education is changing in the age of India. For more information, please get in touch with Mr. Vinod at the registration counter. Well, I request everyone to join our ongoing conversation by using the hashtag Latest control. In case you're planning to post any pictures, videos, or comments related to this event across our social media platforms, please do not forget to use the hashtag #legal latest control. You can also watch us live on www.meetavlegal.com and on our social media platforms. Before starting the day, ladies and gentlemen, I'd like to take a moment and express our deepest gratitude to our partners helping us turning our vision into reality. Knowledge Partner, Honest Partners, and Optimists. Elite Partners, joytravels.com, Tantrum, Daily Coffee, Just About AI, The Big Shake Factory, Reality, Stores for Media, iwnplus.com, Impact and Pitch. We will be joined by our chief guest, Honorable Justice Mukta Gupta, former judge of the Delhi High Court in the evening. And now, without any further ado, ladies and gentlemen, to give you all a warm welcome, please welcome our chairman and editor-in-chief, Dr. Anurag Batra.
Morning, it's my honor and privilege to be here. We've completed 4+ years of BW Legal Work. First of all, my gratitude to everyone who's contributed to it. I'm primarily here because Mr. Lalit Basin is here. Otherwise, I would have come a little later, but I do be grateful for his continuous support to BW Legal Work, being involved in our initiatives, giving time for opportunities, and really contributing in this way. And he's older than my father, which is 1 year older than my father. And my friend Mr. Sundaram did not represent my father-in-law had born this day before yesterday. So I was just, first of all, gratitude to Mr. Basim for making time, to all of you for making time. I know you were professional endeavor, and Mr. Basim is rightly saying that the idea was for 250 and the book should have been there. Look at the quality of the content. But I'm sure during the day we'll have an absolutely fantastic turnout, I know. So just want to say that on 12 December 2019, we had the first event of BW. It was the Global Legal Summit, which is basically where law firms award agencies and it's calendar. I stand between me and Mr. Basim address, but I just want to say that this environment is very, very dynamic. That's professional, that business environment is becoming quite important. The services domain will grow 4 times in the next 3 years. So what is the aggregated fees that go to law firms, litigation, and arbitration, that will become most surveys say that it will become 4 times in the next 3 years. It may even happen in 2 years. The way it is growing. Today in the private schools, welcome Pranav. And Surat, it's the largest building of its kind. So really the scale in India of everything is growing. I just want to say that as you look, I will only say that the 3 C's, we all are humans, so we can't make it zero, but if we can make up zero, we can. 1 C is comparison. While we all want to grow, and we must grow both in knowledge, financially, in our role and responsibilities, but don't compare. Everyone's journey is unique. People compare, that's true, but if you can minimize it, I use it as an inspiration. Second is don't criticize. Sometimes we criticize people without knowing what their background is, what are the circumstances they are doing, what they're doing. So don't criticize. Last, don't complain. We are blessed after COVID. If we are alive, we're getting everything else in a bonus, right? So don't compare. don't criticize, don't complain. It's tough. It's tough. Day before yesterday, I read something and said, go without complaining for 24 hours. Yesterday, I tried that and I can't say I didn't complain, but I had a sales and business meeting. So, but I was very nice in that. I will tell you, I didn't make anyone feel uncomfortable. Sometimes I can be aggressive in the meeting, but right. So Saturday are for sales and business review. So I try and follow what I'm doing. I've become myself calmer in the last 1 year. I was with somebody and the person told me, you're calmer. One of my very close friends who works with me, I have become calmer. So he actually took into my turning out. No, I don't know. But I have a conscious effort of being calmer. So everything is possible in life. I also want to request you to embrace the three H's. The three H's are first is hard work. Mr. Basim is there for the junior league. What initiative he signs up for, he's there. And he gives it all that he has, whatever his knowledge is, whatever his acumen is, of course his time. So, he puts in the hours, it takes efforts, he will show up for his social engagements. He has his own law firm, he has a family, he has social obligations, he's the president or founder, president of SELF, he has relationships with every media company. So he's able to do that, he puts in the hours. I can tell you, I am lucky at business world. I have a team who puts in the hours. That's why we're able to, it does take focus, time to do it. So work hard. Second is humility. The more you grow, you have to be grateful for you have, for what you have, and the grateful should be reflected in your humility. And third is hope. I genuinely wake up every morning really genuinely believing today is my best day. I'll give it my best. And I'm sure it'll be better than yesterday. And I enjoy whatever it is. So I don't want to stay between your and Mr. Lalit Basim's speech. He will talk to you about what's happening in the legal profession, how should you prime up yourself for the future. And I'm sure it'll be an engrossing speech. You'll learn from it. I wish you luck in your endeavors. Business is growing, legal services domain is growing. There is super specializing happening. There are more domains that are coming up. Look at what has happened in gaming. Suddenly, the gaming landscape in 4 months has changed. Look at what's happening in the metaverse. Look at what's happening in crypto. Look at what's happening in blockchain. So it's a very, very dynamic world with policy changes, with geopolitics. Look at what's happened in the supply chain ecosystem because of bottlenecks in certain parts of the world. So really, the role of a lawyer is a business person who understands legal nuances, who understands governance, compliance, strategic solutions, plus the trade-offs between multiple options available, and be able to advise the promoter, CEO, the stakeholders on what to take. So you have a large role to play in India's growth. I'm sure we'll do well in the evening at 6:30 p.m. We have the BW Legal World 40 under 40. We do our awards through a jury process. I don't even know. I know because then people call me who haven't won and try to put pressure. And I'm very sensitive. I take every call. I try to tell them what happened because, I tell my son I'm in a service business and, be empathetic because I have two children who apply for awards and when they don't want, I see how it impacts them. So I'm very, very sensitive. But we absolutely honestly, there are very accomplished people who did not present well on the day of the people know shortlisted in 3 years they haven't won. Some have won after 3 tries. So we don't. So you see the winners, it's a very good quality of winners. I saw the list on Friday. The 30 under 30 list was primarily decided by Mr. Lalit Basim. Is a good list. And we've totally gone, and Mr. Basim has been part of 3 of our juries. And we never, whatever the jury chairman or jury does, totally stick by it. All awards are honest. No process is perfect. It can be close to perfect. And as Mr. Basim will attest, I'm assuming the only one that is perfect is Lord Shiva and my wife. Everybody else is close to perfect. But you say, I think 90 out of the 40 units, 56 are coming, and out of the 30 units, 28 are coming. So that is pretty much 100% of the winners are somehow coming with their families. Some asked to attend the whole event, so you'll see them there. So it's a very good quality of selection or a cohort that the jury has done. Please give the jury a big round of applause. Uh, Justice Mukta Gupta will be the chief guest. He retired Justice. Dr. Lalit Bhasin told me we should also get some active players in. So the next one we'll do, we'll get in active players. We must also do something in Mumbai. We must do something in Middle East because it was becoming a center for business. So these are things he was telling me. Please give Mr. Lalit Bhasin a big round of applause. She doesn't really need an introduction, but I'll let Saib formally introduce for some people who may be new to understand the giant emerge.
Hard work, humility, and hope. Ladies and gentlemen, let's give a big round of applause to Dr. Batra. Thank you for sharing your views. And now for the much anticipated segment, ladies and gentlemen, a personality who needs no introduction with a big round of applause is Dr. Lalit Bhasin, who is our partner, Bhasin, and continue to share his views.
Thank you, Ms. Kaur. The inimitable Dr. Anurag Batra, who has been a pioneer in promoting legal awareness, legal education, and legal practice. I have seen it, I have experienced it, I have participated in it now for many, many years. He said one wrong thing that you people will learn something from what I have to say. I think what I had in mind was that this is an event to honor and recognize the merit of 30 under 30 and 40 under 40. So for 40 under 40, they are already established lawyers. They have put in 10 years to 15 years of law practice. Therefore, to tell them anything about law, I think it's an exercise in futility because they have already gained the expertise, the experience in the fields in which they are practicing law, whether they are practicing lawyers, external lawyers, or whether they are part of some in-house legal team. Therefore, my idea was not to tell you something from which you will learn, because you already know something, but in return, I would like to learn something and I would like to raise some issues with you, particularly from those very few who are present among the recipients of the awards, as to what are the issues which are facing. Because I face these issues in my practice, which is now of 61 years, and I would like to share those issues with you and to get your inputs. That is a learning process for me. So I'm not going to teach you anything, to tell you anything. You already know about it. But yes, there are some law students also here. They may learn something because the issues which we are going to discuss would have a great impact on when you start your practice of law, whether as in-house counsel, whether as a litigation lawyer, or even as a law teacher. What are the issues which are facing the profession in particular and the global world, you see, in general? First and foremost is the use of technology. we talk about artificial intelligence. I don't know anything about artificial intelligence because I am a firm believer in real intelligence, not just artificial intelligence, because the artificial intelligence is also a creation of the human brain, human mind. But what is it? How would it impact? You see, the law practice, how would it impact, you see, the economy of the countries? How would it affect the legal profession? The other day I was in Pune sharing some views with the Honorable Chief Justice of India at the convocation of symbiosis. He said that we have digitized, you see, most of the filing work. There is a ease of filing of cases, ease of filing of affidavits, petitions, so which helps and facilitates the litigant by reducing the cost, you see, of litigation, and it facilitates ease of filing. I was to speak after that, and I shared my views with him. I say, Your Lordship is right. You have facilitated the filing, the ease of for the litigant. Cost has gone down. But what about the disposal? Will the disposal come from artificial intelligence or technology? Yes, it may help you in doing some research work. You want to know case law or natural justice, so you will find it readily available on so many platforms. You see, you will have that. Any type of research would help you, you see, in gaining some knowledge. But then what about the disposal? Disposal cannot come from artificial intelligence. Artificial intelligence can be used as a supportive measure, but not as a decisive measure, you see. That decision has to come from here because each case has to be decided on its own facts. And facts of no two cases are similar. All the facts would be different. So I raised these issues. I said, how do you cope up with this notorious laws delays? 5 crore cases pending, 80,000 cases pending in the Supreme Court, 61 lakh cases pending in the high courts, 4 crore something pending in the district courts. So how will the technology help in disposal of these matters which are pending? Then another issue arises. Are the citizens of this country getting justice? The decisions which are being made, they pertain to, you see, all high constitutional matters, Article 320, Mandir Masjid disputes, on reservations, on everything. But what about those cases of the ordinary citizens which are pending in the courts, whether district courts or the high courts or even in the Supreme Court? Those cases are not being disposed of. So the question which arises, for your consideration, I would like to have your views, is are the citizens of this country getting justice, which is a mandate given under our constitution? If you see the very first preamble of our constitution, it says that we, people of India, have to secure for ourselves justice. This is the first preamble. Justice, social, economic, political. Are we getting that justice? No. We are getting law. Law is different from justice. Law is a part of justice. The eventual goal is to get the justice for the citizens of this country, which people are not getting, at least the judicial justice. Economic justice is still far off. Political is also far off. But even with regard to the day-to-day pendency of cases, you see that is increasing. And with the ease of filing of cases, this will increase further. But the disposal will not match. You see the filing of the matters in the courts. That is one very big crucial issue. Some of you would possibly, those who are lawyers may also be a part of law firms. You are engaged in corporate work. The issue which comes for consideration, which I have faced, is that our government, the present government, the Prime Minister, he very rightly speaks about ease of doing business. Now, in your experience as lawyers, I can't talk about students because you don't have as yet that experience. But the General Counsel are here, the Sundaram is here, and everyone, they would be able to respond. Whether it is only a lip service or there is a genuine ease of doing business so far India is concerned. Are there any relaxations in the regulations? Because we are not into self-regulation. We are accustomed to regulations being imposed on us every day, possibly at the drop of the hat. We have new laws coming in. These new laws bring in new regulators. These new laws bring in disputes. Good for lawyers, but bad for the country, bad for the economy. So is there in reality ease of doing business? That is very relevant for those who want to practice or who are practicing on the corporate side, and those who are advising big business houses, you see, as the General Counsel and as in-house counsel. So, what is the answer? I have 20 minutes were allotted to me. In 10 minutes, I have tried to raise the issues. Now, I would like have a dialogue with you, some of you. Firstly, I would like to know what is the role of technology you feel can be helpful in reducing the law's delays. Are there hand mics? Please give it to someone. Anyone who wants to speak, please speak, because after this present session, you will only have speakers who will tell you what they want to speak about. But I want to know from you, what do you feel about these two basic issues? That is artificial intelligence and in reality, does ease of business exist? So anyone who wants to speak. Yeah. Students first and very briefly, 2 minutes. Please tell your name also.
My name is Ria, and I'm from Maharashtra University, Law School.
Just get the mic, please.
I think that artificial intelligence disables students and legal professionals in trying for their own in the world. And I think that somehow it disables them from actual hard work. Like Sir had mentioned, that it is very important in life. And that is what I think, that this disables us from actually getting the knowledge that we deserve. Typing few words on the internet and getting some crux of the information is not enough. I think a well-read person is more intelligent than a person who has accessed artificial intelligence. That is my personal
Good, good, very good. Anyone else, please? Yeah. I had seen some hand being raised. Yeah. There. Let some senior people also speak. Yeah.
Sir. Rajiv Chaudhary this side, General Counsel of Dalmia Group. So this is my personal view. In terms of ease of doing business, I think we have seen a lot of positive changes. And in fact, one of the positive changes is decriminalization of some of the provisions of Companies Act and other laws also, like legal metrology. If there's a small violation, there used to be a prosecution against the entire board if you're not nominated one of the directors, and it leads to a lot of hassles. And I think even the labor code has already been affected, but it's a positive steps towards ease of doing business. I think the difficulty which we face, and this is my personal view, not my organization view, is that there is no ease of doing business, or there's a lot of work needs to be done at the state level. While India's ranking in terms of ease of doing business has improved a lot because of the initiative taken by the successive governments, and especially in the last 10 years. But I think the state governments, because we have a federal character of government, so there are a lot of state governments which have to travel a lot in terms of ease of doing business. And I think land is one area, especially like from manufacturing background. You get the auction, but it is it is impossible to get land because of the strict land laws which we are having. And similarly, a lot of license and permits which should be given. I think if all this is given, used out, our economy can grow much faster, is what I feel.
But in reality, there is no ease of doing business, because it starts with when you want to start a business. You need so many permissions and sanctions and approvals. I can tell you with some certainty, because I have some knowledge about this sector, the hospitality sector. For setting up hotels, you see, you need about 156 approvals from different authorities and all that. So there has been no progress so far that aspect is concerned, and that needs to be highlighted to the our rulers, you see, who make and also parliamentarians who make laws. You see that there should be ease of doing business in the real sense. We talk about one window clearance. Is it there? You are the experts, you are the general counsel. You tell me, is there one window clearance now available to anyone? No, it is not. Anyone else, please? Mr. Sundram, yes.
Sir, thank you so much. You brought it out very nicely to the young lawyers I can see around. On the point of artificial intelligence, even the Delhi High Court said in the context of ChatGPT, and we all know how the New York courts also said. So it's very, very clear that when we talk about technology, we are not talking of substitution of human intelligence with artificial intelligence. That substitution is definitely not going to be there. The human mind and the brain will always be above artificial intelligence. It's a human brain which will manage artificial intelligence, not the vice versa. So that's the first thing that we should be absolutely clear about. Is artificial intelligence and technology going to reduce the number of pendency of the cases? Some of the areas, as we can see, especially in when we talk about online dispute resolution, high volume, low value cases, those petty motor vehicle transport challans, even section 138, these are a couple of high volume, low value cases which can still be resolved by online dispute resolution mechanism by the use of technology. But when it comes to your application of mind, I think human brains will supersede the technology.
That's right. Yeah, very, very relevant. And the issue here is that artificial intelligence has its own benefits, the uses, but also the abuse of artificial intelligence. And that is what is being debated upon, not only in India, but all over. how to control and regulate this artificial intelligence. And so far as legal profession is concerned, you are right. In these areas, it could result in reduction of our pendency of cases. But in effect, it will not, because the ease of filing of cases is increasing. So the number of cases which will be filed would not have any ratio, you see, so far as the disposal of the cases is concerned. And that is what needs to be looked into. The only solution, and I can share that with you, I have said so in many public platforms, that government is the largest litigant. I'm talking of India here now. Government is the largest litigant, having about 60 to 70% cases which are filed, you see, either against the government, or if the government loses, it definitely goes in appeal or revisions or reviews and all that, because it's a question of ego for the state governments or the central government, why we have lost this case. Therefore, if there is a change in the mindset of the bureaucracy, the governments, to reduce the pendency will straight away get reduced to less than even 50% if the government has this. There was a move that disputes intercede between public sector undertakings and others that could be referred to a committee of secretaries, but all that is on paper, only black and white, but nothing has come out of that. Therefore, this pendency of cases, it has to do something, because that is the only way we can provide justice to the people of this country, which they are not getting at the moment, because litigation as a means of resolving dispute has totally failed in India. There is a complete breakdown. Arbitration has not helped. Arbitration again, you see, has become very expensive. And with due respect to the retired judges, it is being monopolized, cartelized, you see, by all the retired judges, whether of the Supreme Court or the High Court, making it very, very expensive, very prolonged. Where does the citizen get justice from then? Only answer is samjhauta, settlement of disputes, mediation. Therefore, there is a big responsibility on the legal profession, the General Counsel, in-house counsel, the lawyers, to have this sort change in mindset of people, to advise the clients. And I say that repeatedly, a bad settlement is better than successful litigation. If I try to have settlements, some give and take, but for that there has to be a change in the mindset of people. The law schools have to inculcate that feeling, that educate the students to promote, you see, this type of atmosphere which could result in settlement of disputes. Negotiation skills have to be developed in the schools, in the law schools, and among the junior people. Therefore, my suggestion to all of you, and it was good to hear the views of some of the eminent General Counsel here and from the student. So, give back to society by bringing justice to the citizens of this country. That will be your biggest contribution for the students, you see, who will join the law, and for the practicing lawyers to please adopt this. Have a change of mindset, firstly, in yourself also. Thank you very much.
If I may ask one, I'm not a pessimist. I'm not a pessimist. And I like India and everything that I am. But it's a little larger question than legal. Today there is more affluence, there is more money, there is more abundance. But the quality of life and the depth of everything we do is coming down. How can we as individuals, will come to deal with that, because I feel, for example, India is growing in every aspect. but our air is bad, quality of water is bad, there is an urban mess in terms of traffic. We are too focused on making money.
You're absolutely right. But Dr. Anurag Batra, your organization starts with the word business, you see, whether it is business world, business legal, and all that. Therefore, you see affluence so far as the business world is concerned.
But there is another world.
There is this world, that Bharvi, the slums, and all that. We don't think about that. And when I say justice to the citizens, I mean those citizens, not these business people whose cases are have taken priority, you see, over all other matters, and they are decided with great speed. What about the citizen? Therefore, when we say affluence, we also have to see the fragile part of our society, which is the lower, you see, income people, the poor people. We still have poverty in this country. Although we say we'll become the biggest economic power among the big five and all that, but we still have, you see, poverty in this country. And thank you.
Usually or collectively, what we desire, what we wish for, what we want, we take from the world. Perhaps it's time to give back as well. Thank you, Dr. Basim. Thank you very much. With the same, ladies and gentlemen, we are headed towards the first panel discussion of the day. General Counsel's role to address emerging business challenges. Join me as I welcome our panelists. Please give it up for Mr. Abdul Quran Surjan, General Counsel, Senior Vice President, Legal, and also Corporation. Please welcome Ms. Ayan Kuran, Director, Legal, Shaker, India. Please welcome Mr. Indra, Director, Legal, Freshworks. Please give it up for Mr. Rachel Chandraguru, General Counsel, Director. Please give it up for Ms. Sharma Motial, Vice President, Legal, HDFC Limited. Was the session chair, Dr. Anurag Batra, Chairman and Editor General of the W Business World and Exchange Media Group.
Please give Mr. Abdul Basim a big round of applause. It makes me think, recreate the things that matter. So, now we have a GC panel. When we started BW Legal World, there are legal platforms that are available, and life is abundant, about abundance. Everyone should do well. But we chose to be the homepage of the GC. That's how we define ourselves. Because we believe we are at the cusp of business and law. We're not about courts. That's not how we define our existence. So really for us, GCs are a core audience. In fact, today we'll also announce our jury panel for our GC 100 and our GC awards that are in Feb or March. So really this is an important session. The General Counsel's role has grown in the last decade. Their remuneration has grown in the last decade. A lot of them have started to make it to the boards. Still a long way to go, but the General Counsel is very important, or among the most important stakeholders when it comes to the business world and the legal world. Today we are discussing how our General Counsel is evolving to deal with modern day challenges. So let me start by asking each one of them for their opening comments, and then I'll raise some specific questions about what do they see the role of the GC in the future, how much emphasis they have on compliance, how much on risk, how much on governance, how much on business, what are the challenges they face, what is their advice to the younger people in the room. But let me start with Mr. Amar Sundaram for his opening comments on how has the role of a GC changed in the last few years.
Thank you, Anurag. And first and foremost, We all GCs community thank Dr. Lalit Bhasin and Dr. Anurag Batra for the kind of support that they have always extended to the in-house counsels and general counsels. This support has been the major contribution in recognizing the efforts of the GCs on a number of public platforms. So thank you so much, Anurag, for doing what you are doing. And we hope you will continue to support us. Same for Dr. Bhasin. We definitely need your blessings and advice. But coming back to your question, Anurag, let me share a couple of data points. So, Association of Corporate Counsel (ACC) just came out with a survey report, which is a CLO survey report of 2023, and they captured the feedback from almost 900 CLOs across.
CLO meaning Chief Legal Officer, which is like GCs and the terminology, but it's really the kind of people on the panel.
And they surveyed some 900 general counsels, the CLOs, the chief legal officers across 20 sectors in 35 countries. And they came out with a data point that 78% of them are reporting directly to the CEO, which was, and this is 2023, which was 66% in 2018. So that jump of 6% in terms of a direct reporting to the CEO. If you go back to those traditional reporting structure, they were reporting to the CFO or HR head or maybe the commercial head. 51% of them are reporting directly to the board. So that's the changing contour of the in-house general counsels within the organizations. So that's how people are looking at it, that as business is growing, new complications are coming up, especially in the context of India. The role of GCs are being seen as a widespread role. It is not only legal now. If you see last 5 years, it's a spread across various areas. So lawyers, in-house lawyers, GCs are not doing only the hardcore legal work. They are into policies, they are into data, they are into cybersecurity, they are into compliance, they are into ethics, they are into whistleblowers. So if you see the whole spread of the role of a general counsel within an organization,
it is expanded.
It's much expanded role that we are talking about.
So Mr. Sundaram is making 2 points. One, that the role has become even more important, and hence in the numbers represented directly to the board or the CEO. Second, the role has become more comprehensive, and which we always say a business, solution provider. If I may simplify it, we'll go around the house and we'll get Payal to be able to, Ms. Khanna, your opening comments.
Yeah, thank you. And thank you so much, first of all, BW Legal World, for giving me the opportunity. I think considering that, I have worked across a couple of diverse industries, I worked across in FMCG and then automotive and now with logistics. I personally feel that our role of a general counsel has become more like a business enabler. I think that's something which we all always debate about. But personally also, I feel it's now more that they look about general counsels as a more proactive approach. So it should not be the case that when the business is into any trouble or when the business is having any issues, only then they come to us. So we work hand in hand with the business teams, not just when they are sort of having any project, but just, sitting in the board. So that's, I think, one of the very important part that why we lawyers.
Yeah, in fact, I have friends who work for MNCs abroad, my business school. They say if our legal head vetoes a merger, and I'm talking of a very large organization, for whatever reasons that it may hit a antitrust issue or there may be monopoly issues, then we don't put time and effort into it mostly.
Yes.
Or we find some ways to either make the merger smaller or whatever, find ways around it. So really the role of the GC in terms of strategic decision making has been very big in the US. And I think now in India in the last decade or so, the same is happening.
Yeah, it's all also because of all the globalization, multinational companies coming in, and they really encourage and they really value our, involvement. But however, I think a larger role, for us as general counsels is also being a trusted business partner. Many times when we sit into board meetings, many times we sit into business meetings, we should be looked at somebody whom they can look up to for any advice, even though they may not be always on the right track. So I think for us, I think two key takeaways, I think all these years, which I always try to emphasize and try to work upon, is being a trusted business partner. And of course, you're a lawyer on the board, trying to support them, but how they can just reach out to you for anything, if they have any issues or they don't have any issues or seeking guidance. So I think is a very important role for us as general counsels these days. And I think that's really helping us in bringing that visibility, helping us in navigating the challenges across.
Thank you so much, Pranav. Again, you work across industries, now work in the new age firms. So how has the role of the GC changed? And where is it headed? What's still right? What's still not right?
Very, very, very contemporary question. I think I was expecting someone to ask basically only this question, because I thought I will only have an answer for this question, and you just read my mind. It really depends. As a GC who started from a law firm, things will be very different. The challenges will be very different. A GC who starts in a startup, things will be very, very different from how he's seen in a law firm or an independent practice. And a GC who's in a private firm versus a listed company, I think there are 4 GCs that you will find, and some of them will have very, very different challenges in the sector they operate, not only because of the businesses that they are into, but also because of the way their own business internally is structured, or the CEO is trying to get a revenue, trying to get stability, trying to get profits, trying to get a benchmark with other fellow competitors. So in the modern day businesses, for a general counsel, I think the first thing that you should probably as students should be looking into is to understand business. Law is, I wouldn't say it's very, very difficult. You will, over the years, will probably understand. You have all the law firms to support you. The experience on the other side will help you. But if you don't understand your own businesses, the law firm will also not trust you that much. So understanding your own business, the nitty-gritties, the details of it, everything from how the employment happens, from how the manpower is coming into an exit, all of it you need to know. Some products, some businesses can be very, very technical. Cloud-based cryptocurrencies, blockchain, and those will take especially a longer time, and you need to understand where the law will fit in, or if there is any law, or as Dr. Batra said, do we really, or Dr. Bhasin said, do we really need a regulator to operate in those, or are we okay to be self-operated? So it really depends upon if the consumer is at a risk or is a business at risk. If the consumer is at risk, then the government will step in and probably make laws to make it far better and achievable for consumers to get a remedy. It's a different issue that they may not be able to in the timeline, which is an issue with any developing country. But as businesses, they will have all the means to be looking at getting resolutions and remedy in time, or whether they have the money to prolong a dispute. Then there are 2 more other aspects of how a GC will have their own understanding. First is the external geography. If you're operating in multi-geographies, you need to understand much more than what an Indian law is, right? And the law operates very, very differently for US versus European countries versus anywhere outside the geography you operate in. And then your own legal team will also operate from many other countries, which is also challenging to work with because of the timelines, because of the service quality, because of the years of experience, because of team management. So if you are able to put it all across for your own self as a GC and probably able to manage your own team, I think the business will trust you far better, because they see you as a department that you can probably are better at, and then they trust you to handle your business very well. I think that's where I have really thought through. But yes, if you are unable to manage your own team, if you're unable to manage the department, it's going to be very difficult that the business really will trust you with their own business, which is revenue bringing, which is to make profits, which is to give specialist legal advice. So yeah.
Okay. Let me go to Mr. Chaube. Mr. Chaube, your opening comments on how you've seen this role evolve.
So thank you, Dr. Batra, for this opportunity, and BW and our guru, Mr. Vasim, for his kind and opening. Now taking on from where Amar, Payal, and Pranav have shared their views, I think I will look at from a slightly different perspective because I am somebody who started in the late 90s. And the biggest event which I have seen is liberalization of 1991. And that is where I think it changed the course of India as a country because we were a closed economy. And even, I remember my father wanted to buy a Bajaj Super scooter in the late 70s. And he had to buy this to black. In the sense, somebody book, you have to give it, then you can get that scooter. So those were days when even if Bajaj Auto was given a license to produce 10,000 scooter, it cannot produce 10,001. So that was the kind of pre-91 where licensing was very common. And then the economy was open and then initially partially and then fully. And that brought a lot of investment. So because earlier only few companies, maybe companies like Unilever had legal officers whose job was limited to maybe going to a law firm and otherwise reply to a case or attend to court. That was the role of the US legal. Now, what happened is after 1991, a lot of private investment came and people took risk, and we have seen how some of the risk which has been taken or the kind of setbacks which we saw 10 years ago, whether it was the coal scam or the 2G scam. What I'm saying is that businesses did not take the proper legal advice which ought to have been taken. I'm not saying if you had taken these things would have not happened, but at least the point which I'm trying to drive is business dynamics today has changed a lot. And as GC, I think there are three elements, which is I call it as GRC, and so does so many people, and which is governance, risk, and control. And I recall the words of Mr. D.S. Sundaram. I was earlier ACC, Chief Legal Officer for ACC in Ambuja, and as a GC, so he was the chair of audit committee and he was also the board of Infosys. And he used to say that for me, three people are very important in the company apart from the CEO. One is the CFO because he gives me an assurance that the internal financial controls are in place, apart from the auditor. And then is the internal auditor because he does an internal audit of the processes which has been set and gives me a confirmation where we stand. And the third person is the general counsel because whatever businesses does has a legal impact. And I can talk to the GC and the GC can give me a neutral view, absolutely unbiased view. And so, especially in terms of compliance, in terms of contingent liability. So governance, everybody understands, I think, setting up the right processes, training and everything. Risk is one of the key areas. So whether it is, so just before entering the room, there was something urgent in my company which has to be discussed today. So I attended a call at 11. And why I was pulled into this call, my CFO was there, I was there, and two business guys. Is that we want to do this deal. Rajiv, what is the view? I had given views yesterday night, but it was on a call. And I had to flag certain issues which the business could not think. So what the GC brings on the table is completely unbiased view, which maybe, at that point of time does not strike to the business guys. Maybe, it's like in an exam, I have to, write 120 question in 2 hours, CLAD exam. I know all the answers, but I am not able to complete in time. So it's not that I tell something which they are not aware, but they are not able to think through. So I think one of the key role of the GC is to bring that neutral perspective, that what is the risk?
The devil's advocate.
Yeah. And I may flag the risk. That doesn't mean that the business is not going to do, but understanding that where I stand, and if I'm taking the risk, what is the,
Trade-off.
Opportunity cost or trade-off. I think that is very, very important. And the third is compliance. I think compliance is very important because especially if you are for a listed company today, the way regulations are changing, it is becoming tougher and tougher today under the SEBI LODR, if there is a fine or penalty of even a 1 rupee or a 50,000, you have to report to the stock exchange. And that becomes maybe a headline or will be carried in the newspaper. And then you have to respond to the investors and everybody. So I think inculcate that culture of compliance within the organization is one of the key legal. And I think I will stop here and we will take it further as we discuss.
Thank you, Mr. Chaube. Ms. Nautiyal, I know you're last on this panel for the opening comments, but your opening comments on how the role of GC is evolving, where is it headed?
Well, let me start with how it's an absolute pleasure and delight to be part of this event and share the panel with the industry stalwarts. Agreeing to what the other co-panelists have said, I would say that GCs are the heart of the organization. They have to balance it out between what business needs, balance it out between what the law says, balance it out between what your credit wants, mitigate the risk, manage the risk, preempt the risk. You have to be preemptive. You have to be farsighted. India is in a very transformative stage. The laws that were enacted for India, are of 1800s and early 1900s. That time, the Indian economy was in a socially developing stage. So you would see the flavor of those laws, are in the nature of something that a socially developing economy needs. But today, we are proud to call ourselves a developed economy. The kind of financial progress India is seeing and is going to see in the next few years when the geographies of, other nations are going down, India is witnessing a decent, stable growth. That is why we are having legislations like Companies Act 2013 or the IBC. We are mirroring the West, but we are enforcing it better, I would say. So GCs have to be preemptive. They have to manage the risk. They should know and be prepared of what the law has. Like, DPDP Act is such an overhauling statute and we all are gearing up for it, waiting for the rules to come out. But I'm dead sure that all the GCs have a plan in place already, which might change when the rules come up. But we have to be prepared. And adding to what Mr. Amar had to say that, about the reporting pattern, I'm very confident that in the next decade, GCs are going to be the CEOs of most organizations. Because every organization wants to be on the right side of the law. Every organization needs somebody who holds the moral high ground and can find ways of doing business. And I'm one aspiring GC. I'm not a GC of HDFC Bank. I am part of the legal team and I report into a GC. And I'm that one aspiring GC who is going to be maybe someday the CEO of an organization and not just a legal counsel. Thank you so much.
In fact, I did raise this question last year. How many GCs go on to become CEOs? We'll start with you, Ms. Nautiyal. What do you think, because there are some young people that throw them up, what do you think are the qualities needed? So if you have 10 people, I'm sure you're unique, and if you have 10 people aspiring for the role of a GC in a large organization like yours, what will be the qualities that will make one person a GC? Of course, it's a lot of luck. It's God's,
yes,
it's the willingness to take larger roles, take projects that give you a segue into a bigger role. All that is there, but give us the, when you look at your colleagues across the table, you look at your boss, what are the qualities that the GCs should have or have?
I feel that, GCs have to be very decisive. They have to be decisive. They have to take a decision. They have to hear out the problem. They have to solve the problem. So, to the fellow law students, when I was studying law and then when I started working, it was just so different. I'm like, what do I do with what the sections that I have learned and, what do I do with them? But when you apply those sections, that is the art. So GCs, when we have discussions, we cite the problem. But that is not what your role. You have to cite the law that because of this you can't do. You have to find out how. Because at the end of the day, if business is there, then a GC is there. So you have to be a problem solver. The better the problem solver you are, I think your road is going to you will get opportunities. But yes, identify the problem. You can't ignore that hum kar lenge. We will do it and you are passionate and you are positive. All that is needed. Half the battle is won once you identify the problem. The other half is won when you are able to solve it and find ways to solve it. So you have to be a problem solver. That is what my, key takeaway is.
Mr. Chaube, you're a GC, right? You interact with other fellow GCs. How do you think GCs are doing in terms of recouping themselves, evolving, or what should they be doing? What do you do to make sure that you have in your area a nuanced understanding of what is happening and also have knowledge of all other areas that impact the business, which is what the CEO should know, which is what the CFO should know. So what are you doing to be able to, so to say, add value to yourself?
Yeah, very good question. And I think I personally feel, and I'll share my experience, and it has not been kind of planned, but it has happened, is that you should need a very good understanding of the business. So, like currently, I am in a group which is one of the major businesses, cement. And fortunately, for the first time, even I was in cement earlier also. So today, I understand cement as a business as much as a business guy will understand, at least very close to that. That what are the dynamics, how pricing is done, what are the raw materials, why it is important to tie up for the raw materials, how do you build your resource and reserve, because you need limestone to build to manufacture cement. So what is the raw material security, where auction is happening, what is the premium, because unless you understand these issues as a GC, you will not be able to link and contribute or understand even the risk. So I think understanding of the business, and Mr. Batra, I can tell you, nobody will come and teach you. So you have to make your own. Like I read a lot of articles on the business, what is happening, who is acquiring which company, there is a consolidation happening, why it is happening, what is the demand, infra is growing, so will cement will grow. I think this entire gamut of business activities, you need to have understanding. That is, I think, key, because unless you have those, and to Ms. Nautial's point, that any leader, why GC, any person has to be very decisive. I think decision making is one thing, because I have seen people not able to take decision when they are given with a situation, because there is always a trade-off, as you told. But I always remember Ratan Tataji, because he said that I always don't take the right decisions. But once I take a decision, I ensure that it is right. There's a lot of power in what he says. So as a leader, you will be given with a situation. It can be, maybe filing a contempt against a government. You think, yaar, jal mein reh ke magar se main bair nahi le sakta. But sometimes you have to bite that bullet because if the circumstances call for. So, and convincing the business that, look, we have an order, it is not getting enforced. Let's file it, At the most, if there is a pressure, I will withdraw it. But thinking that it is against the government, I will not file is no decision. I think decision making is very, very key. But only if you understand the business, that's very, very, important in my view, to become a CEO or any business leader.
Absolutely. Pranav, because this session is titled about the challenges that GCs face. Give us some anecdotal, what are the challenges you face sometimes in your role? And what are the business challenges you face?
I think coming to Dr. Batra, the thing that Mr. Chaube didn't tell anyone was cement is also very technical. You need to understand how it's manufactured, but more than that, you need to understand where will we keep it, because you can't store it forever and it will perish, and it perishes very easily. So it has a 90-day shelf life. After this is all concrete, you will probably see in metro station making a post where the guard is probably standing so that the bullet doesn't hit him. So it's a very technical business. And following from whatever the panel was continuing, where I will say one of the things that I had in mind when the points were being discussed is you had decision making, you had understanding, but consistently applying that understanding to make a decision is very important for the GC to be the GC that everyone respects, not only in the company but also in the panel, also in the industry, because different views every time will only diminish your charm, your personality, or your ability to make a business understand that this is what they need. Of course, with time, you'll probably have much more facts and issues which will have a different decision making process, but consistently applying the same to more like a Supreme Court that they do is one of the things that maybe we should look forward. One of the anecdotes, I think, what Dr. Batra is asking me is as a SaaS-based startup, we started about 12 years back. We got listed about 2 years back on NASDAQ, and we had a very successful growth. But we were hit with COVID when we were getting listed. And we did get listed even during while we were all working from home. And while there are challenges that everybody is facing around the world, there were a few key points that I thought maybe there's worth discussing. Is the ability to work in a team. If it doesn't happen, you cannot get anywhere. And I just don't say ability to work in a team just as a legal team or team with finance or with the CFO. Everyone, even business, even if you don't respect them too much about how what they bring to the table and you bring much more as a GC, you still need to work with them. So you can't be angry, you can't be agitated, you can't be frustrated. Maybe with time they will also learn. Maybe they're not as experienced as you are on the table, but that ability to teach them also is very important. And that's what startups learn from professionals, because not all startups are founded by professionals alike. Right? You have varied of them. The other thing I think the anecdote that I would probably want to put across is when we expand in geographies where we do not have a direct setup, and the business feels that the revenue is going to come in about 2-3 years. So let's set up a subsidiary in Dubai. Let's put it out in somewhere in New Zealand or wherever in Latvia. The question then really is, it's not setting up, it's how easy can you exit? And Dr. Bhasin said the setup window for India is not easy. It's not easy for any country, by the way. It's not as challenging as India also. But exiting is also very difficult in India versus exiting outside in other countries. So when you, as a GC, you probably want to understand, what if things go wrong? What if I don't make revenue in the geography? What if my losses are gonna be more than what I benchmarked in my annual? That's it. And the employment factor, of course, you can't get rid of employees just in a day or two. Somewhere it's easy, 2 months notice. India 2 weeks notice to 2 months notice to 6 months of pay. It really depends. So as a GC, you need to understand which countries are most easy to work with and which countries are most difficult to work with. You'll probably have all the theory from the law firms, but you need to make that decision on the table yourself. The law firms will not help you.
Thank you, Pranav. Ms. Khanna, coming to you, you've heard various viewpoints. Now, let's look 3 years ahead. What do you think is likely to happen to a GC role? The role has evolved. The core is the same, but more layers have got added on. So what do you see will happen in the next 3 years, 5 years to a GC role? 1 year salaries will go up a lot, but beyond that, let.
I think that's the final motto that keeps us motivated, the salaries part. Okay, so I think the General Counsel, the word General Counsel is very self-explanatory. Somebody like a counsel is, of course, somebody whom you come to for advice, for guidance. But general means who knows everything, or who is able to guide you about any problem or any supports that you need. So I think earlier, if I go back when I started off 16, 17 years back, I'm sure I have more experienced people here. It was not about dispute resolution. It was all about, how do you fight cases? I'm a second generation lawyer myself. So I saw my parents all about, advising clients and fighting court cases. I think now I see that 3 years down the line, of course, we have come a long way. We have got a seat on the table. We have advisors and all that. But I see it 3 years down the line as a very critical function in the company, a valued function. We are not merely a support function. I always try to make it a point in my organization that we are not only a support function. But I also feel it also comes with you. I think how you are able to navigate through. So I think personally, stakeholder management, how you are cutting across all your colleagues, how you are ensuring the CEO is informed. That's what my co-panelist just said. But I think it's all about that you being a very important part of the organization. And I hope someday also look at CEO roles. I personally have one of my managers who just became a CEO in my past organization. She was always a lawyer. She took a HR role and now she's heading a managing director position in a global company. So I think we do have some examples already about it, but I think it's also on us how we try to make extra efforts to be with the business, make them trust. I said that point before, that they really see our value addition in the organization. So I think a mindset change from both ends, from our ends and from the ends of the business. I think that's something I see it already happening, and I see it to be continued, and to so that we always hold an important position in the organization.
Okay, Mr. Sunil, you started on a right note where you talked about the role being expanded and the importance being there in terms of reporting. What were the findings in the survey? I haven't read the survey. I'm going to go and find. And I'm thinking we at BW Legal will should do an India GC survey, which
Absolutely.
that's. But what was in the survey which was disturbing? We all talk about rosy good things on panels.
So definitely, I'll not talk about what was disturbing, but an important component, and salary hike is a natural phenomena. It will
Sure.
it will not happen because you want it to happen. It will happen because you have proved yourself. One of the important component of that survey was when this question was asked to 900 GCs, the CLOs, that what are the 3-4 areas that you see which is going to be the main critical area in next 3 to 4 years. And they said 3 things. They said cybersecurity.
Of course.
They said regulatory compliances. And third, they said data privacy. So these were the 3 areas where there will be a lot of focus. Now, just in terms of the regulatory compliances, 67,000 crores charge sheet has been filed, one of the largest manufacturer of the handset today, ED. We all read, right? So every day when we get up, and today I was seeing the morning TV news, the entire criminal law system is getting changed. Police remand, which was so far 15 days, is going to be extended to 60 days plus 30 more days. So 90 days. That is the kind of change that we are witnessing in India. The whole criminal justice system is getting revamped. Whether it will have positive impact, definitely it will have. It will also have its consequences. And that's where we need to be aligned and one up. We talked about an global judgment, Anurag. This judgment, 5-judge bench decision came, and we were all worried within the organization that how will it impact? And we started working that even the appointment letter, which was on the letterhead of an organization which has an arbitration clause, the purchase orders, which has an arbitration clause, those letters on the consultancy and the engagement letter that we signed with many of the consultants, they have an arbitration clause. Based on that annual global judgment, we decided that should we stamp it? And suddenly we see this now 7-judge bench decision, which gives us that protection, and it says that arbitration clause will still be justified because that's a separate agreement altogether. So therefore, staying one step ahead of how the changes are happening, evaluating how the changes are going to impact the business. These are the key areas, Rag. And definitely for Indian GCs, we should do that exercise. That will be a good exercise of how we feel about some of the finer aspects.
Absolutely. It's time to close the panel. So let me get closing remarks from everyone. And I just want to say that, I went to an engineering college, I went to a business school, but after working for 5 years, I started one media company and acquired another media company. So clearly, you can learn things. It's about how much effort you put into anything. Life is about focus. There's nothing that is not achievable. Anything that you focus in and you are at it and you get the mentoring from the right people, you have an inquisitive and a listening and a learning mindset, everything can happen. It depends on how hungry you are, so to say. And rest, a lot of it is luck, though I believe the harder you work, the luckier you get. But I'm maybe a little old fashioned. And also I feel in the last 10 years, my angel investor was a lawyer. When I started Exchange Committee, you may know him, Harvansh, right? Harvansh is a friend of mine, and I'd gone to a large industrialist who was this 23 years back. And Harvansh said, I called Harvansh saying, he wants an SHA. What is an SHA? I didn't know, and I mean, I now know what is an SHA. I've signed money in many companies. But and Harvansh said, oh, you need money, take it. And my closest Harvansh, the only lawyer I knew was DT. He's my friend, Titus, and I met you through SEMA, right? I first met SEMA at TT because he was my buddy, it was not working. He even offered me a legal role. At 26, I said, मैं क्या करूँगा DT? मुझे तो law आता नहीं है. So I can only say seeing lawyers in the last 23 years, because my journey started with a lawyer writing me a 70 lakh rupee check 23 years back to start my first company. So I have seen, I've had some funny incidents with lawyers. One day, I used to have in 97, I used to have a Maruti 800, chauffeur driven though, red colored. I did driving, now I don't know. And at the GK Savitri, a lady bumped into my car. She was in an esteem. And according to my driver, उनके ड्राइवर की गलती थी, मैं अपना फोन पे लगा तो मुझे पता आज भी नहीं पता. But she came out and she was so aggressive. She said, you don't know I work for a law firm. So I knew a lot of law firm founders even there. So I said, which law firm? She said, Kocher and Company. So I only knew two lawyers, Harvansh and BT. So I called both of them. I said, who's this Kocher? Right? You can imagine this Kocher. And I got to hear some amusing things. I will not say that on stage, but and then I had some other, and I remember I was speaking in Japan. I met a partner of Kocher and Company and invited for a meeting with Mr. Kocher. I had heard so much about him. So I said, okay, Mr. Kocher came 2 hours late, and then for the next 1 hour was telling me how much he's spending on his daughter's birthday. For the next 1 hour, I heard that. But so I have not many. But the point I'm trying to make is the role of GC has become very much in demand. I get young people coming to me who work in law firms because of this 4 years of BW Legal World asking my advice. They all want to become GCs. So law firm वाले सब GC बन जाएंगे तो law firm कैसे चलेंगे? ये क्वेश्चन का आंसर बताओ मुझे.
मैं आपको बताता हूँ एक बड़ा इंटरेस्टिंग डिस्कशन वन ऑफ द forums and we were doing with the law firms, and there were a lot of attritions happening within the law firms, and one of the managing partner of a prominent law firm was talking about it, and I said that, look, one of the areas that you are not looking at it is your biggest competition today is with in-house counsels. Because now the gentry and the quality of in-house counsels that you see in the corporate houses is very different from what it was 10, 15 years back. Today, we know and we are updated with the law as much as a lawyer in a law firm is.
They have super specialization where we can't afford that.
So, and Rajiv said, and everybody's talked about that trust and integration with the business, and that is where we are one step above them. Of course, they will have more experience in terms of diversification, dealing with more organizations. But when it comes to us, we know the businesses and we are equally competent and up to date with the latest laws and the judgments and the laws. And so therefore, the biggest competition is with the in-house counsels, right? And you said that's one thing about, because there are a lot of I can see there are a lot of young law students that is here, Rag, and we are also.
I can see some of the that started coming in.
Yeah. So, 2000, there were just 500 law colleges in India. And 22 years from now, 2022, I was just reading somewhere, there are 1700 law colleges now, right? So just make an average of 300 to 400 law students every law college. How many law graduates we are producing in India? And therefore the competition is on quality and the kind of competitiveness that is generating, right?
Closing comments.
I'll just add on. I think I always sort of joke around with my law firm friends that, obviously, law firms have a very important role for us because I come from a law firm background. I was trained in a law firm which got me a job in-house, right? So, with due respect, I think they have a very important because the kind of drafting, the kind of yeah. You see the positive side. Now, general counsel's roles have become so lucrative, and see the amount of opportunities that now the law school students have, which were now only earlier limited to mostly courts. So I think that's the positive side. And if people want to aspire to be a general counsel, see the amount of law graduates you are attracting into this profession, which was not the case many years down the line. So I see that from a more positive side.
डॉक्टर बत्रा, आपने एक कहावत सुनी होगी, दूर के ढोल सुहावने। वही है कि लॉ फर्म को लगता है कि जीसी की लाइफ बड़ी अच्छी है, जीसी को सीईओ बनना है, और सीईओ भी सोच रहा है कि मैं कहाँ जाऊं कि मतलब मेरे को कुछ ना भी करना पड़े और कंसिस्टेंटली पैसा भी आता रहे। तो ये दूर के ढोल सुहावने, जब तक आप काम करोगे आपको अच्छा लगता रहेगा, आप करते रहो, नहीं तो संन्यास ले लो, क्योंकि हर रोल में अपने चैलेंजेस है और वो चैलेंजेस आते ही रहेंगे, चाहे आप किसी भी पोजीशन पे हो, चाहे आपका बैकग्राउंड लॉ है, फाइनेंस है, इंजीनियरिंग है, marketing है, ये चैलेंज।
Yeah, very important points. Both roles are important and they have their pros and cons. That's what Mr. Pranamera is saying. Because you work for Freshworks. Now, again, the age of GCs is getting younger. I meet GCs who are about 40, 41, 42, 43. So, and that's happening in every profession. So the CHROs are getting younger, the CEOs are getting younger. So there is overall people are achieving a lot more. Younger people are getting larger responsibilities a little earlier, right? Do you see the age of GCs becoming even younger than 40?
कभी कभी मैं भी हैरान होता हूँ कि मुझसे भी यंग लोग जीसी बन गए हैं और उनके पास एक्सपीरियंस भी नहीं है और वो हमसे ही पूछते हैं कि ये कैसे सॉल्व करेंगे, जो बहुत ही बेसिक क्वेश्चंस हैं। तो जीसी का टाइटल होना से कुछ नहीं होता है, यू शुड ब्रिंग एक्सपीरियंस टू द टेबल।
Thank you.
As a global company, I report to a chief legal officer who is double my experience, and she looks at much more than what I have experience on. Of course, it takes time, but ऐसा नहीं है कि आप कल लॉ स्कूल से निकले और परसों आपको जीसी की नौकरी मिल गई और आप ये पैनल पे आ गए। वो बत्रा जी का भी एक फिल्टर है, वहां बैठी हैं वो उनको पता रहता है कौन किसके पास कितना एक्सपीरियंस है। तो it takes time to reach at a certain stage in life.
I think from my side, I think we are living in a VUCA world, which is volatile, uncertain, complex, and ambiguous. And in such times, I think as a GC, I think the key challenge is to deliver.
Absolutely.
Delivery is the key.
One of the things they said is ultimately you have to take a decision, you have to provide a solution. You may give a legal view, but it has to dovetail a business view. Final point from you, Ms. Nati.
Just to answer your question, Mr. Batra, that why lawyers, law firms are aspiring to be GCs.
Law firm professionals.
Law firm professionals, sorry. So because when they interact with us today, the only reason we outsource work today is not because of lack of legal talent. It is only because of limited people. Because we in-house counsels do not have big teams and resources like law firms have. And when we interact with them, they realize that the legal acumen and astute which we have is at par, and at times better because we understand our business better. And the opportunities that we have, the diversification, like, in my 14 years of experience working in 3 organizations, I have done a little bit of retail banking. I have handled cards. I have done digital banking. I'm handling international branches. I have done investment banking. Had I been in a law firm, at least for 5 to 6 years, I would have to develop my expertise in one area. So after 14 years, I would have been probably a project finance lawyer at best, to be very honest. So that is why, and the interactions are so close and they see how we are running the transactions. So that mutual respect is there. And that is why probably, what you are saying is there. And what, Pranav, just to slightly, disagree with you on that point, that, what experience brings to the table can never be taken away. Like, Mr. Bhasin spoke about his years of experience and I was totally spellbound with what he was saying and agreeing. But younger people, the edge they have over the older generation is the adaptability, and we are transforming. So the change, the acceptance to change, the adapt to it and deliver is faster with somehow it is. I don't count myself as one of those, though I'm trying to be, but that mindset of the Gen Zs and millennials. So that is why they have aspirations to be a GC at a younger age. Like, I still call myself as an aspiring GC because I know I have years to go. But that is the difference. And I will not be surprised that, maybe a few years later, I meet a GC who's younger to me, but brings a lot to the table because at a very young age, probably he or she has experienced a lot. So, times are changing.
I must tell you an anecdote from yesterday.
Sure.
So my first company is Exchange for Media. I don't run it. But of course, it's my company and it's the whole ecosystem of advertising, marketing, media. They're my friends. I grew up with them, they grew. So yesterday, a journalist friend of mine called. He's about 43. And then he said, I want to come and meet you. I said, okay, come. I've known him for many years. Came and met me and he said, I work for an ex-organization. I'm not enjoying because I have a new boss. Can you recommend me? Everyone. So I said, okay, tell me. I'll call anyone. So he said this. So I called the boss. And he's luckily a very close friend of mine. And he's himself about 46 or 45. I mean, be off by a year. So he said to me, he has a mandate that in the digital business, they can't recruit people above 40.
That's true.
Right? So he said, in fact, we're trying to recruit people between 30 to 35. I have to call that senior journalist and tell him, boss, this is the reason you won't get a job there. But I believe, yes, younger people think different, but I think the skills that are needed are both of experience and of dynamism. And I think, I can say a lot of older people than 40 work as hard or are as driven as younger professionals. The thinking may be a little different, but they're very driven in terms of learning about new things, what new areas. He talked about the 3 areas that are top. So I don't think it's an either or, but yes, the age of achievement is getting younger. I see it across functions. So on this note, I'll wrap up this GC panel. We have a millennial changemakers conclave on 26th at the IIC. First year, actually the oldest speaker was 22, but Nandini added one more 25-year-old. I was growling at her yesterday for adding a 25-year-old, but that's okay. She done a fab job. Talis is here from, he runs our CHRO, CFO, and is now relaunching our CIO and CDO community. We have a CHRO event on Wednesday at the Imperial, right? 20th is a Wednesday now, 18, 19, 20th. So I think we have a point of view in every community. So that the point I'm trying to make is that the age of achievement in every community is shrunk by 2-3 years. Maybe there is more talent. Also, in-house people are getting more opportunities. Also, what matters is what is the size of your ship. In HDFC is a very large company, right? It was large even before the merger. With the merger, it is super large. So it's, again, if you're a GC of HDFC versus your GC of a smaller startup. Again, the startup may be in an area that will become so big that, that may be. So you shouldn't compare. Everything is unique. Every experience is unique. But the role of GCs is here to stay. The role of GCs is clearly governance, compliance, risk management, being a business enabler, as Ms. Karna said. And as Mr. Sundaram said, the role is getting expanded. The role is more important because it reports into the board and CEOs. So clearly, we as BW Legal World, we aspire to be the homepage of GCs. Out of our multiple issues, there are GC on the cover. So, we want to be a homepage of GCs and do content that brings GCs to our editorial platform. With this, I'll lock this panel up. Please give our panel a big round of applause. I learned something and it made me think, a bigger round of applause. Clapping is fun for art myself. I know it's a Sunday, it's still a full house, and I think in the evening you'll meet a lot more people. So if you're staying back, stay back. Otherwise, come back in the evening. Some of you have been on the jury. You have younger to decide both the 40 and the 40 and the 30 and the 50. So look forward to celebrating with you in the evening. Thank you.
Could I please request everyone to kindly come forward for a group picture? Thank you very much. Thank you. Some experts and students of the industry joining us here to discuss this further. Ladies and gentlemen, joining us in the book of our list. Please give it up for all the children. As well as safety and General Counsel Corporation. Just welcome everybody with a big round of applause. Thank you very much. Without a Secretary resolution. Secretary International Law, Advocate, Supreme Court of India. Secretary Information and Reconciliation, Sultan Silvan. Let's give it up for session chair. Advocate. Thank you.
Good afternoon, everyone. We all know that mediation has gained significant momentum in resolution of disputes, both in India as well as across the world. In countries like USA, 90% cases are settled before they go to trial. This is particularly so in disputes relating to commercial issues. The people who have been mediator in cases would know that there are miracles happening when disputes get resolved. Disputes which have been pending for 2 decades, 3 decades, are resolved over 4 or 5 sittings in mediation sessions. Disputes get resolved by merely giving an apology, saying sorry. So where does this magic come from? The number of commercial cases are increasing. They are getting complex by the day. We have the Singapore Convention on International Mediated Settlements in commercial contracts. We have recently had the Mediation Act in India, just 2 months back. So what is this magic? Where does this come from? That complex cases, long pending cases are getting resolved in several sittings, which in a court proceeding or may even in arbitration is not possible. So technically our session is over. We are running against time. So I will start with the questions straight away. And my first question goes to Veena Ralli. She has a distinction of having done more than 1,000 mediations. One of the most successful mediators of our country. Veena, we would like to know from you, what is the cause of this magic when people come to mediation?
Neelam, mediation is magical. When we started mediation, we started because of overloaded dockets. And there was a situation where it was realized that maybe we have to go for alternatives to the adjudicatory process. So people were trained, mediation started. I'm one of them who started at the initial stage itself. But over a period of time, we realized the benefits attached to the mediation are magical. And this process does not only look at the outcome, it looks even at the relationship. Be it personal, be it matrimonial, be it commercial, be it organizational. In nowhere in adjudicatory process, the relationship is given any value. Rather, the damage is so much that it's further cemented by one judgment in favor of one, and again it is taken into appeal. And parties look at each other as enemies. But when you come to the magical room of mediation, the techniques the mediator is supposed to use, I'm very carefully using the word supposed to use, they bring the magic in the beginning itself. And a mediator navigating the parties through the length and width of the techniques which are required to be used for the purposes of mediation brings them to a level where they start collaborating for resolution of their disputes. They are the decision makers themselves. In the adjudicatory process, somebody else decides for them. And nobody wants my problem to be decided by someone else, but we have no other option. But there, their role changes. So that is the magical wand in the hands of the mediator. And for this, I will emphasize one thing, that mere 40 hours training is not enough. You need to understand the nuances of techniques, not only of the communication, but negotiation as well. The lawyer may say, so far, what has happened? Lawyers have been trained for mediation. So we see it from the perspective of lawyers only. But I feel that even if under the Commercial Court Act, it has been made mandatory, the voluntariness attached to the mediation has not been taken away. A question might be bothering on the people sitting on this side with me and to you also. Once it is mandatory, so where does the word comes for voluntariness? Voluntariness is attached to the process. And if a trained, well-equipped, well-talented mediator is there, he can navigate the parties through the whole difficult, challenging situations while using his techniques, making it throughout voluntary, but still driving them towards resolution. That's challenging, of course. But by experience, we have learned, and I'm sure anybody can do it. So even if it is mandatory, voluntariness has not been taken away. There can be something called, once it is not mandatory, so why people should go? There, our system is such, we are avoiders. We want to avoid outcome at the earlier stage. देखेंगे अभी थोड़ी देर देख लेते हैं क्या होता है. And there, under the Commercial Court Act, if we see the litigation cost being evaluated at the time of computing the cost, this aspect can also be kept in mind, because the authority under the Commercial Court Act is Delhi State Legal Services Authority so far as Delhi is concerned. And there is a fee given for that. So that will be computed. And then a question further will be there, where there was a reasonable offer coming from one side, but unreasonably refused by the other side. So those aspects are still there. So as a mediator, while discussing the initial benefits of mediation, we must bring this aspect also to the knowledge of the participants, so that they know that there is a benefit. If I agree today, it is an executable award, and definitely the parties are going to be benefited for all times to come. And the most important thing, relationship is not damaged at all, or even if not repaired, at least further damage is taken care of. I think I'm.
Thank you, Veena. So it is the mediator's magic which transforms and empowers the parties to be able to collaborate. And this is from a stage where most of the time the parties, the relationship, there is a complete breakdown. There's no communication. So it is the magic wand of the mediator, how with his skill and techniques, how he does that. Moving forward, commercial contracts. In commercial contracts also, relationship is equally important. My next question is to you, Abhay, since you are at the helm of commercial cases. Given the increase in complex commercial disputes and your vast experience in the field, do you think mediation offers a viable option for a speedier and less expensive resolution of disputes?
Thank you for the question. And thank you all of you for being here. I think there's a very interesting trend that's taking place with mediation today, which is that because of Section 12A and the requirement for us to actually have clients engage in it, we're seeing in positive results. We're seeing disputes which appear to be complex because of the nature of the transaction, but come down at times just to money. So I think considering that things are getting better with the Commercial Courts Act, litigations are being shortened, but not to the extent where large institutions are comfortable constantly being in court. And mediation does allow you to circumvent that entire process by engaging with a very competent and talented mediators of the Delhi, especially in Delhi, who are able to, at least in commercial transactions, because there's no, unlike, let's say, a family dispute, there's no ego involved. It usually just involves, rupee paisa aana. And once you are able to structure payment plans, once you're able to structure terms, you find that that GCs, companies in general, clients that we have, are more amenable to using the mediation route because overall it's more cost effective for them. I can give a simple example of how mediation, even when it's not under the auspices of the act, we have an arbitration. It's highly contentious, and when the arbitration proceeding started, got a call from the other side saying, would your clients be interested in having a conversation? And until this point in time, we hadn't had one. And so because of now the experience that we're getting with mediation proceedings, I advise my clients to do it. And I believe we're at the cusp of settling a matter which would have otherwise taken up a year and a half, 2 years, would have taken up significant resources on both sides, and with no guarantee of either side being successful, because it was one of those cases where it depended completely on interpretation of a particular clause. So overall, I now advise clients to at least explore the possibility of engaging in mediation, because I feel that even as a lawyer, if you're dealing with clients who are constantly, you work with closely and for long periods of time, the trust then is there that when I say, let's go to court, then they understand that there is no real other possibility, and that lawyers are not in it just to be in court for the sake of being in court, and that they have the client's best interests, both financial as well as reputationally, at heart.
Thank you. Heartening to know that more and more mediation is being used to resolve commercial disputes. Getting to the underlying interest is important. And in commercial disputes, it's mostly money. Yeah. Moving on, my next question is to Sarika. I'm given to understand that mediation was not made mandatory under the Mediation Act due to a lack of availability of qualified mediators. Though in the bill, it was made compulsory. As Secretary General of Madhyam, International Council for Conflict Resolution, could you tell us what role can private service providers like Madhyam play to build capacity and bridge this gap?
Thank you, Neelam, for your question. Madhyam has been pioneer in the mediation movement in India. It is engaged in capacity building and propagating mediation at all levels. Madhyam has been training individuals from last many years In the last 1 year, we would have had, I think, more than 3-4 training sessions. And most of our members are trained by international organizations like Strauss Institute for Dispute Resolution and also SIMI. So we have internally built the capacity already. With the new act coming in force and with the mediation institutions getting now the mediation cases, and it will develop further in the due course, Madhyam is already ready to provide services to the public, which is the need of the hour. Section 12A, as we already discussed, is already, there is a mandate of mediation there. And Madhyam has, domain knowledge and expertise also, because we have a lot of senior lawyers as members of Madhyam. So domain knowledge today, like Section 12 mandate, is very important for mediation. Madhyam provides or is ready to give these kind of special services in the field of mediation.
Thank you. That's good work being done by Madhyam. Coming to you, Saurija, you are a practicing lawyer at the Supreme Court of India. Given your background as a litigating lawyer, are there any other ways to introduce a requirement for mandatory pre-litigation mediation other than under 12A? And how to ensure that it is taken seriously by the parties?
Thank you, ma'am, for having me. So, just briefly to start off, 12A, while a party has to, while initiating any proceeding, they do need to explore the option. Of course, they can avoid that if they have an urgent interim application on board. But once, let's assume they don't for a moment, even though generally always such an application does follow. Even if they don't, when the matter reaches the mediation cell, what next happens is an offer or rather a notice is issued to the other side. Now, the other side can very well say no. If they say no, the matter ends there. It goes forward. So what I've been noticing as well, and especially in my experience, it's been happening more in international commercial arbitration agreements, where there are, of course, foreign parties involved. What's happening is that they have a mandatory mediation conciliation exercise that needs to be carried out before you can actually invoke arbitration. So your arbitration clause is dependent on first having explored that option. So once a party, when we are entering into contracts, the parties are not perhaps at loggerheads at that point in time. So they would be more amenable and open to having such a clause because, of course, as everyone said, it may be a more economically viable and better solution, rather than having a situation where disputes have arisen and as it was rightly said, in mostly it's money terms, but sometimes also in these situations, I've seen ego coming in the way quite often as well. So if you have a clause such as that right at the start, subsequent to that, if disputes do arise, that's the first way of ensuring that actually the exercise is carried out. So essentially there are two hurdles, primary ones in my view. One is to getting them together. Second is, of course, how do we ensure that it's taken seriously? So the first could be sorted out by such a clause being there in an arbitration agreement as well, which says before arbitration invocation, you have to actually explore settlement, you have to explore mediation and conciliation. The second is how do we take it seriously, which briefly ma'am touched upon on the cost aspect of it. There's a principle which has evolved and it's been enforced for quite some time in the common law countries. It's called the Calderbank letters. So essentially it gained prominence through this 1975 judgment, even though it was in a divorce matter. The issue that happened, it arose there is, even though the husband did receive about £10,000 as a divorce settlement, on the issue of costs, the wife said that I had made an offer for about 12,000 before, which had been refused by the husband. So the court while determining the costs payable, and especially in foreign jurisdiction, the costs are quite high. So for the cost payable, the court held that no, the husband has to bear the costs. Because what had happened is that a reasonable offer was made. And what finally you did refuse that offer and you went ahead with litigation. You were not able to gain an amount which is higher than that particular offer. And in fact, the offer made was higher. So you'll have to bear the costs. Now that is the second way. And in fact, in India, especially in international commercial arbitrations, more that I'm seeing, is a situation where actual, more or less, realistic costs are being awarded. Of course, there's a reasonability line to it as well, because one may not have 4 firms involved or 3 firms involved and 4 senior advocates involved, so they're not going to pay you for that much. But depending upon the matter and depending upon the complexity of the matter, somewhat reasonable costs are being awarded, and which is to an extent realistic. So in that situation, and if it does, so let's say, for example, a claimant, a plaintiff in this situation, a claimant, let's say, before going in, we had a discussion. I made an offer, being the respondent. The claimant refused. Going forward, the matter went into arbitration, and what the claimant did end up getting is around or less than the offer that I had made. Even though the claimant had in fact won the matter, the tribunal might, while deciding costs, make costs in my favor in that situation as well. So that is an interesting line. And in fact, in some situations that does happen, but it's mostly in an international commercial arbitration aspect. And also the other thing is very important over here is that even in domestic arbitration, if the tribunals start, and it started as well, but there's a long way to go on that front. If they start actually giving real or close to real costs, then that is always a aspect which will be played in the back of the mind. So broadly speaking, those are the 2 hurdles. And one way is costs. Costs is a way of actually sorting that out.
Thank you. Our mediation law, does not provide for any consequences of a party refusing to participate in mediation. So I think some kind of sanction cost should be there, like some jurisdiction. UK has it. They impose sanctions if the party is not coming forward to at least try, give it a shot at mediation. Veena, I want you to come in here. Since you are at the helm of affairs at the Delhi High Court Mediation and Conciliation Center, Samadhan, many a times we see when the court send the parties to mediation, they come and say, we did not want to do it. So how do you handle those kind of situations?
See, first of all, even in legal profession, we have not taken mediation seriously unless we really experience it. So the parties who are not aware about the mediation process, they feel this is another courtroom for them. Maybe a judge is sitting who will force them to decide or take this option or take that option. So that is why the credibility of the process depends upon the person who is holding the process in his or her hands. There is a specific process attached to the mediation as well. Generally, people feel mediation क्या है? एक को कमरे में बुलाओ, दूसरे को कमरे में बुलाओ, दोनों जहां agree कर जाए वो mediation है. My answer to that is it's not mediation. Mediation has a skill. There are techniques to bring the parties to create options and then select the option. So when the parties come with such a mindset in the mediation room, the mediator has to meet them, greet them, and treat them in such a way that they feel that this is a place where they can look at their interest, not by digging into their positions, which they generally do in court. And one important aspect, which is very, very relevant for all of us to know, is that in courts, we have a dispute which is surfaced, which everybody knows, but nobody knows the conflict between the parties, why this dispute has arisen. So once you disclose them the process and encourage them to participate, even if in the beginning they say no, because the judge told us we have come, but you can transform the parties and bring them to a level, at least they are ready to talk to you as well as to the opposite side. So it all depends upon the person who is holding the process in his hand. And I think magic can be done at this stage itself.
Thank you. So this is where the skill and the training aspect becomes important. My next question is to Preet. Singapore and Hong Kong have created mediation ecosystems, settling and deciding multi-billion international commercial disputes. India is looking at being the hub of ADR in both arbitration and mediation here. Under Section 12A of the Commercial Courts Act, pre-litigation is mandatory. Does Section 12A help in popularizing and maximizing the resolution of commercial disputes through mediation?
Yeah, so I mean, your question has two legs to it. I would try to answer the first one first, which is how other countries like Singapore and Hong Kong and some other jurisdictions also, they have become hubs of ADR. It all started primarily with arbitration and then mediation has picked up. India lags behind on many counts. One of those, of course, we have tried to address when we have tried to have now time-bound ADR processes so that it is a faster process. But to really popularize our country as a venue, what has to be done? And the answer lies in your question when you spoke of ecosystem. We need to have a robust ecosystem of institutes who would administer a mediation or an arbitration. You need to have physical infrastructure. Like in Singapore, they have Maxwell chambers where all of that is, most of the arbitrations can take place. I think in India, we still lack that sort of an physical infrastructure. Of course, offline mode is, I think, a better mode when we talk of things like mediation, like other than an online mode. Because when you meet a person face to face, you are able to connect with them and understand their views better. I mean, we see that every day, even in our meetings, the online mode cannot always take over the meeting, the people. And, often when you talk of commercial disputes, these are between people who were working together up till a point of time and they were like colleagues. We often see, okay, two companies, impersonal people and fighting with each other. It's not like that. You have been dealing with your consultant since ages and then there is a dispute, or some service provider, you were sitting with them working on a project and then there is a dispute. So it is important you have that physical infrastructure where parties can meet and settle disputes, and not to mention the entire ecosystem of mediators and lawyers who are also trained, in-house lawyers who are trained to educate people on what is this about. Incidentally, what I feel can be a big drawback to this entire process is the overall resistance to initiate any new proceeding in between. Because most of the time what actually happens is you presuppose people haven't really discussed their disputes before initiating arbitration, whereas that happens. Often, 6 months, 1 year has already elapsed before a dispute proceeding starts. So then somebody will question that what benefit would a mediator bring to the table, or would these proceedings bring to the table, because we have already tried discussing. So then again, as and when parties see the benefit of this entire system, that is going to be a stepping stone or a starting point where this process becomes more acceptable. And as and when, something becomes popular, the ecosystem develops, and then, you can think of becoming a global hub. And that's how, maybe Section 12A, which mandates this proceeding as a mandatory step, because voluntarily nobody would have gone for it. They would have said, we have already tried talking. But if it is a mandatory process and then they say, yes, this gives us some value, we are able to settle the dispute, save on cost and time, and that is where actually you will see a change coming. But a lot depends on how we develop the overall ecosystem and the infrastructure around this.
Since time is a constraint, I'll come back to you on the connected question. This Mediation Act aims to institutionalize mediation.
Aims to institutionalize mediation. What, according to you, because you mentioned the need for a proper ecosystem to meet the increasing demand for mediation, what, according to you, are the steps required to achieve this objective of the Act?
So, when you say steps required, one step has already been taken. They have said that the Mediation Council of India would be set up to, impanel or monitor the agencies who would be mediators. Second step, of course, is, like I said, developing the entire ecosystem of mediators who are lawyers, not necessarily people coming out of the court system as retired judges, but because they are in that adjudication mode, but maybe people who are from the industry themselves, who know how to tackle disputes in a non-confrontational way, having institutions to train the mediators, and generally to have awareness sessions around this new law, because something which is very new, people don't understand, and then there is resistance. And I think the biggest challenge right now would be to educate people that this is something which has happened and this is how it can work in your favor. And then, have contracts which have unambiguous clauses, because I can see a lot of litigation happening around it that we never had a mediation clause to start with. So why am I required to do this?
We have the arbitration clause. How many disputes revolve
Around that? Yes. So even with the mediation clause, how to draft it? How will it work? So, I see there is so much which has to be done just to make this a seamless process and not again another step where, you people parties are litigating and arguing about. So I think awareness sessions are the first thing which has to be done.
Thank you. I come back to you, Abhay. Considering your field of work and given the mandate under Section 12A, would your firm recommend mediation to all your clients in commercial matters? If yes, why? You did say that you are telling your clients to go for mediation, but why do you think that is a preferred option?
I think to come back to what I was saying earlier, I think it comes down to cost effectiveness of mediation and the fact that when you're dealing with corporate and commercial disputes, you're looking at either compliance with terms, or you're looking at services being rendered, products being provided, or payment being made. A lot of the times when both parties understand that, because as everyone here is aware, mediation also allows you an opportunity to suss out the other side's arguments. Because in order to justify your demands in mediation, you do put across your points. Now, what we're finding is that lawyers are getting better and better at having very different personas when they're mediating for their clients as compared to when they're in court.
They have to wear a different hat.
You have to wear a different hat, because otherwise you're doing injustice to your client, because you're not able to maybe take them to a point where a settlement is possible. But yes, as I'm finding, as the mediation sector matures under the Commercial Courts Act, we're coming to a position where law firms and advocates across the board are find it more conducive to at least attempt mediation and to see where it heads. And I feel that it'll just go from strength to strength.
Great. Thank you. Saurajay, the Mediation Act makes the mediated settlement agreements enforceable as a decree. Do you think this is going to help increase the magic of mediation?
Yeah, so coming back to the Commercial Courts Act as well, even 12A, it's supposed to be drawn up as an award under Section 30 of the Arbitration Act. Now, one has to also look at 96 of the CPC, because then it's a consent decree effectively. So if you're looking at it from that perspective, just because the Mediation Act says it's going to be drawn up as a decree, and your Commercial Courts Act quite clearly says that it's going to be treated as an award, from what has happened on the enforcement front under the Arbitration Act, is that if it's something, and of course, you've got grounds of fraud only to challenge under 96, a consent decree. So what effectively will happen is that an arbitral award will effectively be treated as a decree of the court as well, without you having a right to challenge under 34, until you say there is fraud. So in both situations, yes, the terminology used is a little different, but even in 12A, by virtue of being referred to as an award, it still has the same force as a decree because it's a consent one. And just to wrap up the previous point we were talking about on the reasonability bit, if one has a look at our cost regime in 31A, 3D, it also says one of the factors the tribunal is supposed to look into is whether a reasonable offer was made or not. So that's the other bit. Yeah, thank you.
Thank you. Sarika. Being responsible for resolving a large number of disputes for any organization is a stressful occupation. Actually, Preet can also pitch in here. Should all internal counsels be trained in mediation, skills and techniques to bring the other party to the negotiating table?
That's a very relevant question you have put, Neelam. See, in the previous session, we heard all the general counsels say that today GCs are involved in everything, every aspect of the business. Therefore, I mean, maybe I'm biased. I'm a trained mediator from last 15 years. So I always propagate mediation. And I have seen it helps in the, organizations as well. So, but a lot of sensitization is required. As we evolved, and Veena has told us, mediation is relationship building. Relationship building is important even in the big companies. At certain points, I see there is a dispute with one of the business partners, but one of the business unit within the group would say, sorry, we cannot break the relationship. The other one is wanting to go legal and, snap the ties at any cost. But the other person is standing in front of me and saying, sorry, the business won't be able to run. And that's the point when I have to convince them to try mediation before taking any other action. So I feel a lot of sensitization within the companies is required. Sorry.
Yes. So just to add on to maybe what was said earlier, see, a lot of awareness is required, and also in-house counsels would have a great role to play in this new form of process also, because obviously when you are talking of drafting of your your offers for settlement and what correspondence has to go, it is mostly, at least in larger conglomerates, the in-house team which does that correspondence. The initial dispute correspondence and the notice is done in-house. And when we are looking at, mediation and what is it that is required, I think that is one aspect in which in-house counsels would need training, because most of them wouldn't have drafted, this sort of an offer for settlement and ancillary proceedings. And generally, to act as a mediator, I'm not sure, because there would be a conflict of interest, but definitely that is something which I think in-house counsels, being close to the business and often, negotiating a lot of deals for the business, are more, are actually in a better position to develop a sort of an offer. Because especially if somebody has seen the genesis of the contract and the dispute and can see it more objectively than people on the ground who have suffered, or they feel they have suffered at the hands of the other party, they are better equipped to come up with solutions. So yes, I think in-house counsels, it's not an option. They have to be trained in this system now.
Thank you. Great. Now we've already run out of time. Let me have your quick comments on the topic of the day. Veena, let me have your comments first.
I started with magic. I'll just say one thing, that court annexed mediation started in 2006. Today's Delhi's success rate at the district court level is very high. At Delhi High Court, it is about 50 to 55%. Court annexed mediation centers are generally approachable and approached by lawyers. So lawyers need to be aware about this part, that they can take their clients to this side and get them what they want. I will call it a mediation advocacy for specifically required for mediation purposes. Commercial Courts Act was introduced in 2015. Rules under this act were introduced in 2018. Immediately thereafter, because rules were framed in July, COVID came. And after that, at the initial stage, there was no infrastructure even. And in the absence of infrastructure, it was difficult to implement the provisions of the Act. It took time to establish a system by which now court annexed mediation centers are doing mediations under the Commercial Court Act. And today's success rate at our center, that is Samadhan, is about 30 to 33%. So what I say that our journey of 3 years has got us 1/3. I think we can approach further and we can reach up to 50% very soon once we have mediation advocacy very much available to us.
So I think mediation and conciliation is an extremely important tool which has to be used properly. And I think Abhay rightly touched upon it as well, is that the lawyers have to actually practice it in such a manner where they try to close matters out. So personally, I try to get as many matters settled as one can. And of course, the settlement can happen at different stages of the proceedings. So one has to be, as a lawyer, as your client's representative, you have to look out for your clients and you have to ensure that you actually try in whichever manner possible to close the matter out through settlement. Whatever stage it may be, it may not be in the initial stage at all. It could happen at a subsequent stage as well, because that's the definite art of getting a matter settled, because then that determines your strategy towards it. So yeah, that's very important.
They say mediation never fails. Even if the parties go back in the first round, there are chances of them coming back because they have been transformed to some extent. Yes, Sarika?
Yes, I'm for the title of the topic for the day today, that mediation is a magic wand, and the more, there is a mandate of mediation. I told everybody that Madhyam is ready. We have the capacity to provide services of mediation. And even as an in-house counsel, I would say it will be easier for the in-house counsel if there is a mandate of mediations. We will have more sessions of sensitizing our colleagues within the organization, and they will also be ready to adopt this method.
Yeah, so yes, it has the potential to be a magic bullet, but I think it will have to stand the test of time, that how well is it adapted and what roles the legal community can play, because it does require a bit of rewiring of the lawyer's mind, not to extend the dispute and maybe let it end. Maybe somewhere everybody needs to do a bit of introspection and provide incentives for ending the dispute to the lawyers, because it should, in 6 months, obviously they cannot bill that many billable hours. So maybe higher rates for settlement or something like that. So, but yes, I think it's a good step and it can help in really reducing the disputes.
I will have the last word.
No, I think there's very little to add to what's already been said, but I think you're looking at, as India since 91, as was said in the previous panel, India as a economic market and ergo a legal market is definitely maturing. And I feel that as you have alternate dispute resolution processes abroad, we're moving towards that. And I think both the entire ecosystem, being the stakeholders, being your clients and advocates themselves, are understanding the benefit of it. And I do believe that apart from cost, I think trust is always the most important thing a lawyer has. And if your client trusts that you're able to offer them cost-effective solutions which protect their interests, they are in the long run going to trust you. And that would just, you'd build on that, on those relationships, and it'll just be mutually beneficial to everybody involved.
This trust of lawyers has come a long way. Let me just share a fact which you may not be aware. When in 2005, the first mediation center was set up in T. Sadari. Veena will have more details of that. It was vandalized by the lawyers. They pulled it down. And it was then sitting, then president of the Delhi High Court Bar Association was summoned by the Chief Justice. And he said that we will have this center, we will have it at High Court. And subject to one condition, it will be run by the lawyers. So this was the first step towards gaining the trust of lawyers in mediation. They thought we will be this thing rendered jobless if the mediation picks up. So anyways, now we all concur and hope that this magic bullet is off to a flying start. Thank you, panelists, for your time and expertise and giving us such wide, diverse perspectives. And thank you everyone for your patience. Please give the panelists a big round of applause.
Please request the panel to kindly pop up for a quick picture. The question, a lot of questions lurk around the corner. Well, throughout the day with the panels and with the experienced stalwarts of the industry, we look forward to answer most of these questions. With this, we are now moving on to our next panel discussion. The topic at hand is unraveling India's data application framework, execution and hurdles. Ladies and gentlemen, please I welcome our panelists. Please give it a round of applause. Please welcome Dr. Singh, cyber law expert and founder of Associates. Please welcome Neha Pradhan, partner and Vice Partners. Well, it's not easy to have together, like supremely easy. Please give it up for strong round and scale, Personal Protection Officer, Zomato. And joining us virtually will be Dr. cyber law expert, completing the panel. Let's welcome the session chair, Devesh Verma, Principal Associates, Iraq and Partners.
All right. I hope I'm audible. Right. Good afternoon, everyone. We have a very 30-minute tight session and an esteemed set of panelists. But welcome to the session that's discussing data protection, unraveling it, understanding the execution and the hurdles that we are facing, right? So this is a journey that began with the Puttaswamy judgment many years ago, 2017, and we have all seen different versions of the bill. The Justice Sri Krishna report being tabled in the parliament, being withdrawn from the parliament, the Joint Parliamentary Committee report being tabled in the parliament again, and finally, this year in August, we saw the bill passed. And now we're all waiting for the rules and trying to understand what are the different challenges and what are we anticipating in terms of executing this bill. So I want to welcome each of the panelists here and Mr. Pawan Dugal, who's joining us virtually as well. But I'm sure all of you know the panelists and your program dossiers will have their introductions. So I'm going to go straight into the discussion in the interest of time. Can I ask Akshay to start with, a basic overview of the core principles and the framework that businesses have to keep in mind when they're thinking of executing and complying with this law?
Thank you, Vindesh. Good afternoon, everyone. So essentially, there are these 7 core underlying guidance principles which form the framework of the Digital Data Protection Act. Number 1, lawfulness, fairness, and transparency. So companies must process personal data for a lawful basis or a lawful purpose, and that lawful purpose needs to be met for each different processing activity. Companies need to process data in a fair manner, taking into account the interest of the individuals whose personal data is being processed, and transparency, that companies need to be transparent regarding the personal data that they collect, the purposes for which they process their personal data, as well as the various third parties with whom that data is being shared. So that information needs to be provided to all the individuals. The second guiding principle is purpose limitation. So there's an obligation on companies to ensure that they process personal data only for the purpose for which it was collected in the first place. So you can't collect personal data for purpose A and then at a later point of time use that data for a different purpose altogether. Thirdly, data minimization. So companies have to ensure that the personal data which they are collecting and processing is limited to data which is necessary for them to provide the service. You cannot force individuals to provide data which is excessive and really may not be necessary for the purpose for which you are asking the data for. Fifthly, accuracy. There's an obligation on companies to ensure that whatever data they have in their database is kept accurate, correct, and consistent. Storage limitation. So today companies cannot collect data and save it for perpetuity. You can only store data for a particular period of time. So once the purpose for which you had collected data in the first place, once the purpose has been served, then you will be required to delete the data from your database. And also, in fact, if you've shared the data with any third-party data processor, then it is your obligation to ensure that that third-party data processor also deletes the data from their database. The last two guiding principles are one, integrity and confidentiality. There's an obligation on organizations to ensure that they implement technical and organizational measures, as well as reasonable security safeguards to ensure that personal data is protected and there is no personal data breach. And lastly, accountability. So it is a data fiduciary, and a data fiduciary is the entity which determines the purpose and means of processing of personal data, the entity which determines why personal data needs to be collected and how the personal data needs to be processed, is accountable under the law. So even if there's a violation, for example, by a third-party data processor, ultimately under the law, it's the data fiduciary who will be penalized for the violation. So these are the core principles that form the framework of the DPDP Act.
Right. Thank you so much, Akshay. I think one of the things that we realize when we look at this law is how consent is king, right? And what I want to really understand, I want to bring Dr. Karnika Sethi here. Karnika, can you tell us your views on the consent and notice framework that we have under this version of the Act that was passed? Because we've seen how it has evolved with different versions, and what are your views on what we have as law right now?
Consent is very centric to the DPDP Act, as we all understand. And when we talk about consent, it is not something which is, for example, silence of a particular person will not be a consent. If there is a particular affirmative action which shows that, yes, there is an agreement. For example, a checkbox being ticked by the user, that would be a consent, because it has to be express. It has to be very unambiguous and very clear, and it's not something that one could only imply consent or through conduct. So that's very important for us to understand the importance of consent in this act. So there has to be a very clear, unequivocal yes to the agreement, and in whichever way it would be, but very express, very explicit. Only then there would be a consent which is considered as a deemed like a proper consent in the DPDP Act. And when we say consent now, age of consent, it's like 18 years and above. So a person has to be of that age. Otherwise, the consent would be invalid if it's a minor. In that case, there would be a parent or a lawful guardian who can give a consent if one is below 18 years of age. In case of disabled persons, again, there has to be a lawful representative who can give this consent. Now, definitely when we say notice, there has to be a notice given to take that consent, because the notice has to explain very clearly what are the kinds of information which is being asked from the data principal. What, for example, if it's personal information, your address, your date of birth, your health record, it could be anything. So this DPDP Act doesn't have separate categorization of what is the data being collected. So it doesn't have to be categorized into sensitive or non-sensitive. But yes, we must understand this is going to be only personal data, not non-personal data. So in that regard, the notice needs to say what information is being collected, how it is going to be used, for what purposes it's going to be used, and if there's a processing, then what kind of processing, how long it will be retained for, and the user rights. Explain the user that he has or she has rights, for example, to access that data which is given, to update it in the records, to ask for say even ask for a withdrawal of give a withdrawal of consent, and ask them to stop processing the data. And so on and so forth. There are user rights. In case of grievance, they can actually approach a consent manager and write to the manager to ask for the query that they have, and that has to be responded to. So all those rights, they're explained in the notice. And it's also explained that if the user's consent is, given for a particular thing, you can very well withdraw it. And if the query is not resolved by the consent manager, one can approach the DPB board, that is the Data Protection Board. So all those things have to be mentioned in the notice. And that's why whenever you see in the websites, when you're going on to websites to see there is a terms of use template, there is a privacy policy template. So those have to be very clearly read, understood, and an affirmative yes or a consent has to be given to that notice. And then only it will be considered as a proper notice under the DPDP law. However, there's one rider, I just want to mention that. Consent may be not needed in certain legitimate uses. For example, there could be a disaster, a flood. Then the government is trying to help the user, so their data can be used for that purposes. There could be a medical emergency. There could be something which is, jeopardizing the interest of the country. So the data which is, there can be used. Now that data in the DPDP is not something which is already in the public domain. That is also important to be mentioned here, because any data which is used for personal or domestic purposes is out of the purview altogether. And not, even the data which is in the public domain is altogether out of the purview. However, such data which is collected and then, that data is exempted from such, taking of the consent in such cases which are, for example, to preserve the interest and sovereignty of the country, or where there is prevention of incitement to commit a particular offense, those kind of grave situations as well. So those are certain, situations which do not require a consent in the DPDP. One can actually elaborate a lot, but I think in crux, this is the what falls under consent and notice requirement.
Thank you, Karnika, for that. In fact, it sort of opens up this Pandora's box in my mind, not just in terms of what businesses need to do, but in terms of what users need to be aware of and understand so that they can really exercise their rights. But coming back to sort of the burden on businesses and data fiduciaries, as they are called, or processors under the Act, I want to bring in Dr. Pavan Dugal. Pavan, could you walk us through this, very commonly used phrase in data legislation, which is technical and organizational measures and reasonable security safeguards? I'm sure you, in your experience, you've seen this used a lot, and it's there previously in the IT rules as well. So would you like to walk us through a bit about what it could mean and offer some guidance on it?
Well, thanks. The crux of the matter is that this is the Digital Personal Data Protection Act, which is dealing with personal data protection. However, you cannot have personal data protection divorced from cybersecurity. But when I look at this particular law, there's not a single reference to cybersecurity. As a result, the legislators have said, let's not insert this particular clause where companies and all data processors and fiduciaries will be required to come up with appropriate technical and other measures so as to protect data. So I'm effectively reading that this particular provision is incorporating therein the provision for coming up with appropriate cybersecurity mechanisms so as to keep data safe. In any case, when I look at this particular law, this law is not a special law, and it is only in addition to other laws. So the primary legislation on information technology, being the Information Technology Act 2000, continues to be the superior legislation by virtue of Section 81 of the IT Act, which says that the provision of the IT Act shall prevail over anything inconsistent therewith contained in any other law for the time being in force. Having said that, when I look at the Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules 2011, I find that the rules stipulate all intermediaries to implement and maintain reasonable security practices and procedures, and have stipulated an ISO 27001 as one example of reasonable security practices and procedures. The IT Rules 2021 once again reiterate the need for intermediaries to go ahead and come up with the cybersecurity mechanisms and reasonable security practices and procedures. Now, the golden question right now, or the million-dollar question right now is, what will be these technical and other measures that the company would be required to take? That's something that we'll have to wait for the rules to elaborate. One thing could be that the rules will say, well, we already have stipulated an ISO 27001, so we would want you to comply ahead with all parameters of ISO 27001. I also expect them to come up with further additional parameters of due diligence vis-a-vis technical aspects of cybersecurity protection. But having said that, it's all wait and watch approach. I think things will all get clearer towards the end of January by the time when we have detailed rules. But I think the companies, whether it's all the three stakeholders in the ecosystem, whether it's the data principal, whether it's the data fiduciary, or whether it's the data processor, everybody has to tighten their belts, primarily because this obligation is going to be having an intrinsic connection on the way how the provisions of this act are going to pan up in the context of the specific obligations of these three important building blocks of the data economy and the data protection ecosystem. So let's wait and watch what happens. But yes, the more we stipulate for protection and preservation of cybersecurity, the more it's ultimately going to help us create a far more secure data economy ecosystem. The only problem is going to be that because you have not specifically come up with either a dedicated national law on cybersecurity, nor have you come up with dedicated mentioning of the term cybersecurity in the context of the Data Protection Act, the moot question that's going to be, can the rules supersede, or can they go much beyond the ambit of what the primary legislation is? That's, I think, a gray zone. The law is very, very clear. The rules cannot go ahead and overreach the ambit of the main law. But because the specific language that's been used, I think the government will have that arm's length approach and a flexibility to go ahead and stipulate more parameters for these technical aspects of data protection and cybersecurity. Thanks.
Right, absolutely, Pawan. I agree with you, and in fact, so also anticipating sort of the shelved cybersecurity policy from many years ago. There have been different drafts being discussed, and also, the interaction between the DPDP and other laws. But I think Karnika had a short comment.
Just wanted to mention that the DPDP Act also seeks to omit Section 43A of the IT Act. Section 43 of the IT Act envisages or rather prescribes reasonable security practices to be adopted by body corporates. That is, when they take data, how they need to put in place technical measures, organizational measures, and the SPDI rules, which have been so far applicable, which also talk about the ISO 27001 as a standard, one of the deemed standards, which satisfies this criteria, will actually have to go. So there would be something new which will be prescribed when 43A goes. In my view, SPDI rules, which were called out under that, may also be changed or have a completely new regime altogether. We'll have to again wait and watch for this.
Right. Yeah, I think this interaction with other laws is something that we need to really pay attention to. But that also brings me to how this law interacts with other laws across the world. And I want to bring in Neha here. Neha Madan, would you like to sort of walk us through a bit about how this law compares to the GDPR, which is often considered a gold standard, and what are the differences, what are the similarities, any challenges that you see?
Sure. I think GDPR has been the most talked about legislation world over, right, when it came in. And I think it has led to the formulation of data privacy policies, of various organizations having multi-jurisdictional businesses. And of course, many countries went on to the drawing board and revised their data privacy legislation when GDPR came about. Now, I think the one thing, and this is the practical thing that, we as lawyers face, that, somebody who is compliant with GDPR, they're coming and asking that how different is the Indian, law is, and are we compliant, not compliant, and do we need to do something extra? So I think while there's too many similarities, but there's some divergences as well. To just set the perspective, GDPR was more minute in detail. It addressed a lot of practical scenarios, but the Indian law for now has left many nuances, has left many things to interpretations. For example, what is covered under personal data, personal information. Just giving an example,
we do not have different definitions of personal data. We do not have different categories. What is sensitive personal data? Unlike the SPDI, which did have, two levels, two categories of, information, which is personal information and then sensitive personal information. The new laws basically puts everything on the common bucket: personal information, personal data, and everything needs to be provided the same level of protection. GDPR did explicitly, set out that, user profiling. If any organization, any e-commerce platform, and anybody is profiling the user data, that is specifically covered in personal data. Now it is left to the interpretation, right? If I'm collecting any information of a user online, doing the profiling, do I have to, even if it is not, even if it is anonymized, do I have to cover it, not cover it? This is the practical implication what people are facing now. And of course, we have to offer the same level of protection to all kinds of data, whatever classifies as personal information or data. Now, the other, I think, divergence from GDPR has been what happens with data breach. GDPR clearly said that, the organizations have to take the decision that did the breach in fact impact the rights of the users, or basis the volume of data, basis the kind of information they were dealing with was sensitive, now that you have to inform the breach about the breach. But Indian law for now, it says that every breach has to be informed. At least that's what the interpretation for now is, right? We don't have rules around it. And do you have to report every kind of breach? Now, third thing is the privacy notice. I think everybody thinks that the moment we have a privacy notice, the privacy policy on our website, we are basically compliant. But there's much more to it. But the Indian law has basically gone and said that, you need to even only in case where the consent is the basis of, you processing the information or the data, personal data, you have to give that notice, but not otherwise. Legitimate use, you need not have a privacy notice. So now organizations have gone back and asking, do we really need a privacy policy? Because it is covered in a contract. We have a legitimate use of the data. Do you still need to have data privacy policy on our websites, or, even formulated for that matter? Now, then while GDPR did ask you that, even if you have a legitimate use, you have to inform the data subjects, what is the data principles under the Indian law, that, you need to inform them what data are you collecting, for what purpose you're collecting, how will you exercise the rights, etc., which is there in DPDP as well. Now, another important divergence is the role of the data processors. Right? GDPR did implicate or does implicate processors if they do not follow what is there in the GDPR. They're required to have reasonable security practices, in place. They have to follow the law. In India, there's no obligation on data processor. It is left to the data fiduciary to basically ensure the data processor is complying. So essentially, if a data processor breaches, it's not a breach of the law per se, but it is a breach of its contractual obligation towards the data controller or the data fiduciary, as we call in India. Now, I think these are the key ones. Of course, the children, the definition, 13 versus 18, right? But
right, yeah. I just wanted you to sort of, in the same flow, could you add a bit about the differences in approach in cross-border data flows?
Yes. So in case of transfers, since GDPR has been talked about, I'll just touch I'll touch point there only. GDPR did say that, there were certain criteria for the organization to determine that whether they should be transferring the data or not, and how should they be transferring. For example, is there an adequacy decision given by EU? It basically means the country as a whole does have a law which is as robust or offers same security level as GDPR does. There could be some countries which are not doing so, but in case they're not going, then you're bounded by the code of conduct. You can have a contractual, clauses in your contract to ensure that they're following the same. But in India, what they've done is they said that it is the obligation. There's no country transfer regulations or rules for now, and they said that the data, it's the onus of the data fiduciary basically to ensure data processor, whether located in India or outside, has to make sure that they comply, right? And all the more, while it is okay if you're transferring, let's say, a data processor is in EU, you're transferring your data there, but what happens to countries where the laws are not robust. I mean, let's say the small country do not have a legislation as robust, then you're only, you're bound by only how data fiduciary will ensure that, the data processor is complying there. So I think.
Right. That's an interesting take, Neha. Thank you so much. Sriram, I'm really excited to hear from you because you represent a business, and most of everyone who spoke here actually are representing firms or independent lawyers. So I really want to hear from you. What are some of the practical challenges that you've mapped out and you're looking at in implementing and complying with the law or in preparation for it? So Sriram, over to you.
So implementation and preparation, I guess, are the key words here, because at this point, the industry is not really taken by surprise by anything, because we've seen so many iterations of these rules come out, the act itself come out. And the version that just got passed is a lot more straightforward than some of the other drafts we've seen in the past. So there's nothing catching us by surprise, but the law's been out for 4 months, right? In terms of preparation and then moving to the implementation phase, there's still so much that we're waiting for clarity on, which, like others have pointed out on the panel, we expect the rules to clarify. And I think one of the key aspects there is also the timelines. On a macro level, obviously, we need to wait and understand which provision will come into force. When, as a company, how much time will we get to adapt once the rules are out and we need to implement those specific changes as well. And for a bigger company, if you're a significant data fiduciary, for example, based on the volume of processing, then there's an additional set of compliances. So you will expect or you will anticipate a slightly longer time frame for compliance. But also on the micro level, we will expect a little bit of clarity on various timelines internally within provisions of the law. I mean, it could be small things as well. For example, if I get a data deletion request, given that I now have an obligation to also make my third parties delete the data that I've transferred to them, how long do I have to action that request and make sure that it's completed from my end? So once we have clarity on those issues, obviously we can move forward faster. So I think the biggest hurdle in that sense would be the fact that we're expecting the sub-delegation of the legislation to take a more definitive structure, and so that we have a finished picture, right? So even today, when we're comparing the GDPR and the DPDPA, for example, I'm comparing a complete law to something that is still not fully fleshed out in that sense. And obviously, when the stakeholder discussions roll around, there we'll have a lot of things to say as an industry rep and say that, okay, this is how, in practice, when it comes to implementation, these are challenges that we anticipate. So that's a little bit in the gray area right now. But in terms of challenges for implementation, I would say that we would have to, I mean, going back to a lot of what Neha spoke about, is the differences between the GDPR and the DPDP Act. And why I'm saying that is because until the previous law was in effect, if you were GDPR compliant, you were broadly also compliant with the existing data framework. But now that is no longer the case. You could be fully GDPR compliant. You could be functionally doing all your compliances overseas and whatever, but there are some key changes, right? There's your consent manager concept, there's your verifiable age consent, all of which needs to be baked into legacy systems which have been operating in a certain way for so long. So while it's not a hurdle in the true sense, implementation will take a lot of technical coordination, spanning across business verticals and all of that. And for that, we need a high level of clarity from the rules so that tomorrow it doesn't come back to us saying that, okay, you did not look at this aspect or this got left out. So I think that's where we stand on the implementation journey.
Right. Thanks, Sriram. That's a very useful perspective, and very optimistic about the rules as well. But Akshay, do you want to add to that, especially in terms of what are kind of practical?
So adding to what Sriram discussed, so the DPDP Act is essentially a GDPR style law, which has been drafted in a very simple language for ease of compliance. But what actually has happened is we've in fact created a law which is much more complex in compliance than the GDPR. And a couple of examples, I'll deal with it. So like the address, every company needs to determine a lawful purpose or a lawful basis for each different processing activity. And consent is only one of the lawful purposes. There are these other non-consent based lawful purposes which companies can rely on, which are our legitimate users under the Indian law. Now, unfortunately, there are these two very important non-consent-based lawful bases which are found in the GDPR, which is performance of a contract So if anything needs to process data for the purpose of performance of the contract, you don't need the consent of the individual. Second is legitimate interest. If the processing activity is falls within the legitimate interest of the business and it does not override the interest of the individuals, then you can do it without seeking the consent of the individual. Now, unfortunately, those two consent bases have been left out under the Indian Act, and the question arises, but how does it impact? So I'll give you an example. Think of a situation, let's suppose, as an OTA platform. The user goes and wants to book a hotel or book a flight. So the OTA will provide a privacy notice and take the consent of the individual and transfer the data to the hotel. Now, the airline will also process that personal data. There are also data fiduciaries under the law, separate data fiduciaries. But those entities don't have a direct interface with the user. So there's an opportunity to actually give a notice to the user and take the consent of the user if you don't have a direct interface with the end user. And in the EU as well as Singapore, Australia, across the world, typically performance of a contract was a lawful basis which was relied upon by these companies who did not have a direct interface with the user. Now, in the our legitimate cases, that's been left out. So that's going to be extremely challenging for companies to comply with. And I think the second challenge, timelines I will discuss about because under GDPR, we gave companies a period of about 2 years to comply. In India, the ministers on previous occasions stated that looking at 6 to 8 months for compliance. So that's going to be an extremely challenging exercise for companies because a data mapping exercise just for a company to find out what data it connects, that's a significant period of time. So the clock is ticking, and I think the timeline is something that other businesses will be worried about.
Right. I think the clock is ticking is very timely thing for me because but we're just going to take a couple of minutes extra and not hold you back from lunch. But I want to bring Dr. Kanika Seth back here, and I want to ask, what are the first steps that a company should really take in terms of getting prepared for this law? And I'm also want to hear from Sriram on this, but Kanika, please go ahead.
So essentially, when we deal with companies and we advise them on DPDP compliance today, we understand the timelines are not clear yet. There is a lot that can be done at this point. For example, we understand what data they're collecting and how they're storing that data, what use they are making of the same, and if they have engaged vendors, other servers in India, or the processing happens outside India, and how the transfer takes place. First of all, to which countries? Because there's also a power with the central government to restrict the data flow to certain countries. So looking at that, then also, whether this data which is going out, is it anonymized? Is it for use of research, marketing, or archival purposes? Or is it something for performance of contract, for example? Then also we look at, how long this will going to be stored. And if it's with a processor, then what are the back-to-back arrangements between data fiduciary and the processors? Are they of the same reasonable security standards being maintained as we have promised the user? That is the principle, data principle. So a lot of these issues we look at. The most importantly, we look at the data. What is the data? Then who are the entities who dealing with the data? What use is being made of it? What are the retention timelines? And in what format it is stored? So all this is important because pseudonymization is also permissible, is something which is encouraged. Encryption is encouraged in terms of security. So even though we don't know as on date what security technical standards will be there, but these are some benchmarks which are already accepted even under the GDPR. So if you look at the standard contractual clauses or you look at the way GDPR is prepared, these are some technological measures which are strongly, advocated, and that's strongly encouraged. So that's something which we, as a norm, understand that this will be a base at least. So apart from this, we look at how many countries are going to be involved. If it's a lot of vendors, a lot of countries, then if it's GDPR, are we dealing also with European citizen data? That means we are going to comply not only with DPDP, but also GDPR. We also look at aspects where, for instance, certain rights like right to nominate has been given under DPDP is not there under GDPR. So we look at legally vetting the policies, the privacy policy, the terms of use, and the notice requirement, the way the data is flowing. We essentially prepare a hierarchical chart or the Excel sheet sort of a thing of how this data is going from one jurisdiction to the other, and are we doing everything which is permissible as per the norms laid down by the DPDP framework. So it's not just technical organizational measures, but also the templates, the legal documentation, which is going to be overhauled as first steps.
Okay, thank you. I think that's quite a comprehensive thing. I understand we're really short on time, but I really want to hear from Sriram and also go to Dr. Pawan Dugal. Sriram, 30 seconds, quick summary. I'm sorry to really cut you short on this.
I mean, at the risk of repetition, I mean, a lot of it's been covered because I think the primary step for compliance is going to be a painfully expensive data mapping exercise. You need to, because there is no compliance under the law that you can do without mapping out every single data point that you have, where it's going, where it's stored, what's your data retention policy, who has access to what, and all these new compliance that are coming in, right? Verifiable age consent. Am I collecting the legal guardian's information as well? If there's a nominee's information, so many stakeholders across the company. By the end of the process, you'll discover that your cup is just overflowing with data points you may not have entirely accounted for during the time. So that is the first step. And once you have that, then you can start with your structured definition of processes and systems and how you document that legally within your contracts, your privacy policy, your notice, and all of that. So your first step is going to have to be a very, very thorough data mapping exercise.
All right. Thank you. I think that mapping and inventory process is going to be quite an ordeal. Dr. Pawan Dugal, I want to come back to you and give you the last word. In fact, we've discussed about how this law has required a lot of compliances and the different interactions with the other laws. How do you think this will sort of impact how companies assess cybersecurity with the other regulations like the CERTIN or the TRAI's digital consent acquisition framework, the RBI's data localization mandate? Any comments on the interaction with the larger legal landscape and the last word on it? Also, 30 seconds, Dr. Dugal, sorry.
Clearly, there are a lot of challenges. There will have to be intermingling. The intermesh between different legal networks will have to be seen. But I already begin to start seeing teething problems in this direction. So much that there is a lot of euphoria that the DPDP Act does not come up with any data crimes. It's the criminal liability both under the IT Directions 2022 and under Rule 7 of the IT Rules 2021, which should keep a large number of corporate boards and the CXO level people more awake and be bothered about the fact that apart from this 250 crore figure that's going to hit their potential companies, it's also going to be criminal liability. So I think due diligence, caution, care, and compliance will have to be only guiding mantras. Well, good, bad, or worse, this is the law of the land. Till such time this law does not get set aside or is not amended, it's the bounden duty of every stakeholder to ensure compliance with this law for the selfish purposes that you protect your legal interest. Otherwise, the 250 crore rupees per contravention fine going to the government of India is going to pinch large number of companies apart from even extinguishing their existing business practices. And also the criminal liability is something that a lot of the corporate stakeholders will have to be aware of. So let's go ahead and comply with this law. Let's hope there's more clarity coming in the rules, but don't wait for the rules. We are Indians, we love cricket, and we love to hit 6 sixes on the last over of a T20 match. Please remember the DPDP is not going to give you that particular frequency or that leverage. You will have to make preparation right now before you come in for the final over. Why? Because the rules come in and they will get implemented almost instantaneously. There might be a small interregnum period of some kind of preparation, but it's better to be prepared now rather than facing a barrage of complaints against you for your non-compliance with provisions of the DPDP Act. Thanks.
Right. Thank you. Thank you so much, Pawan, for that. I think I'm not going to try and summarize any of this discussion, and we're already out of time. But I want to thank each of the panelists for their brief but exceptionally informative inputs. Thank you to the audience for paying attention. And if there's any questions, we can take it over lunch.
Of course, of course. Could I please request everyone to kind of come to the group picture? Ladies and gentlemen, let's welcome Dr. Counsel Chair for such a productive session. Thank you, Dr. Dugal, for joining us virtually. Which has quenched our thirst for knowledge. It's now time to fill up the questions. Ladies and gentlemen, we request everyone to come and join us for the next morning lunch. We request everyone to come and exactly 25 minutes for the next session. Thank you. Please enjoy the lunch. Gentlemen, I hope that you all are having fun. Let me find that discussions and look forward to the event in the next 5 minutes.
हाँ वाइट वाले दोनों भी एक ना वाइट वाले हैं मेरे मेरे पड़े हैं एक क्रीम कलर वाले भी 11 बजे पहुंचना है मुझे 10 बजे पहुंचना है 9 बजे तक आज ना शाम डिनर करने का डिनर करके करूंगी
On the monkey backside. Please be careful. So that was keep it here. Wait here.
काम याद रहेगा चला गया अच्छा यहाँ से आया चला गया चलो प्लीज स्टार्ट करते हैं प्लीज
Welcome back, ladies and gentlemen. Good investing everybody to requesting to kindly put your mobile phones on silent or vibrate on remote. Our next panel will be discussing about balancing ESG and economic priorities. Join me as I welcome the guest. Please kind of Sugar and Biology Association. Stop. Associate Director, Shilpa Sachdeva, put on the field risk and industries. And completing the session is the session chair. Please give it up to Sudhir Mishra, Managing Partner, Trust Legal.
Hello. It is quiet. It's okay. Everybody can hear this. Hello. Yeah. So good afternoon. After the lunch, this is the first session and a very important session. There is nothing more important than ESG, especially if you are following the newspapers and the current issues, whatever is happening in the country, abroad. So everybody was in Middle East last week who cared about environment. So when we talk about ESG and the businesses, everybody should know why this panel is here. And I'll come to what happened in last 10 to 15 days. First, you see my panel, Bharti Balaji, one of the most well-known general counsel we have in the country. Meghna Mishra, most celebrated, distinguished litigation lawyer we have in the country. Dr. Mukul Shastri, who heads the Department of Legal for Cube Highways. Praveen Sharma, who is part of the legal team, heads it in PwC. And Shilpa Sachdeva is unfortunately not here. She had some health issues. I'm aware about it. And I'm Sudhir Mishra, who practices environmental laws. So what happened actually? ESG is environment, social and governance indicators. So before I bring this illustrious panel to you, let me just set you a narrative. Al Gore, who was the most famous and perhaps the most unfortunate US vice president, who didn't become a president. The whole world wanted him to become the president. He didn't become a president. He last week said that this is the worst climate negotiation he has ever heard. And because OPEC is hosting this entire climate initiative in Middle East, any issue, any culmination on fossil fuels will not happen. Anything substantial will not happen. This was last week. But when the entire proceeding ended in Singapore, they did mention, okay, we will consider about fossil fuel. I'm talking about the planet and E first. Nothing substantial was passed because India was not committed, China was not committed. Now, parallelly, also please consider, even if we are talking about net zero in 2070, India has alternative power now, non-fossil fuel power, roughly 35 to 40% in the grid. While we are still doing that, in last 10 days, India has ramped up its entire coal powered generation, despite all the talks of air pollution because of poor emissions in the power plants. 11 power plants around Delhi, by the way, even if you have closed down Badarpur and others. So how will we deal with all of these things? How will a growing economy, a 5 trillion economy, will deal with these great challenges? Every business, like another US person, I'll have to quote the climate negotiator, who is the climate, what is his name? Anybody can mention the climate negotiator of US government who was earlier the Secretary of State? John Kerry, wonderful, wonderful. John Kerry said that every lawyer, in a lawyer's conference in ABA, he said every lawyer has to become an environmental lawyer. And that's why this panel is sitting here. So before I'll come to Mukul and we will set the tone, I will just give few more data points to you. The whole country is talking about, so E we have addressed, the whole country is talking about the monsoon leaves, and they're also talking about what Narayan Murthy talked about, 70 hours. So that's the elephant in the room for S. When we come to G, we have issues after issues, whether it's upscaling of reservations, your entire structure of reporting, corporate compliances, advocacy, whether you will allow the ranking of India in the global business indexes, how much actually it has improved, all that is part of G. So what companies will do? How even after SEBI has said that 1,000 companies have to essentially now report on the environmental, social and governance parameters, and how battle ready companies are, how much they are ready to imbibe ESG as a business initiative, as a business amplifier, and what companies are doing, Mukul will address first.
Thanks, Mr. Shah. Thanks, BW Legal World, for having me. And Mr. Mishra, as always, has set the context wonderfully well, that ESG right now is the buzzword. I'm a bit under the weather, so please excuse my voice. So no doubt ESG right now is the buzzword for all the corporates, and especially after the SEBI BRSR core, which now they have introduced in 2023. But it's not a new thing in 2018 itself. So BRSR core of SEBI refers to the guidelines, making guidelines on responsible business conduct, which was in 2018, the government has passed. So it's not a new thing. It is still there for the last 7-8 years. It was there in the mind of regulators and government. So in that BRSR core, SEBI has mandated a lot of things that you have to report and you have to rectify. And there are 9 key principles which BRSR core talks about. And it's a wonderful, so it talks about environment, it talks about the social, human capital, it talks about consumer, it talks about vulnerable and marginalized stakeholders. So it's a wonderful big document that a company has to fill in and has to report. And when you're reporting those things, obviously, you are going to act upon those things. But now, obviously, ESG is a key thing. But then again, we have to understand one simple thing, that ultimately it is business which has to be the driving core, isn't it? Because business has to be the engine. Everything else obviously has to support business, but the business engine should not fail and should not be too much into compliances. Only good for people like me who are heading legal and compliance, but it's not good for business to just be run by compliance and then by filling forms and focus completely shifts to just compliances. And I was just in the previous panel about DPDP, we have this. So now you see for a CEO, he has to comply so many things. Obviously, there are sector regulations and the business challenges, but along with that, he has to be very mindful of the data that he's getting. He has to be mindful of the environmental regulation. He's mindful of the social problems. He has to be mindful of governance per se. So see how much we have burdened our business people with so many things. Also, it's a balancing act. And before I just conclude, just one small thing I'd like to add. But then again, we have to do it. And especially I come from a PE fund. So ours is a PE platform. And therefore, interestingly, the UN has started with a concept of PRI, which is basically Principles of Responsible Investment. And therefore, every investor which is investing in these companies have to see that the investment is done in the right manner. And therefore, there are two reports that are generated. One is the transparency report and one is the assessment report. Transparency is all about governance. Assessment is all about how environmental and social friendly your business initiatives are. So therefore, the investors also are investing into those businesses which are ESG friendly. So I'll just rest my opening comments.
Good opening comments, and I welcome Dr. Batra. And just see that he's attending this panel, how much important it is for him, the ESG part. All his conferences which we attend, and I want to say in front of him, I'm completely stunned with the kind of emphasis the new companies are giving to environment, especially environment and social. For example, I was just last week moderating a panel, and there was this new ice cream company which has already got 40 outlets in the country. Now that ice cream company was working on the model of the ice cream, but they were also working on the model of a straw which will be used with the ice cream shake. Those are shakes which they wanted to make was not that important. They were more careful that we don't want to use even paper straw. So for the first time, they started using rice husk straw. And that's your problem of parali burning. So if you can make a straw out of it, just imagine how much impact it will have. So that company is actually putting up the story that how they did this entire transition. While they were inventing new concepts of these shakes, they were also thinking how they will be environmentally responsible. Mukul, you made a very important part. Ultimately, it's business. And I will come to basically Bharti will guide us that look, there are big businesses which are already taking giant steps towards sustainability. If you talk about sustainability, what sugar industry has done in India, especially in last 10 years on ethanol blending and how much it has helped on environmental causes. Bharti would like to elaborate on that.
Hi, good evening, everybody, and thanks to Sudhir. Well, at its core, what is ESG? ESG at its core is the companies trying to identify and mitigate risk and also find the opportunities for the right growth for the businesses. That's what ultimately ESG is all about. Well, I think ESG has right now become a very cool word because prior to COVID, not everybody attention was there on ESG. It's only sometime in 2020 was a very pivotal role. It played a very pivotal role. In 2020, there was a remarkable growth in companies investing in ESG products. In fact, there was a survey in Investopedia and to Invest Readers where it was noticed that 53% of the consumers using ESG products, it sort of created interest in them, and it converted to 19% of the companies incorporating the ESG in their own business models. Well, coming to the sugar industry, we do have called ethanol. I don't know if everybody is aware that ethanol is primarily out of molasses, which is a byproduct of sugar. Sorry, did somebody? Yes. Okay. So ethanol gets blended with petrol, and as of now, on average, 20% of the petrol ethanol gets blended with the petrol across the India. So there is a ethanol blending program, which is a policy given by the government of India in 2012, and ultimately ESG, I believe, is it also major stakeholder is the government because government needs to support it with a robust regulatory framework. Because end of the day, if you leave it to the companies will not want to forgo the short-term capital profitability for long-term strategies of so-called ESG. So therefore, there needs to be a
the right amount of push from the government in terms of the regulatory framework. And also the companies need to look at the larger goals end of the day. So ethanol policy has been hugely supported by the government of India. It's in fact, why should we be looking at ethanol? Ethanol controls pollution, and it's in the transport, it reduces emissions. Now, these are the steps taken by the sugar industry. There's something called, in fact, Toyota and Maruti was tied up with ISMA, wherein you will see hybrid vehicles coming, where we have flex fuel engines, which is now they're running at 20% of ethanol like petrol, but you'll see very soon all the vehicles should be running on 100% of ethanol. Obviously, there is a argument in the market vis-a-vis electric vehicle versus the ethanol. What is the profit, etc., etc. But in the day, we should not forget that the electric vehicles again are based on the fossil fuels. And if you're looking at renewable energy sources, as the sugar industry is expanding its portfolios, diversifying, whether it's plastic waste management, whether it is in green power, it's renewable energy sources based, bagasse-based cogeneration, or ethanol, the sugar industry is definitely ramping in terms of at least the E part in ESG. And E and S, I believe, is quite interlinked, definitely. So I think...
Very, very, very good initial thoughts. And Meghna, I'll come to you as the last resort, like disputes and litigations are the last resort. Praveen, I'll come first. And Praveen, before you address this gathering, now PwC has done amazing work on few of the stories of ESG compliances and ESG as a business strategy. Even those reports I was looking at. But I just want to address to the data. The new startups, India after US, China, we have the most robust startup ecosystem in the world. 70,000 startups we have in India. But the shocking part is only 7 to 10% are prepared for any ESG commitment. Now they all will become giant operations after some time. So when you have these stories of ice cream, which I was telling you, I have another story to tell you. Again, thanks to Dr. Batra, because I was part of that panel. There was this apparel company which was saying that people after people, and Mukul, you made this point, consumer behavior also decides how much committed we will be to ESG. So consumer actually returned this because there was over packaging on that apparel. He said, I will not take it. Why you have layered it with 5 layers of packaging? Now imagine 5 years back, this was not possible. So Praveen, when you mention about how you look at ESG, what is happening in Indo ecosystem on ESG, how prepared we are to be on the global stage on ESG parameters?
Oh, well, thank you, Sudhir, for this wonderful question, and thank you everyone for having me here. So very interesting question, and I would just address it in bits and pieces with respect to what all we have said and have set the context for. Now, when it comes to sharing the ESG story for any organization, as you mentioned, that PwC has actually helped a lot of organizations to set that story right in its context. Now, it starts with the 3 key pillars. There are 3 pillars, what we call it: strategy-led reporting, and reporting-led transformation, or reporting-led strategy, and then again leading it to transformation. Now, when I'm talking about these 3 pillars, it's certainly ESG does not have to transcend only from a compliance perspective. ESG cannot be looked at in an auxiliary form. Absolutely. And it has to be embedded into the business strategy, because all these business decisions has to be derived with the backing of profitability. Now, certainly ESG asks for a certain amount of investment, efforts, the compliance has its own cost, but eventually you have to make business working. Now, these stories that we have worked with are more from a transformation perspective. Now, how ready India is at a global front, certainly it all started with A, strong stakeholder activism, B, the investors push, C, the regulations. Now, regulations are really catching up quite fast. Now, with BRSR, we have actually set the benchmark.
Just say the full form also, business
responsibility and sustainability reporting.
By SEBI.
By SEBI, it has set the benchmark, and now BRSR core is setting another benchmark which asks organizations to take reasonable assurance, not limited, reasonable assurance from FY24 from the top 1,000 companies.
Lovely.
So it's starting from there. Now, just coming to the point of startups.
Yes. Sorry, I was just trying to.
There is another aspect that is being covered is that all these startups also have to report in another format called BRSR Core to cover 75% of their partners, value chain partners upstream, including upstream and downstream. So that is getting being
it will percolate down.
And these startups, certainly whoever we have worked with, it makes a lot of sense for them to capitalize on the idea of consumer activism, as we spoke about, where we can certainly be more innovative in our ideas and our product launches and setting the right context with respect to the social and governance aspects that come work with us or buy our products. We are a company who's not only financially profitable, but also non-financially working phenomenal.
Brilliant. Very well said. Meena, now everything is ready for you to go. So basically, I'll just take you in the background. What all of us are saying here, because you have handled such matters and the firm is so well known for handling those disputes. So when in the 90s and 2000 and post 2000, this transformation in this country was happening because you make a building on a foundation. This is a country where your forest cover was 9% at the time of independence. Today it is 17%. So this is the good work. And your courts have facilitated that. Similarly, the High Court, Supreme Courts and the NGTs and the empowered committees, what they have done, they have inculcated a culture of strong compliances, which you call a jurisprudence for environmental issues, so far as E is concerned. When you come to S, all the Vishakhas and the POSH Acts and all the judgments which have created rights for the child, for the woman, they all are something which the country is proud of, which shows us internationally in a different way. So that becomes your S. On the G, in last 8-10 years and even before that, the kind of the performance indexes which the world believes in, even if you say we are golden, Sone ki chidiya, nobody believes that. But the performance indexes which are there, our ease of doing business, our corruption index, our regulatory compliances, we are now broadly under 100, which we are beyond. So how much courts have played the role in it, and how much this voluntary compliance which is happening now, like plastics, for example, the entire transition of plastic, like we were plastic society and we are lesser plastic society today, is without court intervention. But law firms are playing a big role of telling them on the pollution control board issues, working with the clients seamlessly. How do you see this change happening?
So, first of all, thank you. It's a pleasure to be here. So while law firms will play their part, and before I come to that part of the question, I think what is essential to address is also a change of mindset that we see. So it's not like courts are working in isolation. So, you know, there was a saying, Jaan hai to jahan hai, but jahan hi nahi hai to kuch bhi nahi hai. So I think everybody understands that. And, you know, consumers are also very, very aware today of what they are purchasing. They will look at, is this a sustainable company? Is this something that is using recycled materials? Like on this panel itself, like we've had the discussion about the straws and about the sugar industry. So I think all of that is happening. Courts will always step in and, for example, you know, the top 1,000 companies compliances, if they don't take place, of course, that becomes something that could be a compliance and regulatory issue. But there are also statutory compliances under the Environment Protection Act, the Air Act. Let's take Delhi, for example. When the buses, the CNG buses came, it was through the Justice Kirpal's judgment which came. So I think courts have always been very, very proactive to step in where there has been a vacuum. And I think as time goes by, we will come to a situation where there will be more mandatory compliances which will have to do with the ESG. But at the moment, there is just regulation, guidelines, and we can all urge, and we will require a different mindset and approach. Yeah. So the more we discuss this, the more we'll get there, because you can't have a situation where the courts will function in vacuum, really.
Right. So very well said. So all the four panelists have broadly talked about it. They have talked about consumer behavior and what the market dictates, because we are talking business and ESG here. So if you see it very closely, what happened in Delhi? How did you get so many electric two-wheelers in Delhi? Even if Bharti is right, it's not addressing the part of the circular economy, but there is a massive shift. When odd even happened in Delhi, scooters and motorcycles were kept out of it. But now, in last 4 years, you know how many scooters and motorcycles have been bought which have no fossil fuel attached to it? It's roughly the buying has completely changed in Delhi because it's cost effective. It's not only for the love of the environment, it's very cost effective to run a scooter which is e-scooter. So it is consumer behavior. But I would say a bigger success which is happening is on the electric mobility. Both Meghna and Bharti have talked about it. And that's a huge, huge leap for a country which is still looking to continue developing, continue creating its narrative. So where do you see road companies being an example on ESG?
Yeah, so road companies and infrastructure definitely is the sector where we are doing a lot of work for environment. Because see, roads are to construct roads. It's always an environmental unfriendly kind of a space. It has always involves huge constructions, and then flying of vehicles and flying of fossil fuel vehicles has always been paid as if they are causing a lot of damage to environment. And then obviously labor intensive industries, so now social factors are also there. But then past few years, the entire approach has changed. And as I said, that even investors are looking into those things before investing, that not only it should be a cash generative or a commercial success thing, but it should also be right from ESG perspective. So even that thing has come into mind of investors. And that is where the UN principles of responsible investing has come into picture. And all the multiple or the multinational investors are very much aligned to that idea. Having said that, and obviously there are the scope 1, scope 2, scope 3 patterns or ESG reporting. Scope 1 is something which is directly, which is in my hand, like when we have electric vehicles for petroling. Scope 2 is basically when you have indirect, so whatever you're purchasing, you are purchasing from renewable sources. And scope 3 is primarily asking your supplier of goods and services to be environment friendly. But then all these things, I feel the S part still is missing. If you see, the focus is mostly on E and G. Well, E, there are 100 crores of fines and all judgment of courts. They're always focusing on E. Like well, G, LODR is there, all the reporting governance. But that's S part. When we talk about human capital, we talk about them. But then I still feel diversity, inclusion, and those pieces are completely missing even on the bigger radar. We talk about them a lot in conferences, but on the ground, I've not yet seen it taking off at that level.
So well said. Bharti, your final thoughts in a minute. I have to applaud you for one thing. You have nurtured, if I put that, ISMA, a regulator of a very important industry in the country, and you have put more than a decade there. What do you want other such association to learn from ISMA so far as ESG is concerned, or maybe just S or just G, whatever you want to say?
I think ultimately for any industry, I would say it's policies, again, a policy driven, right? End of the day, there has to be some conducive policy, some support from the government, and obviously for the companies, there has to be some short-term, long-term capital profits to see that. And besides this, of course, let's not forget that today we've woken up to the words of SDGs, environment, and all these goals. Even whether it's investors, whether it is consumers, everybody's become very conscious. And this has become very paramount importance for everybody before investing, before even consumers plan to engage with such industries or even buy such things. Everybody's become very, very subconscious, very conscious of this. So therefore, there is a transformation shift which is happening, though it's gradual, it is happening, but there are still concerns in terms of policies or companies, looking at larger picture than just short-term goals. Because as a GC internally, I do have these concerns internally. It's always about balancing and trying to mitigate the risk and highlighting the risk along with the budgets, the so-called budget balancing.
Okay.
So that is where these concerns come in.
Even if the one ESG report, when you consider green arbitration, how it can help the cause of environment as a ESG report, it will be a great effort to actually, because a lot of pages are wasted, and I'm told that 20,000 trees are cut to do one arbitration.
No, absolutely, Sudhir. This is something that, not only PwC as a big four. So,
आप बड़े होना आपसे मांग रहे हैं
but
स्मार्ट से नहीं मांग सकते
no, but certainly, big fours and the entire corporate ecosystem certainly push the idea of green arbitration, and certainly, and environment anyway is a focus of the matter, Sudhir. Everywhere we've talked about COP28, where we have set the targets. In fact, global target has been revised to 250, net zero by 250. India has set the target.
चलो let's do something more concrete. I'm so sorry. Silfco, I will put a word, Meghna will put a word. PwC will collaborate with us on no cost basis. We'll do a joint report on ESG. Let's take out something from here. BW will be happy about it.
No, absolutely.
Can we try that together? Don't commit.
Praveen, I want a very real latest.
Right.
Come on, stand on Monday. Is on climate plan or green energy plan. Arjun Yadav is going to moderate the next week. The editorial he's answered that. How do you see COP28? Has it succeeded in objectives? What is India? It has like midway during the COP28, I saw Secretary
initially, but
हम एकदम coal phase out नहीं कर सकते, right?
रातों रात बनाना शुरू कर दिया हमने last 1 week में यही बोला हमने panel.
So I really want give us a realistic sense of how was COP28 with the business world in India.
So the realistic answer is, being a consultant, it's good for consulting business. That is one. But no, I believe that there is a long road. There's a long road to go. There is a long road to go. Certainly, at a global geopolitical sense, it's just at a very nascent stage. But certainly, India as a country has huge aspirations, not only to become a leader economically, being a 5 trillion economy or a developed nation by 47, but to do so, we also have to do good in all ESG parameters as well. Being a voice of global south, set our own targets, but certainly has to protect our interest as well, that we are dependent on fossil fuels. So no, certainly, there is a long road to go with respect to what is happening across the world. But interesting, the good development is that every region is catching up with the regulations. The CSRD regulations are, have come up later than the BRSR regulations. Similarly, SEC is looking at,
I'm asking, how did we do as a country?
Yeah, I mean, that's more of a,
Okay.
we have to, we could have done better.
Meena, the last word to you. What do you think?
I think when it push comes to shove, and we saw that in COVID, courts went virtual. We started giving up on the voluminous briefs. We have all moved to iPads and laptops, and I really struggled, but one has done it. So I think once the push comes is also when you will see a lot of action, but it can't be in a vacuum. It has to be a change of mindset. And I think you can't just put everything on the government. The investors also want it. They want long-term solutions. So you have to focus a little bit more on highlighting that maybe right now you have to invest a little bit more, but in the long term, how does that profit you? And so I think with more discussions, more
famous that in the long term we are all dead.
No, I said that right at the beginning, that जहान ही नहीं बचने वाला तो जान है तो जहान है तो होने ही नहीं वाला. So I don't think we have a choice to now push this anymore. So even now, even if we do this at our alarmist pace and we have more people like Sudhir trying to propel this in the right direction, we all must come together to do it. And I think the next generation is a lot more aware. So I as an optimist, I feel there is hope. And I see that with the next generation.
Okay, thank you. We're absolutely out of time. I finished my panels on time. Thank you. Thanks a lot.
Thank you.
Thank you. Thank you so much.
I hope Sudhir will instead of finishing them, you completed them. But he was finishing all of them, but that's also okay.
So that's it. Thanks to you all to kindly come forward for a quick question. Continuing the saga of discussions on next topic of our next round discussion is intellectual property rights in the era of artificial intelligence. Ladies and gentlemen, join me as I welcome the panelists. Yes, welcome immediately. From your audiences and with a big round of applause. Please give it up for Kunal Kapoor, Sim Donald and the Supreme Court. Please give it up for William Coach and Sir Intel and the Law. Please welcome Raju Clear, the General Counsel to Electronics. Swappo also Associate and Litigation, Lex Office. Session Chair, Patrick Chandok, Trust Legal.
Hi, good afternoon, everyone. Thank you so much for having us here and allowing us to speak on this very, very important and I think something which is going to really rule the world in the coming few years, which is AI. And when we talk about artificial intelligence, it's very important that we also align it with IPR, which is intellectual property rights, because at the end of the day, we have been seeing artificial intelligence in almost everything around us, whether it is, in fact, even to the extent of arguing a case as a lawyer in a court of law. So that's how far AI is really, taking its place. And when we talk about IPR and AI, we realize that there are so many things, there are so many aspects in terms of ownership, authorship, how to differentiate the human intervention from AI, and so on and so forth, that it's a very vast topic, of course, something which may not be possible. We were discussing it may not be possible to cover in about 30 minutes, but what we are today looking at is to understand the basic underlying concerns and what we are looking at in terms of protecting IP, especially for the authors or for someone who's created. And with that, I think I'll start the panel with Mr. Malik. Mr. Malik, what are your views on IPR when it comes to AI and intervention of AI? So if you could please share with respect to copyright and with respect to patent. So please start with anything with respect to copyright. That's
you have actually rightly mentioned that the copyright is at a intersection with the AI these days. Traditionally, it was not the issue regarding the computer-generated programs and the creativity, because it was just means of tools like pen, paper, paint, and brush. So these are the normal instruments which used in the creative work. But in the era of AI, the whole dynamics and there is a shift in the paradigm shift in this area. Now, only the software developer is only inputting the algorithms and codes, right? But the system, artificial intelligence, generative AI system is automatically developing the creative work with very minimal human interaction, right? That makes a difference where there comes the dispute, the whether or conflict, we can say, whether it is the AI which has generated, software developer is the owner, or the human which has interacted with that is the owner of that thing. I have seen one series in Guilty Mind on the, I think, in Prime, where it dealt with a very good question, where the AI has generated certain music, right? And the case was filed by the music director that it is copyrighted. Right. Well, in that case, it was a series. So the court ordered that the human intervention is required So it has not granted anything to the AI owner. But if you see in the other jurisdictions also, I think it's only the UK which is giving the right to the AI, and other jurisdictions are still
China maybe.
And yeah, China also. Others only dealing with the human touch, right? And there is one commercial aspect to it. It's a very important that if any suppose the music developer for AI has developed a software or a music program, right? He has spent millions of money invested there, and if he's not getting the right, then what will happen to that? Then how will the innovation will carry on? So on this conflict, I have written one poem. If you allow, I will just narrate that.
Sure, please.
In the room where thoughts take flight, AI's creation is a brilliant light. Yet amidst this blaze of innovation's fire, copyright's dilemma, a tug of fire. AI's creations born from codes and streams, but whose right vein in these innovative blues. Individual sparks, their creativity's glow. With AI's outputs, a conflict to show. Copyright embrace, protecting mind's yield, but AI complexity, a new battleground found. One generation stands in this time and line where AI's powers meets the individual's design, a dance of order, a force of law, innovation's fight, balancing rhymes in digital light, and it's to build a path to find where both AI and creators rights intertwine. So that's the point I have written on looking with the complexity.
Absolutely.
And this, of course, I should give the disclaimer that I have taken the help of AI in writing this. Then I checked with the AI whether what is the right owner. At first instance it said it's the owner is a software developer. When I challenged as a lawyer that it's because of my intervention, it has been on the picture, rather than giving the same result to the person, it said no, it's the only given to you. It will be only used for you, so you are the rightful owner. That's the AI person.
So we have an author here in terms and beautifully, I think, captured. I think all the aspects of AI with respect to IPR that we were discussing even before the panel is what you've captured in the poem very well. So moving on, ma'am, when we talk about, so sir, of course, touched upon a few aspects of author. But when we actually talk about the authorship of IPR, where there is an AI intervention, what are the issues that we can come across? So we were also discussing duration, and we were discussing those aspects. So if you could throw some light on that. So copyright, so of course copyright where there is an AI intervention, and the aspects around it.
Sure. Thank you, Petal. And good afternoon, everyone. So as beautifully written and with the help of AI, I'll take that conversation forward because that's exactly is the issue. Now, AI is machine intelligence and copyright conventionally was provided to human intelligence. Now, we are going to discuss that ownership will vest with machine intelligence or human intelligence. So we have lived an era where computer was aiding to your performance or to the output. Now we are in the era where artificial intelligence is having intelligence, is capable to react, respond, communicate with the environment, and give you the analysis and also analyze the data and give you the output. Now, therefore, there is a conflict of whether machine intelligence will give the rights or whether the human intelligence is yet required. Now, you read a poem and you said that you are the author, the software developer is the author. Now, the question which arises, and I'm a lawyer, so I'll take a step back, whether it is original. That has to be answered. So what is originality? So now again, there are two extreme views. For example, India, UK, Hong Kong, they take, sweat and brow test where originality has to be your labor, which I think you will qualify because you have given some prompts to the AI tool that I want this and these are the challenges. I want it in this manner, whether it has to be rhythmic or not, length or choices of words and so on and so forth. And vis-a-vis that, there is another view where the test is that it has to be human intellect. And human intellect to the extent that, you have written some concept originally and then machine has helped you to kind of convert it into something. Now that's the struggle the whole world is grappling with when it comes to AI. Now, if it is an original work, now the question arises that the prompts which you have given, is the prompt, if given to the machine every time the same prompt, whether it will give the same result? If it will give the same results, then probably your prompts were so specific in terms of parameters that only you could have arrived at it. And this is not what I am saying. This is the recent judgment from the China where there is a case Li versus Liu, where one person, after giving 150 prompts, which was super specific, super technical in terms of what he wanted to be created, and every time you give 150 prompts, the same artwork will be created. If that is of that extent, then it will be kind of some evidence that you have used your human intelligence and fed in the machine intelligence to create something, and that will probably cross the threshold of originality, and then probably you can ask for the authorship. Now, the authorship has, just one more minute, authorship has two aspects of it. Authorship cannot be by a machine for two reasons, because as we all know, the duration of AI is after the death of 60 years after the death of the author. Now, if the machine becomes the author or the owner, machine is never going to die. So how long it will be? So it has to be a human being who will be the author and who can be the owner of the copyright.
But I just differ on that. That why, when the idol in a temple can file the writ petitions, and why not computer can be said as the owner of the machine? Yes. It's not the software, not myself who created the things. And one more thing is there that just like machines and human work on a neural network, right? So we are also. If I'm not writing a poem with the help of AI, I'm writing of my own. Even then, I have read somewhere some things. Then I am creating it. And the same way, artificial intelligence doing the same thing through the neural networks. Right?
I think that is the whole point of debate, whether the author can be a machine at all. Because when we were also discussing, there is China who allows protection in terms of AI created copyright works. But when it comes to US, they are completely, with a very different opinion. They state that only if we are able to differentiate, and rightly so, ma'am had said that only if you are able to differentiate between the human intervention and the AI intervention is when you are able to, get a copyright. Otherwise, you can't. So moving on, Amit, if you can throw some light on. So we spoke about the work that has been created and with AI intervention, or even when it is whether it is patentable or let's say copyrightable or not, or protected for that matter. What about the authenticity part of it? So when there is an end product which has come, how do we understand and really take forward the authenticity part of the product? Throw some light on that.
Thank you, Peter. So you see, AI, whatever AI is generating today, is something still in dispute to have that authenticity to use it to get the final proper result. Like if we are, like ma'am said, we in a litigation, if we are using some arguments which we have framed using an AI, there is a recent case which happened in New York, and they used that judgment, the arguments and the framing, and that they used it in the evidence in that matter. But that was not acceptable. That could not be taken up to use or to put a final judgment in that matter. So authenticity is still a question which is getting explored now that we don't have the exact laws which we should to have the concreteness of what we have derived from an AI. We are looking into the different aspects, how we can use the data which is produced from AI to probably simplify what you're trying to achieve, but not to the extent that it can be relied upon, so that tomorrow if something has happened because of probably a negative situation which has arisen out of what AI has generated, you cannot pinpoint will it be the author, will it be the person who has given the prompt, or will it be the author of the software, the AI software, which has made the situation?
Right. And also, Mr. Tandon, to understand, so when there is a product, it has been created, or a work which has been created, and let's say if it is through an AI intervention and receives also, a protection, what about the infringement part of it? How is that protected? So if it is infringed, who is the author first, and how to protect infringement with respect to any AI created work?
Yeah, thanks, Petal. I think your question before to Amit was really the question which needs to be answered. And
Sure.
the second issue which needs to be answered is who is the author.
Right.
Because if we are able to come to a conclusion as to who is the author, then of course infringement issue will be answered straight away.
Correct.
Authenticity, I wanted to just add that ultimately when we give a prompt on this AI tool, what kind of material AI is going to use, we are not aware. Is it going to use a copyrighted material of somebody? Is it going to use a material which is non-copyrighted? Or is it going to use a material which is completely in public domain? So we are not aware. Now, if I claim authorship to that particular document which has been created through that AI, of course, the infringement will lie on me because I am somewhere responsible. So once the question of authorship is answered, infringement is answered. The second issue, according to me, is the period which you also spoke about, that how do you consider AI to die? AI will never die. AI will always remain there. So are we going to bring in the concept of machine in the laws, or we are still going to continue with the laws which we are continuing today?
Right.
I personally feel that at the moment, we really don't know where we are headed.
Right.
The world is grappling with it. The only regulation which we've seen till now, which is far from intellectual property, is in the EU a few days back, which also talks of how users should make use of that AI. It doesn't talk of AI using these copyrighted materials, etc. So I think as a world, we are far from developing those laws, though we've developed that technology. So of course, this is the hottest topic. I also don't have answers at the moment, but yes, these are issues: authorship, infringement, person or machine, originality, non-originality, whether there is originality in giving prompts, whether there's no originality in giving prompts.
Right.
All those issues are there which will have to be answered, really.
Right, of course.
And one last thing, I totally disagree on one fact, that the AI will be able to take over court work. I don't think
it can, because
there are a lot of emotions involved there, and AI has no emotions.
That, as well as the skill. I think that skill part, AI can never,
That's right.
take over.
So I just want to add here that, the human being is blessed with inherent cognitive faculty, whereas machine is a trained, intelligence. So there is a huge difference, and that can never be taken away. And just to add what Kunal just said, that, for infringement also, the data, input data and the output data, we have to understand it very well. So if input data is legitimate, which means if it is taken from the source, which is publicly available data, non-copyrighted, and if you are then generating something, probably you will not be responsible for any copyright infringement. But what if your input data itself, the AI tool which you have used itself, has collected such data which are infringing copyright data, and you're not made aware of that, and you're using, who will be responsible for that? Software developer, the AI providing tool machine, or the user who has used? And this is what the question the whole entire EU is grappling with, the legal framework, the ownership and the responsibility associated with handling AI development, or AI as a tool, or by the user. So this is going to be a very interesting era, but all said and done, we can't avoid AI is there. We have to embrace it.
Absolutely. And ma'am, if you could maybe also throw some light in addition to this, to the fact of, so we all know that copyright, really attracts royalty aspect to it. So how is that going to be dealt when it comes to any AI created work?
A very interesting question, because IP we all know is what it is like it is a potential to exploit and generate revenue. IP is a tool to generate revenue. If the underlying work or if the creation is not rewarded, then there is no IP, there is no interest in IP. So therefore, when we are talking about either a patent or of a copyright, who is going to take the award or who is going to take the royalty or the work for the work generated? That's the question which we need to answer. So if it is going to be machine, and whether we are going to, for example, I'll just give a quick example of this Dabas case, which has gone to US, to Australia, to UK, and everybody said that it is the natural person who can be in terms of the patent I'm talking about. And only Australia said that, okay, it can be a natural person, but in terms of who can receive the reward, who will have the person who can secure the, because it can't be a machine. So the person who is owning that AI or the owning that software can receive the royalty of the invention which is being exploited. But in terms of copyright, it's more complex because we are talking about copyright. There is one word can have underlined work. For example, there is a musical composition which can be a lyrical word. So now there is a lyricist who has created something, who has written the song. Now there is a composition, but when you are playing the music, there are so many underlying work, and you have to give royalty to all those people who have created the underlying work. So how are you going to make AI as a author of the book? How are you going to distribute this royalty to the people whose work has been collected and fed in the machine to create a new work? So are you going to recognize and give those royalty to those underlying work and to those authors whose work has been fed in the machine to create a new work? So that all that is going to be a very complex issues, and I think internationally a lot of work is going to create that framework and the ownership and the liability and the compliances issues that you have to undertake and disclose as to which are the work which you have fed, what data you fed in the machine. If the data is copyright free, then probably you can use it. If the data is not copyright free, you will have to first pay them before you are feeding this data in your AI machine.
So I think at the end, the only answer we need is who is the author.
Who's the author?
Yes, if we find an answer to that,
the creator. I think if that is clarified, then a lot other things are also crystallized further. So, sir, from you, maybe also closing remarks and some thoughts on the aspect of disclaimers. So, when it comes to, let's say, when we were also talking about numbers, throwing light on the aspect of whether protected or a copyrighted work is being used. So what is the input that is being generated, and whether it's a patented or a copyrighted or protected work that is being used in creating your new work or not. So do you think that AI also needs to have that kind of disclaimers, and that will probably help us to create a work which is let's say not going to attract any liabilities when we are creating a, let's say, copyrightable work?
Actually, all these issues seems that a human has a fear. While we have created AI, but now they are in fear, what will happen to them only, right?
Yes.
I don't think God, while making humans, had such kind of fear, right? so practically, if we say, of course, disclaimers are there. AI is being linked as sometimes as a beast, sometimes it's out of a genie bottle, and some things cannot be controlled. All things are there, but still, I feel the AI itself will give the answer all these to these questions of the queries which you are having. I am confident that the technology will find the way. Of course, there is a need to have the balanced approach between who, because nobody should be get hurt because of that. So everybody will get their dues in the due course of time.
Right.
so
Right.
Petal, I think the answer. I'm sorry.
Yeah. So I'm just saying that the rise of machine are there, not as a conqueror, but as a creator. Someone has said, I have not said this. Disclaimer.
So I think the answer to your question lies on the fact whether we have the care and diligence to
Absolutely.
be exercised in respect
While we're creating.
while
Yes.
it is being created. Now,
Yes.
care and diligence is required to be exercised in certain areas. It is not required to be exercised in certain areas. Like let's say defamation law. Care and diligence may not be required when you're airing a news. You just to follow and stand there and say, I say this is the truth. But care and diligence may be required in AI creation, in which case disclaimers will not work. It can't be that I disclaim that this is right or wrong, because I need to be careful and diligent.
Correct.
So it'll really depend as to how the laws develop.
Even if it is there, it may not be of any help.
May not be of any help.
Absolutely. So, Amit, maybe some closing remarks from you, or maybe we'll go one more round if there's time. What is that one pain and boon that you were talking about when it comes to using AI in, let's say, any IPR?
So you see, like I said,
One each.
yeah. So the boon is you can use it to simplify your stuff, to simplify an answer, to probably, in fact, I was just telling Kunal that we can feed it to AI to ask him who is the author to you. Might not name you the author, but it will give you an answer. But the boon is simplifying. Bane is you can't use it. You can't use it to actually give an answer to where you are representing.
Or let's say you can't even rely on that answer completely.
Yes,
100%.
you can't rely on that
Yes,
answer.
yes, absolutely. It may have made life simpler in some manner, but at the end of the day, you need to put your what Mr. Tandon said, skill and diligence at all times. Closing remarks from you, Mr. Tandon.
Bane or boon?
Yes.
I think surely not a boon, because human mind will surely become very lazy. We as human beings tend to find very, very short methods of producing results. I can give you one very small example. When we came into the practice, we didn't have search engines like we have today, SEC Onlines, etc. So the research used to happen through quintessentials or the 10-year digest. We used to go under those topics, look for those judgments, and for latest judgments, we would actually go to quintessentials and see whether under that particular act कोई judgment तो आई नहीं है कि नहीं. आज क्या करना है? At the click of a button on Google, I can get कि कल judgment कौन सी pass हुई थी. So the fact that I'm trying to say is that you are not reading anymore. You're not enhancing your knowledge. You're just going, typing few keywords, getting that judgment and reading that judgment, and that's it. But you're not reading 10 different judgments. So surely, my view is it's surely not a good thing. But yes, technology is going to help us somewhere. Let's see how it goes.
Very quickly.
Yes, very quickly. I disagree completely, and I'm sorry, Kunal. It's a boon, and nobody can deny it, because it's a progressive time, and AI is now being, jokes apart, AI is now being used in education, in training, in medical, in medicine. I mean, every walk of life, everything we are talking about, it's AI related. So it's definitely a boon. It's a new future. We need to kind of be not lazy enough, but learn it quickly. Yes.
Be ahead of it.
Yes.
So, Bane or boon, quickly.
It's always a blessings actually to have AI also. It's only the God gifted. So we should use it diligently and with care.
I think the moot point is to be able to use it and be able to really make the most of it in the most appropriate manner, and without getting lazy, and with a lot of precautions. So thank you very much. Our time is up, and so are we. Thank you. Thank you.
Thank you. Thank you so very much for such an interesting conversation. But I please request you all to kindly come forward for a group picture. Artificial intelligence. Well, the experts have shared their opinion, but we leave the room and to a better understanding to formulate your own final answers for this one. Following the conversation about artificial intelligence, our next topic for final discussion is generative AI and legal risks in company operations. Join me as I welcome our panelists. Please give it up for Raj Singh, Associate General Counsel, Lakeland Trip. Let's welcome the gentleman with a big round of applause. Please welcome Sharma, Vice President, Engineering and Contracts for Use 24/7. Please welcome Raghav Gupta, OPR, Legal Counsel, Play Systems. Please give it up for Kanika Sachdeva, host and Legal Counsel, Striker. Please give it up for our panelist, Kriti Sharma, Tech Innovators, Privacy Counsel. In conclusion of the panel, the session chair, please give up for Arjun Yadav, Senior Correspondent, Data Business World.
Thank you. Thank you so much. Thank you all for joining us this afternoon. And back to back two panels on generative AI. I think for the first time in 1 year at any of our events across communities, we have two panels on AI back to back. But that's how, it sums up the importance this technology has gained ever since the coming of ChatGPT in November. We've seen investment news, a lot of investment news around this technology, a classic power struggle weeks. And when I glanced at the agenda a few days back, I first thought that it's more on the use of AI and how it will revolutionize legal practice in general. But our topic is a bit in detail, which has a business element as well, where we are talking about how it is being used in day-to-day operations and the legal risks arising out of it. So panelists, in your opening comment, I want to understand that in this 1 year, how has corporate India embraced the use of generative AI when it comes to their day-to-day company operations in your respective sectors? You can share, or in general, what corporate India is thinking about. Viraj, if you would like to start. Thank you so much. Very quickly, there is no regulation for AI as of now, which regulates its use by a corporate. So, as such, we are in a situation where there is tremendous business pressure to start improving processes, to start improving content creation using AI. But that does not come with any inherent legal protection or legal processes which can be followed to mitigate risk arising from it, leading to a strange situation where, while on one hand there is tremendous pressure to use it to revolutionize processes, there is also a situation where a company has no protection in case the results from that AI are suboptimal or may lead to any sort of liability. So we are in a situation where you can use the AI, but it is completely at your own risk, and you have to own any result which the AI generates. So therefore, from a legal perspective, at least, we don't really see as much the heights AI can achieve. We are more concerned with the depths of, what we call the stupidity part of the AI is what the legal department are most concerned with. Because with the AI is a consumer-centric touch point where he's talking to customers through an AI chatbot or generating content for customers with the customer will review, then any mistake in that is owned by the company. And I think that is where the legal fraternity right now needs to be really careful on how to guide your company to use generative AI carefully, selectively, consciously, and mitigate the risk to the degree possible. Right. Thank you, Abhiraj. What's your reading on this?
So thanks for inviting me. We are seeing that generative AI has come in since last year and a half into for more since ChatGPT was launched, right? Inside our company and in the industry, people have been experimenting with it. But as of now, it's not being used on a large scale anywhere for customer-centric outputs or in media campaigns, right? Generative images or text right now, but it is definitely increasing the speed of work when done internally. For example, you need to make presentations, quick images, quick text, outlines, those kind of things. So it's being used there, but again, nowhere where it can go out or it could create legal risk. So that's where it is. Generative, as Dhiraj also highlighted, the errors, right? So no company would like to put its money behind it as of now. And we'll continue to watch and wait
for it to reach to a stage where, it can really lessen the load, or it become economically viable and safe.
Right. Thank you, Pawan. Gaurav, what has been your readings? How the corporate India is embracing this?
Before dwelling into what corporate India is doing, I think we need to look at from a global perspective. A lot of companies, tech-driven companies in US and Europe, have to some extent tried to embrace generative AI in their day-to-day operations, but at this stage, it's a very early stage, right? So, for example, in the way a particular department functions, the legal department or HR, how you can use AI for workflow management, how you can use AI to read the contracts, to kind of use that information which can help in day-to-day operations. I mean, the technology has always been there, but it's just how quickly you are willing to adopt that technology. So there are certain big companies who are early adopters to these technologies, and they have kind of taken considerable steps in this direction. But I guess in my perspective, from my perspective and from an industry perspective, I think going forward, the smaller companies will adopt more wait and watch policy and see how they can maximize the utilization of AI in their day-to-day operations. So I guess it's more of a wait and watch.
Sure. So wait and watch. Kanika, what would you like to add to it?
I think just taking the conversation forward, we are at particular crossroads where we need to make a call. We definitely need to figure out a way how we can adopt AI, because technology, I think we were having discussion in the last round, whether it's a bane or a boon. A lot of organizations feel that if we don't really adopt AI at this point in time, we would be left behind. And I represent MedTech. So for us, it's very important. But at the same time, what is important is doing the diligence, putting out a framework, a responsible deployment of AI. I think all these factors really need to be considered when you decide to deploy AI at a large scale. And for every workflow process or whatever, if you want to do it, if you want to make your processes easier to adopt, etc., then I think it has to be responsible deployment. I think that's where it comes, like, input, output, what are the errors that can be created, what sort of disclaimers do you want to put out, who would be taking the liability for, say, like, erroneous output that's come about. But going forward, how I see is that a company which is not ready to move along with the technology will definitely be left behind in the race.
Right. Thank you, Kanika. We'll look into more details on some of these aspects later in the conversation. But Preeti, what was you think about this?
So thanks for asking this question, Arjun. So how many of us sitting here know the basic difference between AI and artificially generative intelligence? How many? Like, if you want to raise hands. Okay, so this is an indication of waking up. We are not just playing with algorithms, but we are also playing with human cognition interference, where we can actually manipulate artificial intelligence to give us the right answers or destructive answers. So there is an importance where we have to learn to be ready for what awaits. We don't just have ChatGPT, we have Bard, we have Midjourney, we just have to put a paragraph and the whole cover page of a book can be generated, the whole PPTs can be generated, as Gagan rightly said. So there is a lot which we need to be prepared for, and we are not. Because it's a lot of cogs in the wheel. It's data protection, it's IP, it's copyright. You never know what you're generating already exists. It belongs to somebody else. Maybe you're just copying some famous painting and just creating some elements to call it your copyright. So it's about the kind of corporate governance which companies need, and India is definitely not up to it. We are still very late in the journey of where America's, EMEA's and Asia stand. We are still thinking that this is just a leverage, whereas we cannot leverage it. It is an anchor. So you have to create something on your own, and then if you want to test it through AI, you can do it. But do your homework first. And I say this every time when I'm at a BW event, but go back, do your homework, and then use AI instead of using AI, messing it up, not doing your homework, and then be answerable to the stakeholders.
And I don't think we will have the right answers because accountability is what is important and we are not yet ready. So
Sure,
that's where I stand.
Now, Abhiraj, if I like to begin it with you, if you look at some of these risks, let's say in April this year, Samsung had some of its user, leaking out some proprietary information to the model, or some users actually giving certain prompts to Microsoft's AI bot and getting some confidential information. So, what are the risks related to proprietary information getting leaked, and how do you see it going about it?
One of the biggest risks that I feel is companies need to be really particular about people because ultimately AI in its current form, be it ChatGPT, Bard, or any of the variations thereof, they only make an individual's job easier. Coding is easier, making presentations is easier, writing a note is easier. But to put that into commercial use is still not permitted under most AI models. They are not for commercial use, they are for personal use only. So I think for a company, there are two perspectives. First, you need to make sure to the degree possible and practical and enforceable that your employees are aware that AI generated content is not suitable work output when talking about commercial work. Second, from that naturally follows if that education is there on employees. So for example, if employee's job is at Amazon to make content written content which goes along with any product, he needs to know that even when AI can generate that, the reason because Amazon cannot hire ChatGPT to sit and do it. It's her job to sit and do it. So if there is that sort of learning, then I'm sure as a consequence, it will follow that employees are aware that there are certain sensitive information that cannot go out. We will become more responsible in how they use it to maybe get ideas at a personal level, but have that boundary set between what they can and cannot use AI for. And if that knowledge is not already going out, that companies are complicit and they're creating an environment where somewhere down the line, there is going to be a problem because too much AI will not be used too extensively to be able to effectively step back from.
Right. Now, how do you see proprietary risk associated with this information being leaked as this usage picks up?
So I think there's definitely risk. People are using it specifically at the junior levels, right? They are not aware of the risk. There's not enough training. There's not enough discussion. There are not enough policies within the companies to address this issue. So that risk is there. And these generative AI which are out in the market, right? They're training their these systems on the data that you input, right? And there are human reviewers of all the data. And they pick up things which randomly and they get reviewed by human intervention as well. So definitely if there's something which is confidential and if you're putting it out, people I've read that people are using it for doing financial analysis on unaudited accounts and things like that, which is really dangerous, right? Again, it could, if you are a listed company and you use these tools, then you are open to insider trading investigations, other things. So there's large risk. There needs to be a discussion on this at the corporate level, and the policies needs to be formed on how it needs to be used.
Right. What I mentioned about some inaccurate results coming out in our opening answers. We were discussing this as outside as well, giving the example from my industry, where last time around this year, when the Reliance Capital insolvency case was happening, some of the intern used ChatGPT and changed the headline to Reliance Capital to Reliance Industries. Imagine if that was published, what would have been the legal consequences for that media house, or what the shareholding value of Reliance. So how do you see the risks associated with these inaccurate outcomes? If you could tell on that.
I think insofar as inaccuracy is concerned, the risk is really huge. Now, the risk can be spread across the industry, so whether it's a medical industry, whether it's a financial industry, or whether there's any industry which has a very sensitive personal information which is there out there, there is, like any other aspect, there always is a scope of that being misused, because you don't want that information to go out of hand. You want to make sure that you have sufficient safeguards and internal policies to, and you have the adequate technology to ensure that whatever is the confidential information, sufficient safeguards have been taken to protect. Because ultimately, from a company's perspective, it becomes a huge liability, when any of your personal information, confidential information is used. So, for example, in a software industry where I belong from, if any of the source code of a particular product is leaked, and imagine what when AI uses that source code to produce something else, A, it's an infringement of your IPR. B, it's a loss to the company, right? Because the company has invested a lot in producing a software where they could have acquired software through M&As or through multiple hundreds and thousands of, software coders. So imagine something like a source code getting out of control, and how that source code can, lead to so many additional products, which I think will put companies at a huge commercial risk. So I think there has to be a very, very strong requirement of ensuring full protection of this information.
Very well put up. Gaurav, Kanika, how do you see these two risks?
I think, as he just mentioned, that output could definitely be incorrect. Also, primarily because the inputs, the data that it was actually getting trained on was not correct in the first place. We talk about web scraping, right? There are multiple sources, and it's very difficult to identify one particular source from where, say, generative AI is picking it up from. So there are multiple sources, because of which the authenticity, the correct nature of the data input or the prompts that is actually going, it puts a question mark on that, and which definitely leads to say the output being questionable. And that is where the safeguards really need to come in. It's very important to balance the productive part of AI versus the risk that can ensue because of what you're trying to utilize in your day-to-day company processes, etc. So
right. Kriti, you were talking about this term hallucinations, which was a learning for me today. If you could tell more on this and how, yeah.
Got you. So hallucination is the technical term used under the AI language for all the fake theories and concepts which AI can create. So, for example, there has been a case where an associate created a petition where he quoted certain case laws, and the case laws were wrong because he used ChatGPT. Right. So the concept, as far as the AI is considered, is called hallucination. And in America, as we were speaking, they have an affidavit which they want the lawyers to sign, which undertakes that if they have used AI, they have done their fact check right. So the basic comes down to very important factors, which, as I said, there are cogs in the wheel. So do your fact check and use AI only once you are sure that you have done your homework, and go back to the book, because as lawyers, we have to stick to what law provides. We can always enhance as a business enabler. I've been an in-house counsel. We have many in-house counsels here. Our job is to ensure that the stakeholders know what the book provides. If we don't have the laws, use transgression laws, take ideas, take use cases to ensure what we are doing does not mess up what we are supposed to do. Right. So I hope I answered your question.
Definitely. Navinaj, if you look at the regulatory landscape around this, how do you see that evolving? Maybe in respect of the DPDB bill, or even some foreign regulations as well, if you would like to comment.
Thank you. I think, not immediately, I don't think there is an immediate need for it, but going forward, when AI is available for commercial use and it becomes imperative for all industries, especially critical industries, defense, nuclear, medical, so on and so forth, it becomes critical to start harvesting and using AI technology for your business processes. The law will need to provide some sort of intermediary protection in case of any liability arising from use of AI. What I mean is, so akin to Section 79 of the IT Act today,
companies will be able to take reasonable procedures and put in place reasonable processes to make sure that the output of the AI is correct. They will be able to get, I saw a director from PwC here, they will be able to get someone from the Big Four to come sit, review all processes and certify that the processes are right. But no one will be able to ever say that the result will be 100% right. So I think the liability, at least from a legal perspective, regulatory perspective, what I expect is sectoral regulators and the law in particular needs to cover two things. First, they need to cover cases where AI is a no-go. They need to clearly delineate when you can and cannot use AI. And second, they need to provide the minimum standards which and governance models which need to be followed while implementing AI, and subject to compliance with those, a company should be given a reasonable degree of protection from any liability arising out of the results. Without that, AI won't really germinate or take off in any meaningful way.
Right. Thank you. We just have 5 minutes left. Gagan, your quick take on this.
What I think is this generative AI, would any law firm or any legal department will put out work done by the first year, right? Directly out. So generative AI is a tool which you can use as the paralegal or like a first year lawyers to do basic research, generate forms of the letters, but will you send that out as a final output? Right. Never, right? So it's again, whether you're using human resource or AI resource, at the end, it's the responsibility of the organization that is using it to check it, and whatever output goes, it's their responsibility. I little bit differ from what Adhiraj is saying, that I think it should remain the responsibility. There should not be any protection because it's a tool at the end of it. If you are not sure of the tool, don't use it. It's your responsibility that you analyze the tool fully and use it properly, and whatever is the output, you own it.
Right.
That's what my
Thank you, Gagan. Gaurav?
I think we already started moving in the direction where you have recently seen some development at EU front, where the EU AI Act was passed, and I think now the EU is kind of first region of taking this in a more formal way. And we have also heard, kind of requirement in certain sectors to have a law to regulate AI. I think we need to really be careful, because we don't want to be over regulating, because again, it's a tool which is there to enhance the performance, and over regulations can at time, make this beautiful thing much very, very diluted. So there has to be a strike, we have to strike a right balance between the need to regulate and understand what may be the consequences of overregulation. But I think from an organizational perspective, a lot of internal organizations have already started using, having these policies on how to use ChatGPT, where all you can use ChatGPT, in the communications, etc. So I think we are kind of going at a stage that there will be combination of external legislation and internal policies.
Right. Right. Anika, how do you see the regulatory landscape evolving?
See, as you mentioned, over regulation, I think that is a bit of a question mark. But in my view, under regulation or over regulation, both of them are problematic. And in some way or the other, I feel that we will never reach a stage where we are fully able to regulate what AI attempts to achieve, because it'll always be ahead of law. It'll be more reactive. We'll see a lot of situations. The one that you mentioned about Samsung or or like, that specific lawyer who devised certain judgments which were fake in the first place. So I think, these instances will help us react to these situations and come up with some amount of framework that is required to put out the governance there. But I don't think we'll ever reach a stage where we will be able to fathom or anticipate every possible scenario that is capable through this technology. I don't think we'll reach there. But as he mentioned, I think it'll have to be a fair balance between, say, corporate governance. What is it that and it has to be curated as per a specific organization's risk appetite as well. So that, along with, I think, regulation, we should reach a stage where we are able to utilize it effectively.
Very well summed up, Malika. Kriti, we'll take 1 minute left.
Yeah. So I think just to summarize, it's very important to how you read the regulations, as I earlier said, and what kind of regulations. It's not just India. So just to give you a quick recap, initially it was the IT Act, then it was the SPDI rules, right? Then we have the new, which is the Data Privacy Act. And now we are hoping that IT Act will be scratched, and we have the Digital Technology Act, if I'm not wrong. So this is how disruptive we are getting, and not miss reading GDPR laws, because they are very important. They are the baseline. So the world is your oyster, and laws just common sense. Just make sure that you are aware of cyber security risk and the kind of right training which is required under you as an in-house lawyer, so that your stakeholders feel safe when they are going ahead and doing something. Don't be shy in asking the engineers, the product engineers, to give you the data index. There are times when you have to go through each and every slide to check the disclaimers are right, the policies are correct, be it the trading policy or the privacy policy. How do you break the privacy policy? Because the data needs to be mapped, right? You have to collect it, you have to use it, you have to transfer it, you have to store it with the processor. When do you erase it? How long do you store it? What is the regulations? Is it the PMLA which allows you to store it for 5 years, 8 years, 10 years with regulation? So go back to the book and do that, because our internal security is more important than waiting for law to come back with answers. So we have to have the answers with us when we are questioned.
Absolutely. I'll take one more minute, which will start with you only. Very quickly, in one line, what has been said about AI and taking on the jobs. But given the developments, do you see another layer of legal artificial intelligence specialists or associates coming up to help corporate legal teams? Everyone, just in one line.
Right. I'll give you one word: upgrade.
Upgrade. Anika?
I don't think so, but I do feel that the jobs would be shaky for a person who does not use AI. So it's like effectively humans will have to augment AI to a certain extent. Yeah.
Right.
I think there will be a generation of lawyers who would be kind of dealing with the AI matters going forward. Because AI again is self-generating, so I think there has to be somebody to check. I think there might also be some level of role played by lawyers in doing day-to-day periodic audits.
Right.
So to the extent, I think yes, I do see lawyers, exploring this new option as a career.
Thank you.
We have, lawyers will be already using contract express and all those kinds of tools, right, to lessen the load of the work. So it's good that we'll use it more efficiently to lessen the repetitive work, but again, it needs to be checked. But so it's good that it will lessen the repetitive work, but needs to be checked.
Very quickly, 2 lines. Firstly, यार किताब सब पढ़ते हैं, अच्छा वकील वो होगा जिसमें किताब से आगे भी कुछ आता है. Alright, so AI सबके पास होगा, अच्छा वकील वो होगा after the AI what we can bring to the table. And very quickly, the second point will also be limited by the quality of AI. It will not be like books today where pretty much all books are available to everyone. Right. I think a lot will come down to the quality of AI you use, whether you can afford the really good AI which can give you the best results. Right. Thank you, Adhigar. And thank you, panelists, for joining us this afternoon. I was apprehensive, that we may have some overlapping with the previous panel, but I'm sure all of our panelists have given great insights and different perspectives. Thank you so much. Thank you. Thank you.
Sure. Thank you. Ladies and gentlemen, let's roll up a very enthusiastic chair for such an interesting conversation. एक बार जोरदार तालियां बजाएं हमारे panelists के लिए. Thank you very much, everyone. Thank you. Super quickly, let's take 3 deep breaths in and release. ऑक्सीजन मिलेगा, थोड़ा सा ब्लड सर्कुलेशन बढ़ेगा, कंसंट्रेशन हेल्प करेगी थोड़ी सी. So requesting everyone to kindly stay in the best of their spirits as we move on to the next panel discussion. The topic at hand is request in IBC, declining recoveries around resolution timelines. Joining us on stage, our panelists, please give it up for Agarwal, partner SA. Let's welcome our panelists with a big round of applause, everybody. Thank you very much. Please give it up for such that our partner Lutra and Lutra Law Offices India. Please welcome Lamita's partner, Britain's Link Legal. Joining us virtually is Nitesh Padani, Managing Partner and Art Legal. Civil Amachar Mandal was supposedly was supposed to join us shortly momentarily, but due to some personal issues, he might or might not join us. And yes, we must keep a chair for the person here. And a big shout out to the session chair. Let's welcome the partner Lex Italian practices.
Discussion, I think, it's about IBC and the declining recoveries and the prolonged resolution. Personally, I feel, considering IBC had come in with an agenda of resolving, there were already existing laws by way of regulations, by way of SICA and other things which were looking at for resolving companies. But generally, the purpose of IBC was to consolidate. It started with a good trend, but you see, as a matter of fact, that it is a declining recovery because, like, you have to compare apple to apple. Because when IBC came with resolving companies by way of a CIP and all of that, which there were already regular RBI circulars, CDR guidelines, S4, SICA was there and all of that. So you have to compare IBC with already other existing laws. You feel there's a declining recovery there, and what is the reason behind it?
When the IBC was introduced, at that point, the first set of companies that went under the hammer in the IBC, they had very good asset value backing them. So the recoveries out of those asset values were much better than what they are today. So ideally, seeing it from a very practical point of view, analyzing the companies that are going into insolvency today, I think so there's a difference in the underlying asset value rather than anything else.
Okay.
So according to me, primarily the difference is not in the process for the regime. The difference is in the underlying asset value of the companies that are going into insolvency.
Okay, maybe your comments on it. Then I'll come to Mr. Bhutani.
Yeah. Thank you. So I think the bigger issue, while if you compare it with SICA and the DRTs of the world, I mean, IBC is going to be miles ahead. But IBC itself has faced so many issues. There are cracks, there are multiple amendments, there are conflicting decisions. Inherent flaws are there, which requires overall on a very aggressive basis. I personally feel that the legislature was very active in the first initial 3 years to make multiple amendments. But now suddenly it's not, perhaps no longer the flavor of the season. And therefore, I mean, the amendment which was proposed early January has not still come. Right. So there are issues there which needs to be ironed out. Until unless those issues are dealt on a proactive basis, either by the legislature or through the judiciary, I have my view is that it's not going to last forever.
Hi, sir. Am I audible to you, Mr. Bhutani?
Yes, I can hear you. Can you all hear me?
So your thoughts on the discussion on whether on the lacuna in IBC, whether there is any prolonged recovery, or sorry, a declining recovery because of some prolonged timelines?
Where the statistics reveal that there is a declining recovery. But I think I just wanted to pick up the cue from what the earlier speaker observed, which is that the legislative intervention in the first 2 to 3 years was far more pronounced than what we have seen in the last few years. It's one thing to say that it's a law which is evolving, and the evolution can happen either with judicial pronouncement or it can happen through a legislative amendment as well. So the latter doesn't seem to have kept pace. And the second problem, which was also picked up, was the inherent conflict in the decisions that are coming in the Supreme Court. Now, the ratios of the decisions may remain intact, but at least, given that each of these decisions were rendered in the facts of specific case, they seem to have created multiple rounds of dispute, and there are many of them. I would also feel that the functioning of the National Company Law Tribunal, insofar as the inadequacy of the members is concerned, is another reason. There is certainly need to appoint more members at the tribunal level for timely disposal. So if I just simply look at it, the situation, and the latest figures are available for September 2023, out of 7,000 odd cases that were admitted by the NCLT, currently almost 2,000 are pending resolution. And the average is 653 days where a corporate resolution process is involved, yielding to liquidation, which is taking to 472 days. So, if you compare that with the 300, plus days that were provided for the initial legislation that have been not met, I would not consider the average 70% haircut as a part of the settlement plan as disappointing. Of course, some of the outlier situations we've had, for example, Videocon is a case in point where the haircut was 96%. That is an issue. But I think as the law evolves, there is greater need for legislative intervention. And we can talk a little bit more about which are these decisions of the Supreme Court and NCLT and NCLAT, which are causing inherent contradiction.
Okay, thank you so much, sir. But I think so. Just to take your argument and sir's argument forward, to break it up into two questions, where you felt that IBC, the legislature was more active initially, and the NCLT bench strength is the problem. But now we've seen a lot of appointments that have come where now there is almost full bench strength by NCLT members. So that I'll come to the second question, but Namita, to the first question. So NCLT, I think IBS is playing a very active role in passing a lot of subordinate legislation by way of amending the regulations. Do you feel a lot of these queries are being tackled by way of a subordinate resolution, or you feel the main legislation requires a lot of amendment and tweaks to it?
Yeah. So for that, we'll first have to understand, like, I think we have touched upon some of the issues, but I think first of all, to answer your question squarely and briefly first, is that I do not think that only the subordinate legislations address the issue. First of all, and taking a step back on this, that if you look at how did IBC come up, your DRT question, the first one, the first is that there is a company, it's a business law. We have to understand that. It is not more than principles of natural justice, although it prevails here, but it is a business law. It emanates out of assets and out of liabilities for which you leverage your assets. So therefore, like the 2015 Law Review Committee said, time is of essence of IBC, because if you don't, like Nakul mentioned, that the underlying value goes, why does it go? Because, for example, let's take the Educom case, the IBIX case. It's a 2017 resolution plan. It did not get approved even in 2022. And 2023, when we filed the application to, withdraw it, it was obviously rejected. Now, in that case, although we are further, our firm is representing the committee, the RP, but I do understand the plight of the resolution applicant. His commercial wisdom and commercial assessment is of 2017 assets. So therefore, if the time extends from 2017 to 2022, 2023, I think any transactional lawyer, what they solve, will say that the value erodes. I mean, how can you put it?
So just to that, whether the answer to that is, I understand that issue that we are facing currently, where a lot of these plans which were deliberated were in 2017 or 18. I myself have seen a lot of plans getting approved in 2022, and between COVID and all, which are unprecedented. To that extent, the answer to that is whether revaluation is required to be done. Maybe, sir, we can start with you on that question.
Sorry, can you repeat that question?
So just to take, what Namita said, that a lot of these plans were there is a delay in getting the resolution plans approved, and there is a deterioration of assets because what the plans were deliberated in 2017 are now getting approved in 2021 because of by the NCLT not approved, because the bench cannot be there. For that matter, we feel the answer to that is the COC or the NC will be asking for revaluation of the assets so that correct determination of the plans can be reascertained at that point of time. Because that's because the answer to that is EMIX. You don't want the resolution applicants to back out.
Correct. I think before sir answers, one short point. I think the delay is not just, I mean, your question itself or a EBIX like case emanates out of the delay. Because of the delay, my valuation doesn't work today. But for that, I think we'll have to understand the causes of the delay. And the cause of the delay is because there are so many stakeholders involved, right? Even if it's a COC, it might be 15-member COC. Yeah. There are systemic issues also. Okay. For example, if it is we also have, like in one of my matters, we were arguing that it's a settlement going on, do not admit it. It's my, client. Having said that, that is also a reason for delay. If we looked at most of the delays out of, I think 50% of cases that are filed are dismissed. And so first question, even the IBBI standing committee said that quicker admission of an application should be one of the reasons, because it's not just one vanilla reason that is attributing to the delay. What the delay is doing is deterioration of the value. So perhaps understanding the reason, even 2015 law review said that we have to understand the reasons of the delay and then combat them. So whether the delay is on the court's account, or is it on the COC's account, or is it because so many of the bids, the timelines are not adhered. For example, in Go Air's matter, it's a separate sector altogether, but so many plans were given and the timelines kept extending. Now, why? Because that could be, that one reason could be that the law is not that strict on timelines, or the reason could be that it's an aviation sector, very few people understand it. So I think understanding the reasons which is causing the delay, which results in the deterioration of the value. Therefore, who's going to buy an asset that does not hold the value at it should be?
So, but one of the reasons to that extent could be because of the frivolous litigation filed by the promoters.
That could be one, but frivolous litigation is not just because that, for example, is in the case of a pyramid judgment where the ex-promoters came back on the avoidance case. But there could be others also in merits, because NCLT, I'm not litigating lawyer, but it's a summary, a court. So they don't go into the merits. So if you immediately make a merit case, it goes out of NCLT's purview. So I guess understanding all of this could.
Your thoughts, anything on that? Then I'll come to you.
I think there are multiple issues here. First, and I pick it up from what Mr. Bhutani said, and I have the exact same statistics. Am I audible? Yeah, okay, great. Yes. So IBBI, the data which Mr. Bhutani pointed out, there are 7058 applications which have been admitted. Okay, out of that, only 808 resulted in a resolution plan. 947 cases were withdrawn under 12A. And 2,249 corporate debtors were liquidated during this time. So first, the problem is the numbers. So which will of course take us back to the point you made that, and Mr. Bhutani also made. There are 63 is the bench 10, 57 is right now the NCLT members. Even if you take it to 63, I personally feel that's not sufficient to meet this large or 12,000 odd application number. Just do the maths around this 63. It's just too much. Plus, and they are not limited to what we need to also appreciate. They're not limited to IBC.
Exactly. My next question was that
Companies Act is also happening before them. They are looking into mergers. They are looking into operation mismanagement. They are looking into voluntary liquidation, striking off, and if you go to the NCLAT level, then CCI also comes into play. So, I mean, NCLT, in my view, is the most important tribunal in India right now. As she pointed out, that it's for business oriented solutions. For that, you really need to have a more proactive approach. Second point, on the conflicting decisions. Earlier, there have been decisions of Supreme Court itself that all what you need to see is debt in default. Okay, then comes a Vidarbha and says, no, you need to look at the financial health of the company. You need to look at the viability of the corporate debtor. I mean, if we were going to expand the scope, then obviously it's not going to. Another example, clean slate theory. There have been decisions which clearly says that once the successful resolution applicant takes over, then that's the end of all the litigation which has happened in past. But there have been decisions like RICO. There have been other decisions which have clearly gone rainbow papers. They've clearly stated that no, there is a possibility of some proceedings still continuing. So until unless we have a defined boundaries, it is not possible for us to find a right solution. There is, while of course there are lacunae in the act, we also need to see how they're implemented. And there has to be some kind of a uniformity in the approach either taken by the courts or by the tribunals.
But so just to take that argument further, because as we are mentioning that there has been a delay, and because of the delay of NCLT not even admitting because the timeline says 14 days. We've seen the cases getting admitted after 6 months or whatever it is. But the next step forward is where obviously you have a remedy to challenge that order. And now this has become a trend of every promoter going and challenging it. And every glad the first one to stay the COC formation. You feel anything that can be worked on, because there has been an amendment to that extent where you have to have a 12-day proposals before the COC constitution. You feel promoter is taking this like as a lacuna under the law for filing an appeal for a settlement, and NCLAT is kind of agreeing and staying in the COC because there is a moratorium, but there is also COC is not being constituted. So he's playing around with the time of that as and your argument of assets getting further deteriorated. You feel that's another document. How do you tackle that?
See, I would first want to address this question of numbers that we have. X number of petitions pending. The first fact that we need to understand here is that the aim of the IBC was not recovery. It's been held by a number of times by all the courts unanimously that the basic aim of the IBC is not recovery. The aim of the IBC is resolution, is the corporate resolution process. When we talk of the corporate resolution process, the process actually does not start from when an application is filed. It ideally starts from the time that an application is admitted. So in this view, if we just let go of the time period which goes into the admission stage and come to the CIRP stage. So we've come into the corporate insolvency resolution stage now. Here, the most important number is that today, as per the same report, roughly it's taking 650 days for a company to resolve, for a resolution plan to come in and be approved. This time period from 2017 to 2019 end used to be 330 days. The moot question actually is that why has the time period for resolution increased from 330 days in the initial 3 years of the IBC to 650 days today, and how can we take it back to a model 330, 340 day time period so that resolutions happen promptly and companies come out of the IBC in a better manner. Now, having formed this question in this manner, the basic underlying defect that we see practically before the tribunal as well as the NCLAT at a lot of times, and this is something that Namita also touched upon, is that a lot of time we fail to understand that under the IBC, the jurisdiction that the tribunal assumes is of a summary nature. It doesn't need detailed adjudication, detailed pleadings and hearings to go on for 6 months, 9 months, a year. So that is one of the places where time period can essentially be cut down. The second huge problem, although NCLTs today are at optimum bench strength, do we have the infrastructure to accommodate that optimum bench strength is a very important question, because I have a matter in a certain NCLT in North India, wherein due to the higher number of petitions pending, it was decided that in place of one bench, now we will have 2 benches constituted. So 2 benches can take care of all the pendency that is there in that particular NCLT. They didn't have the infrastructure in the sense they didn't have a second courtroom. So they have one courtroom, two benches. What happens eventually is one bench sits in the morning half, one bench sits in the afternoon half. How has this added to the efficiency which it was so programmed to add to? It has actually deteriorated the efficiency because initially, when one bench used to sit for 7 to 8 hours, they were being more productive. Now you have two benches sitting for 2 hours each. So there are certain issues in the entire ecosystem, which ecosystem will develop slowly and steadily as the law develops. When we talk about the ecosystem, the aspects of the ecosystem is that what is the jurisprudence ingrained in the bench? Do they function in a manner that they understand what summary disposal is? How much time is to be given to a certain party to argue? Especially in commercial matters, you just can't go on and on and on. There has to be an end. But here, so that is something that needs to be ingrained. This is for the bench. When we come to the ecosystem of the lawyers, do we have dedicated bars only for NCLTs? We do in a lot of NCLTs, like Delhi has quite a dedicated bar there. But in other NCLTs, in other parts of the country, do we have a dedicated bar? Or are adjournments being taken because counsels are not available because they are busy in the civil courts or in the high court or doing something else? After that, and this would address your next question also, the question that you'd asked was that in this ecosystem, the litigant is also a very important aspect. Has anyone made the litigant understand that if you've lost out at the NCLT stage and an admission order has been passed, then you should not be going in an appeal until unless valid grounds are made. Because, I mean, as a country, we for some reason favor litigation a lot. And that's why we do as well as we do as lawyers. We are very happy about the fact, but in the entire ecosystem, there is some, I mean, you need to tell people the right thing to be done at the right time. On the NCLAT issue, the NCLAT also does apply its mind while issuing notice and staying the constitution of the COC. And even in cases where the COC's constitution has been stayed, but the petition is admitted, so there's a moratorium operating basically to the advantage of the promoter. I think so the NCLAT makes quite an endeavor to hear those matter at the earliest as possible. Although for them also time is a constraint, they have heavy pendency. Their functioning is comparatively much prompter. The issue primarily lies somewhere between at post-admission, pre-resolution, NCLT level stage. A little closer.
But yes, I'm sure there are a lot of documents that you've seen, and I'm sure we are still in that process and the law is still evolving. We have another let's leave it as a closing statement. I want to understand what are the success stories. Maybe Mr. Bhutan, we can start with you on the success stories of IBC and what are the improvements requirement under IBC.
I think that we will do well if we carry out legislative amendments and issue administrative guidance as to how Supreme Court decisions have to be interpreted. Earlier, the speaker spoke about that IBC is a resolution process. I'll tell you where the problem lies. The problem lies in the preamble. Yes, it's a resolution process. But in the pursuit of resolution, you have to balance the interest of all the stakeholders, including alteration in the order of priority of payment to the government. I think this part of the preamble is what creates the conflict. Let me give you a couple of examples. Let's take the first landmark, Swiss Ribbons case. The Swiss Ribbons case clearly laid down the law, not just on the constitutional validity, but it clearly said that IBC is not violative of Article 14 just because it has difference created in a class of creditors. Well, that dispute is still being not settled because the judgment has not prevented any further challenges. Now, why do I say that? Take another case of the Rainbow Papers case, again, another Supreme Court judgment that was mentioned about, wherein a charge was created by the deal on the property of a dealer under the Gujarat value added tax. Now, we know very well that in the waterfall mechanism, the dues that are payable to the government rank lower. But what did the Supreme Court say to that? The Supreme Court said that there is a sales tax authority that has a security interest against the corporate debtors. And to that extent, these dues are as good as the dues of a secured creditor. Take another example. Again, Supreme Court decision in Monet Ispat case, where the court clearly took a view that the income tax dues cannot take precedence over dues that are due to secured creditors. But subsequently, it was argued again in another Supreme Court decision, which is the Sundaresh Bhatt decision, where they said that if a charge is created in favor of the customs authorities under the customs law, it would not elevate their position under Section 53 of the IBC. Subsequently, the Bombay High Court again made a different observation while interpreting the word first charge. So you see, there are many, many inherent contradictions that have occurred as a result of.
I think you have already done so I'll just close the statement. Sentences from Amit, and then we can just close it with the other panel members.
Licenses for Aircel was another revelation.
So time is up. Sorry to in between. We'll have to just give the other panel members also on success story. We tackle it and the scope of implement.
So success story where a plan has been approved and implemented. Unfortunately, I have none. That brings me to the lacuna, panel. For example, in one of my matters, our liquidation is done, sale is signed, but we haven't been able to distribute the proceeds because there's one litigation by one charge holder still going on. So it brings me back to entirely the lacuna of it. So the positives, or perhaps where the law, as we were all talking, I think everything that we spoke has to lead and translate to the law changing. All the committees, all the timelines specifically, those laws have to be translated fast so that, and it deters serious bidders. If I see that a frivolous plan is coming and the dates are getting extended, why must I even submit a plan? I think again, I come back to the first point that I made. We all have to appreciate that if this does not happen, businesses will start collapsing. Nobody will buy these assets. The whole idea was to sell a very good going concern asset for a lower price. That unfortunately is not happening, and it will have to translate into law.
Yeah, I'll be very quick. I think the biggest success story, as per me, is that NCLT, and that was an initiative taken by the president of NCLT to induct training to the judicial and technical members, because they were coming from different varied backgrounds. I was part of that induction program where I had given voluntary liquidation and striking off lectures to them. But it was a 10-day exercise. I felt that they were quite interested in understanding the law better. I feel that that 10 days, while it's a very good initiative, they must increase that time period. They must give them more opportunity to understand. They should act like in UK. They have a concept of observers. They can act as observers for a long duration. We should also be more careful in picking up those individuals as members, both judicial and technical, who have some commercial background. Correct. Again, these couple of things, if are done properly and we follow strict timelines and not just go by the discretionary mode of it, I personally feel that things can be improved.
So I think so from the success story point of view, I was very fortunate to be involved in a matter for the RP, that is, in which we had more than 100% recovery for all the creditors. So the admitted dues of the company were almost $1 billion, and what was paid back was the $1 billion plus interest to the secured creditors till the date of the plan approval. So that is one of the success stories. Just to end it all, see, no law is perfect. There can never be a perfect law. It's just that we have to all work in a manner to make the law perfect and to make the law sort of work its way around for people. That is what the intention is, and that is, I think, so how we should go about it. I think with this, we can close this panel discussion. Thank you so much for having us. Thank you so much.
Thank you.
Thank you very much, ladies and gentlemen. A quick round of applause for such an interesting conversation. But I please request you all to kindly come forward for the group picture. Can you please turn up the volume a little bit? I'm just throwing this question out in the room. Given that it is a Sunday afternoon, what would you rather be doing if you weren't here? Maybe out with some friends, a nice brunch, or maybe shopping with family, a late night movie. But each and every one person present here in this room decided to come here, decided to chart the discourse of future. Might I request absolute silence as we move on to the next panel, requesting everyone to kindly save the lovely conversations for the networking dinner. Talk about criminal law in the world, societal interplay and print, unprint. Joining us on stage is Mr. Bharat Chugh, founder of the Chambers of Bharat Chugh. Let's welcome the gentleman with a big round of applause. Give it up for Mimi Chandra, independent practitioner. Please welcome Pramod Dubey, Senior Advocate, Supreme Court of India. Joining us momentarily is Geeta Luthra, Senior Advocate, Supreme Court of India. Give it up for the Session Chair, Sridhar Kotarajan, AOR, Supreme Court of India.
Good evening, everyone. It's in fact a privilege to be being a moderator where Mr. Pramod Dubey, Ms. Geeta Luthra, Bharat, Naomi are on the panel. So I was just having a chat with friends outside, and I said, the eminent criminal lawyers like Ms. Geeta Luthra or Pramod Dubey are there. What do we speak? Suraj ko kya diya dikha hai? So it's better that probably I change my role and then get into a position where I can actually clear a lot of doubts that come to our minds. So the subject for today is very interesting. We are in the zone of change which is happening in the country in various spheres. And it has now also touched upon the very essential part of our rule of law regime, which is the criminal laws. Now, as all of us know, the Criminal Procedure Code was actually enacted in 1973, replacing the earlier version. But the Evidence Act and the Penal Code continue to be the colonial legacies of 1860, the Penal Code, and 1872, the Evidence Act. Now, the current government's attempt to bring in a bill which was presented and referred to a committee, and then now it has withdrawn and presented a revised bill in the parliament. Now, there's a lot of opinions which are shared across old wine, new bottle, and multiple things. Removal of sedition, but bringing it back in a more draconian way. So these discussions are happening across. So to share my thoughts on it, I mean, when we have actually framed our constitution in 1950, we have used the template of the 1935 Government of India Act. So which is a precedent probably which was wise to take at that time instead of actually jumping into a completely unknown territory by discarding the existing jurisprudence, case law, and understanding of crime, investigation, and evidence in our society. So this is a good transition where you actually are trying to retain the old and then bring in something new and enacting a fresh enactment which repeals the old code or the acts as the case may be. So as your opening comments, Pramod sir, what do you think about the new laws since they are going to come in?
First, thank you so much, Sindha, coordinating the entire discussion.
we have basically developed the habit of working in the old law. And the old law, we remember the fingertip scheme. This is the 302, that's a murder, and this is the 420, this is the. But the way that time is changing, the nature of the crime is changing, development in the society, development of the technology. So you need a change in the law. This is the demand of the day. No doubt this is the demand of the day. And you have to meet the global requirement. Because one side you are projecting to be a third superpower in the world. So you cannot confine yourself only to the economy. You have to be the third superpower with the help of all the organs of the government. You have to strengthen your law because you have to maintain, you have to develop the confidence in the investors, confidence in the company, the companies at the global level. And you need a stringent law. You have to balance the right of the people, right of the society. And this law is important and well thought. They should have not changed so many laws because you don't require. And even you find in the new law, they have incorporated the old law, but they have changed the section. That will create a problem. And the problem would be like, suppose you have the judgment, you have the special juries. Now you have to change the juries. You have to maintain the new library, maintain the new software. So many things is the extra burden, but you have to accept, you have to do all the exercise. And the way the technology is developing, I think it will not take much time. We'll adopt all these things, and we should basically start thinking in the change environment, and we should accept the change.
Thank you so much, sir. I mean, when you were mentioning about having the sections on fingertips, when I saw the time for this panel, I mean, it was quite telling. Charbis. So I think this effort was required to destigmatize some time slot on numericals. So if I come to Naomi, what is your take as an opening observation?
So to begin with, I think it's very encouraging that sir is saying that with time we'll catch up. Frankly, my first thought was this, that so I'm about 16 years, 17 years into the profession. My first thought was that just about when you're learning the rules, the game, the rules of learning the game, the rules seem to be changing, you know. The other thing is that we have joked a lot about this one frivolous aspect of this change, which is changing the numbering of the sections. Apart from the general, this whole hassle of, referring and re-referring, the other important aspect is that when you have this so-called overhaul, you have to make sure that it is not in conflict with the settled jurisprudence. Because a lot of the sections and the laws which we are referring to already have a very robust jurisprudence in terms of the judgments and the so it's not only about the sections that we can make a table and instead of 302 refer to whatever is the new section, but in terms of the application of law, for every section there are judgments and there are lines of judgments which follow. So if that then gets affected, because then are we expecting the courts to then sort of, or is it the purpose, what is the intention of these kind of changes, that, so that this robust jurisprudence that we already have, we are not able to refer to it any longer at some level? This is one preliminary thought that came to my mind.
Yeah, thank you, Naomi, for those views. But here, let me just say something. We used to have the 1922 Income Tax Act, which was replaced by the 1961 Income Tax Act. We had the 1956 Companies Act, which got replaced by the 2013 Act. And I actually face the problem you're talking about. When I actually take up an old brief to go to the Company Law Tribunal to argue, my notes are all in the old context. Now, if I have to relook, your memory invariably goes to certain sections, 397, 390, operation mismanagement, but you need to grope for the new sections. But I think that is going to be a matter of time that we get familiar.
Which is why I said that this is not one of the bigger problems. This is something which we'll face for somebody who graduates now. Whatever is the new act, they'll begin with that. The problem is that the jurisprudence, the law, the case law, which is already settled on these provisions, whether we'll still be able to rely. And if it is about, that yes, the law remains the same, then only the sections have changed. Then what is the point?
Sorry to interject at the cost of the time slot of Mr. Chug, and Mr. Chug will excuse me. Just Nami said that we should change the jurisprudence and other things. And the lighter side, I would like to say the problem seems to be the first generation lawyer. They are saying that we are the first generation lawyer. We have a lot of problems. We are not getting the opportunity. You could be the first generation lawyer, but you can open the path for the many generations.
Absolutely, sir.
So one person should be come forward. Second thing, the jurisprudence. We are far away from the old jurisprudence, Ms. Chandra, because you remember we had the Krishnaiyer jurisprudence, we have Justice Bhagwati jurisprudence with R.S. Pathak, and we have Justice Tattu jurisprudence, Tattuji, Justice Dalvir Bhandari's jurisprudence, anticipatory, and no one is going to care that juris. Now, every day you will find the new juris. There is a lot of changes in the nature of the crime and nature of the thought and the development of the society. So we are far away from that old jurisprudence.
Yeah,
especially in the criminal side.
Right. Well, Mr. Bharat, if I can ask you for your thoughts, you've been on both sides, on the bench and then the bar. So how do you see it? Can you give a perspective from both sides?
See, that I can't really help but think like that. That's a part of the training, the part of how I've, grown up in law. But on the issue of criminal reforms, I see these reforms in three buckets: as the good, bad, and the ugly for me. Now, there are certain things which are, of course, good. And there are certain things which are possibly not in line with the jurisprudence laid down in the last few decades. But before I come to these 2-3, and very quickly in 2-3 minutes, two prefatory points. One is that much of what we've done really, so somebody was kind enough to do a run on the entire new criminal laws and then compare with the earlier ones.
Right.
So it's about 80% of it is in one shape or the other there in the new laws. So if you're restructuring the laws or changing the positioning of the sections, you're doing it at a cost, which is an administrative cost of a judge, of a lawyer, of a law enforcer, of an investigator having to remember the new sections.
Right.
So that administrative cost, which is humongous, by the way, in terms of performers, in terms of schedules, if you're making a very radical departure from the earlier law, where you're bringing something new, then of course that administrative cost may be justified. But if much of the law or much of the change is essentially symbolic in nature, where the essential argument appears to be we'll decolonize the law, but the new law that appears may be more colonial in a lot of ways than the earlier colonial law, which is something that I'll come to a little later. So these are the 2 points which are important to keep in mind. My personal opinion is that restructuring or putting one provision in 3 different provisions, all those cosmetic changes are not the ones that really matter. There's a huge administrative cost attached to it, and that possibly has not been kept in mind with the greatest respect when this was being done. Secondly, the point of jurisprudence as well. Some of the provisions that I look at, it seems that whoever was designing that maybe has not spent enough time doing criminal trials or has not really kept in mind the jurisprudence as it stands. I'll give you one example, which is a very striking example, and it would align with, and Pramod sir can come in if I'm wrong here. There is one provision in the new law that says section 200 of the CRPC, which talks about taking cognizance of an offense.
Right.
You file a complaint case, the judge applies judicial mind, takes cognizance. Now the provision unfortunately says, I know my first year law student interns can point that out, that now before taking cognizance, you would have to hear the person against whom you are taking cognizance.
Okay.
So the judge has not applied judicial mind, then not even summoned the accused persons, but at the stage of cognizance, you'll have to hear the person.
Right. Welcome, Geeta ma'am.
You'll have to, at that point. So at the stage of taking cognizance, you'll have to hear the person, the prospective accused at that point. So some of the big problems. Now another big issue that I see on the very face of it in these laws is an attempt to increase the period of police custody. Now, if you look at the amendments to the 167, now it's obviously under a different section. Now the new section says that for the entire 60-90 day period, you can take a 15-day police custody spread over that 60 or 90 days as the case may be. Whereas the law as it stood earlier was that only in the first 15 days you can take police custody or judicial custody, but there can be no police custody after the first 15 days.
Right.
So that permitted defense counsels such as us to go and argue in the court that the first 15 days are over. Now there cannot be a police custody, there cannot be custodial interrogation. Now that's itself a ground for bail. Now with this amendment, your police custody can be at the 75th day too.
True.
And the chances of somebody getting to secure bail at that point would become difficult. Now, it's not all dark or, I'm not a prophet of doom that way. There are certain things which are also good. I'll just point out one or two for it to be a balanced opinion. For instance, now victim gets recognized. So victim gets recognized as an important stakeholder, gets a copy of the charge sheet, gets an opportunity. Now that's important. Another important addition now is that the principle of preliminary inquiry has been codified. We were working with judge-made law in Lalita Kumari that, before registering a criminal case, sometimes you can do a preliminary inquiry to find out if this case is worth it or not, or whether it is so patently meritless that you don't have to do a preliminary inquiry. Now the law says that you can do a preliminary inquiry. Now, but again, the devil is in the details then again, because the law says you can do a preliminary inquiry only in cases which are punishable with less than 7 years. Now you've introduced something good, but you've not gone far enough with it. So only in offences punishable with less than 7, you can do a preliminary inquiry with a view to see whether the case is meritless or not. Now the problem is 420 cases, for example, and this is where I'll stop. 420 cases are the ones where the criminal law gets to be abused the most.
True.
Patently civil transactions, commercial relationships having gone south are given the criminal color with a view to, settle scores or get a good settlement. That way, the local police station becomes the best court to enforce a specific performance of a contract.
True.
Unfortunately, that's the ground reality. And those are the cases which need a preliminary inquiry the most. And 420, and you can correct me if I'm wrong, 420 is punishable with up to 7, which may include 7. Now you have a preliminary inquiry which extends to only offenses which are less than 7. So 7 isn't included there. You haven't said up to 7.
Right.
Now, all of these important cases where a preliminary inquiry was necessitated may be deprived of this benefit. To cut the long story short, I think there was a greater rigorous intellectual engagement needed with these laws before introducing them. And I hope it happens before they are passed. And so that we can, use all these years of laid down jurisprudence and wisdom, as Naomi said, and then lay down something that lasts for the years to come.
Let's hope that the old jurisprudence is actually not brushed under the carpet, because ultimately our constitutional ethos and values are enshrined in the judgments of our constitutional courts.
But
so they continue.
Our Supreme Court is increase the number of the custody. If you see the Balaji Santhil judgment, the Supreme Court interpretation, the maximum period is 19 days. So the person could be in custody for 90 days.
True.
In the police custody, the Supreme Court is encouraging and giving this kind of the jurisprudence. So that's the law of the land. The Supreme Court should be because they are the protector of the fundamental right of the citizens.
Sir, if I may now ask Geeta ma'am, what are your views on the changes brought on the criminal laws, and what is the brighter side, and probably what is the word of caution for people on the bench and the bar as we look forward with your experience?
So all that one can hope is that in the various standing committees and committees, perhaps better sense will prevail. That's all I can say. So I think it's a dressing up. You give a name which, to my mind, ultimately should be an all India name. So it's best to be in English. You can have a Hindi translation of that name. But ultimately, these are legislations which are our Bibles for lawyers. For a criminal lawyer, this is a Bible, all these acts. Evidence Act is a Bible for the civil as well as the criminal lawyer. So you are saying, okay, your Bible remains the same. We're just taking it left, right, center, changing it upside down. So that's a dressing up. Okay. But while you are dressing in, we are sneaking in provisions which are extremely police friendly. So this is not what the system was meant to be. And I thought that so there have been some nice dressings because they have taken into account several judgments of the courts, which have been progressive, zero FIRs, this, that, the other. So all this is already established. Good that it's been brought into legislation. I'm not against that. And I'm happy for that. But in the guise of all this, the police powers increase. We all agree corruption is horrible. We all agree terrorist crime is horrible, but we can't have principles of double jeopardy. You'll again be going, there's a specialist act, there's a general act. Then you'll say, not only is there a specialist and general act, so specialist act will prevail, but the general act has come after that. So now what do we do?
True. I mean, that's going to be again a lawyer's paradise, I would say. Yes.
Of UAPA, Makoka. They have been added. These are additions. These are not amendments. The other thing, which I've always stated in various panels related to criminal law, but different topics, is that whatever laws we have, at the end of the day, how they are being executed and implemented.
True.
That's the most important aspect.
So the enforcement by the ground
of law,
police station.
Yes. So are we working on enforcement and implementations with the same vigor?
So probably as a part of this package, it would have been ideal that they brought in police reforms. That's probably what I think all of us could agree on. Because without police reforms, any substantive change is actually incomplete. Because with the need of police reforms being stated and restated by Supreme Court in several cases over decades, that aspect has not been probably factored in, is what I feel. What do you think, ma'am?
I basically think first you bring in police reforms.
And the other should follow.
On a hold. Keep this on a hold. This needs, I remember actually, I think Professor Ranbir Singh of NLU was heading that committee, and I'd also been asked to speak, as must have been several other people. Now, being in an all India panel and just speaking for a few minutes or hours over something which somebody has taken years to draft and meticulously is not our way, is not the way that we can go.
True.
Our legislation has to be, and that's what I think Justice B.N. Shri Krishna said, look, your language in IPC, CRPC is terse, is precise, it's coming to the point. You may agree with aspects, you may disagree with aspects, but let's do it in a very, very systematic manner. So you take the IPC as it stands, even if you want to change it. Just see what are the changes you want and have an object and reason why you are changing that. So that it's transparent and it's clear why. There may be things which, as you said, that there are a couple of good things. I mean, there may not be couple, there may be one good thing.
Probably, I mean, as the change is the only constant, as we all know. So probably, Pramod sir, now going forward, I mean, what do you see as a challenge for a citizen of the country, with lawyers and judges going to consume more time to even get to know which provision is where? I think that's going to cost us on the court time, which is very precious, and we're already facing backlogs.
I had already mentioned at the inception, it is going to create a lot of problem to all the stakeholders, because you have to adopt the new things, and even there is no constructive debate on all these things. It was drafted, you have placed one, you placed before the parliament, subsequently you said, no, we are withdrawing, we are placing the new one. So see the kind of the deliberation which has been done. So what was the hurry to put the earlier one, then withdrawing, then putting the new one? And when there is no discussion, we all are practicing in the criminal side, but there is no discussion from the lawyer who are practicing in the criminal side.
So
there are only some academician who only have developed read the juries and theoretical things. They are teaching and they are sitting in the room, they are drafting all the things. So right, the Bhatt has rightly pointed, given the example 6,400. if earlier jurist was that without the issuance of the summons and the service of the summons of the prospective accused does not have the right to address the court and come to the court. Now you are hearing the accused, so you are hearing the defense. After hearing the defense and you are rejecting the defense, then you are taking the conclusion. What is the purpose of the going to the rigors of the trial?
Absolutely.
You have already adjudicated the matter, the defense of the person. So what is the difference between the magistrate and preliminary inquiry, the police officer who is conducting the preliminary inquiry?
Probably as a civil lawyer, I would look at it as an introducing Order 711 into CRPC. So what is the
rejection of the plaintiff?
Absolutely. I mean, it appears to be so. Yes, ma'am.
So my thought on this is each of the sections, I mean, say adultery, they've removed adultery. I'm very happy. But what is being mooted is that the standing committee is going to make it gender neutral and bring it in.
Yeah.
Now, similarly, 377. There may have been some good in it, apart from the consensual acts.
Right.
So we have, everything has to be looked, each section has to be debated at length. We can't have a round table where we say what laws according to you are good, bad or indifferent. And I say sedition should be abolished. And he says adultery should not be allowed to come in. People are talking that they'll bring it in again. No, it shouldn't be allowed. Somebody says 377 has to be cut down. No, that's not a conversation. That's not a intellectual debate where lawyers, judges, stakeholders, everyone participates. And now this victim issue, although I think I'm in this horrible minority where I say that victims can have a voice. And this is what Lord Denning said. He said, you give a person a voice when you see that you have a very powerful lobby that is trampling on their rights. And he said it in that thalidomide cases by the Times Group was reporting in favor of that pharma company. And he said this, and I think that's so well said. He said, in case like this, I would say a person has a right to file appeals. But see, somewhere, these are offenses against the state. And if you have somebody stand there and say, and be vituperative all the time, then you are not thinking, is this really an offense against the state? Or are two private individuals fighting? So I have a lot of sympathy for the victim, but I think somewhere we have to take it with a pinch of salt, remembering that these are offenses against the state, and therefore there is a limited extent where there is manifest wrongdoing being done, or you find the public prosecutor is not really presenting the case properly. You say, of course, let the private complainant speak up.
So
I have some strong views on it.
I know.
Pramod is smiling, so I don't know why.
Why I'm smiling, because one thing is very painful and troubling me. There is a judgment of the Supreme Court as taking down the provision unconstitutional. The legislature, they are trying their best to bring the same act, same word.
So,
and they are so adamant. Why you are so adamant? Why you are not deliberating?
Sir, I think like the parliament and the standing committees, we too are running short on time as to decide or agree or disagree or even debate the details of the complexities that have been brought about. So I guess it was very thought-provoking panel that we had today, and then to discuss the concerns coming from the members of the bar as to what is the way forward, and then whether these kind of reforms should have been rushed through without probably making the stakeholders, which is the members of the bar, actively engaged in the discussion of various changes, is a question probably for the parliamentarians to contemplate and reflect on. Thank you very much for being on the panel. Thank you.
Big round of applause for our panel. Ladies and gentlemen, could I please request everyone to kindly come forward for a group picture? Like to quickly address the elephant in the room. Shortly, after two panels, we shall begin with the much anticipated segment, that is the award ceremony. So now our next panel will talk about changing landscape of mergers and acquisitions in India. Joining me as I welcome Diksha Machida, partner to Rogue and Messenger. Ladies and gentlemen, it is a destiny to clap on offer a round of applause as a panelist joins us. Please give it up for civil and Let's welcome Seema Jindal, partner and co-founder, Legal Counsel Law Office. One round of applause for partners. Session Chairperson, Raj Frontier Legal.
Hi.
It's on.
It's on? Okay. Okay. Yeah. Hi. Good afternoon, everyone. So, as you know, the topic is changing landscape of mergers and acquisitions in India. Mergers and acquisition, I mean, I don't need to be the first one to say this or stating the obvious, there are a whole bunch of complexities coming right from structuring of the transaction itself, at the term sheet stage, during the transaction, diligence related issues. And of course, there could be a whole lot of issues which arise even at a post-closing stage. How well are you going to integrate the acquisition itself? What are you going to do with it? How is the future growth coming along? Are there any other kind of issues? So there's going to be like a whole bunch of issues which one ends up dealing with during the life cycle of an M&A transaction. What we will try to do during the course of this particular session is to cherry pick like a few issues which have come about of late and which, a whole bunch of M&A lawyers are dealing with, some issues which they're even, grappling with. So which is why, we have this particular panel who at least, based on my interactions, I do believe that they have a fair degree of, deep expertise to deal with these kind of issues. So anyway, so I'll just get started on the very first question. And I think this is picking up from one of the previous sessions which had come about to do with ESG. And, ESG has become like a big mantra and, there are like a whole bunch of pros and cons revolving around the use of ESG, the scope of ESG as so much. And, there are a lot of people who even don't believe in ESG, from a business perspective, Professor Ashwath Damodaran says that, ESG may not be a very sound metric, so on and so forth. But I think one thing all of us agree upon is that, ESG is here to stay. And, and it has become a very, very essential factor of any kind of fundraising as well as, any kind of, M&A transaction. So let me just pose the first question to, Seema here as to, what are the critical issues which you are looking at it specifically from an ESG perspective? These days, what happens in the course of a diligence is that, there is like an ESG specific diligence which happens. And let's say if there's an adverse finding, how does one deal with it? Or, or what do you think are, a critical factors which one would look at while evaluating a particular transaction from an ESG perspective?
Good evening, everyone. So basically, in the M&A space, the determination of ESG, which basically means whether the company is having good practices, ethical practices with respect to environmental protection and social and issues related to corporate governance. Now, the determination of ESG is not a trend anymore. It's not something which has come up in the recent past. It is a necessity, and I'll give you the reasons why it is a necessity. Because if you are a ESG, and there are multiple reasons for that, and one of the biggest reasons is in the M&A space. When you're looking at the M&A space, we're largely looking at companies acquiring you. Now, for you to become a very attractive investee company to be acquired, ESG compliance is a must. Because if you're an ESG compliant company, your valuations will be much better. Your readiness to deal with regulatory issues, your readiness to deal with any kind of employment issues related to environmental issues will be very fast. The second issue is when we as M&A lawyers look at the due diligence report, it's been there in the for a very long time, but now it's critical that the due diligence list has multiple factors related to and dedicated to ESG. And why is so? The reasons are multiple fold. But the first is the exposure, the regulatory exposure that the company which is not ESG is compliant and you're trying to acquire them, your regulatory checkpoints will be very high. Such a company is a financial risk. So question number one for an investor is this entity an investor risk? And how is this a risk from a financial point of view? So if you're poorly managed, corporate compliances are badly managed, your employment issues are not well addressed, your employee relationships are poor, the question of your risk as a financial risk is very high. The second aspect is the reputational risk. Will a scandal come out? Whether a huge environmental risk potential will come out, and whether it will impact your customers' confidence, whether it will impact your future investor confidence, and therefore diminish your shareholders' value. So therefore, the reputational risk is very high. The other is what most people forget is that the post-merger or acquisition integration. So if you don't have your policies aligned with ESG, the investee companies' policies are not strategically and culturally aligned with the acquirer company, what happens is that becomes one of the biggest reasons for the M&A disaster. So 3/4 of the M&As fail in the world. And one of the biggest reasons is post-integration issues related to attrition of the employees because their mapping of the ESG policies haven't been done. So that's a big risk. Your whole M&A can fall through. The other risk is, are you potentially a company where attrition is going to happen and talent will be attracted? So ESG is a big reason. What are your work policies? What are your policies related to employment and issues where the talent gets attracted? So therefore, toxic ESG company is a total no-no when it comes to large transaction. And even when I'm seeing smaller transaction, companies which are not compliant with the ESG regulations, whether it is having a negative impact on environment, having a negative impact on the well-being of the employees, they are not looked at. Now, what happens when we are doing an M&A? Basically, if you're so once we have had the due diligence, we've identified a whole lot of ESG issues. Reps and warranties, your list of reps and warranties, and you're all lawyers here, becomes very long. And it is then followed by a large disclosure list. Now, reps and warranties related to ESG non-compliances then is followed with a lot of indemnities. And then the seller and the biggest potential for negotiation in any commercial M&A is reps and warranties and indemnity. And all of the lawyers are M&A lawyers, they will agree with me that indemnification gets kicked in less than 10% of the cases, but 90% of a transaction is spent on indemnification and reps and warranty negotiations. And the lastly is that when you have a lot of ESG risk, what happens is that if you're a promoter who's going to continue with the company, you also have deferred payment obligations. So that means you are selling your entire company today, but you will not get your payment right now because you will be having earnouts as a potentially earnout system of payment, or you will have your money in this part of the consideration in the escrow because you have a whole lot of ESG exposure. So ESG is a huge thing and needs to be looked at.
Absolutely. Couldn't agree more. Just one follow-up question, and this is open to the panel as such. See, I always believe that, when you're doing an ESG diligence, you can identify issues from the E perspective, the S perspective. But how do you pinpoint and address issues from a governance perspective? Because governance issue is not just a diligence issue, it also becomes an ongoing issue. So, as lawyers, how do you evaluate the promoters? I know that it's not just, a business decision. Tomorrow, if there are any issues against the promoters, it's going to blow back on the entirety of the company, entirety of the transaction as well. So, are there any kind of checks and balances which you're going to put specifically against the promoters, especially where the promoters continue to be part of the system and, they've not had a full exit? I mean, how is that, you try to, address the governance issues? Because, we are in a system where, even in M&A transaction where promoters continue to stay on the boards of the company, they continue to have a fair amount of say with respect to the operations and management of the company itself. So how does one protect against themselves against this kind of a governance risk?
So, is this question to me or?
Anyone.
Okay. Briefly, when we do the due diligence, the governance issue gets identified very quickly. Something it starts as basically as, do you have the minute book ready? नहीं बनाएंगे जाके अभी. So, that is the first checkpoint, that your attention to detailing of even the basic of the company law compliances are zero. So governance starts at starting to maintain your books, registers, minute books, and then it is followed by what is the attitude. See, the governance comes with the attitude of the promoters, and we have massively successful promoter-driven companies in India. And those are the companies where we see a lot of fraud and a lot of non-governance issues. And that is where the customers right now are putting a lot of pressure that we want to deal with the company which is reputationally good. And how does that reputation comes? Tata is a case in point, because when you deal with Tata, you will be dealing with an ethical company. So when we are doing the due diligence, you get a sense of what is going to succeed after, once we have taken the control, and if the promoter is going to continue. And that is where the checks and balances are put in place.
Anything to add?
Yeah, no, I think I completely agree with Seema here. Particularly, there's also a new trend, Gautam, which is that if you look at a lot of listed companies which have just recently done IPO or done IPO in the last 2 years, the so-called technology platforms which are doing very well for themselves, the actual promoters and founders holding is abysmally low.
Right.
And this trend is going to continue, that by the time a company will get listed, firstly, they will not be an identified promoter group. They will be a professionally managed company with a particular founder. And very similar to what we see with Facebook, where Mark Zuckerberg's holding or Elon Musk holding in Tesla is very minuscule, they still enjoy a higher degree of control. Typically, even in companies such as those, because there's going to be such a huge institutional and public shareholder pool, it is extremely critical to keep viewing and keep scrutinizing any decisions taken by the management from the point of view of company's perspective. And increasingly, we are seeing two trends emerge. One is that because if you look at these big listed companies as well, the public shareholder pool is significant. Mutual funds, FIIs own very large chunks of shares. Promoter holding is dwindling down. And like I said, even in these professionally managed so-called tech companies, founders' ownership is no more than 5%, 7%. So proxy advisory firms are becoming very critical to carry the voice of the public shareholders. Inevitably, any related party transaction, any questionable transaction, you're seeing a lot of noise being created by the proxy advisory firms, which is the right thing to happen. SEBI also, many would argue from a listed company compliance point of view, have gone overboard. But I think it was necessary. It was the need of the hour. They have really tightened the regime on LODR regulations insofar as compliances by listed companies on related party transactions, the kind of disclosure that they expect. So actually, SEBI has done a very laudable task of looking at interest of that one equity shareholder holding 5 shares and looking at from the point of view of that shareholder as to how interest of the company can be protected from any errant behavior by the promoters.
Right.
So that philosophical change has already happened. We are beginning to see a lot of proxy advisory firms become champion for the institutional and the public shareholders, questioning all the wrong transactions. Of course, our investigative agencies are also overzealous and overactive at the moment, which also means that transactions of this nature, which are errant, will get scrutinized, will get questioned. And then the third piece, which I must confess, it's a mystery to me why it has not taken off, is class action. I think, as many of you are aware, the Companies Act of 2014 brought in this whole framework of class action along the lines of what the US law on the subject matter was. However, they notified only NCLT Principal Bench Delhi as the relevant body to entertain class action proceedings. But that hasn't taken off as yet. And I'm quite shocked. In fact, there's so many times when, public shareholders or institutional shareholders are approaching us where there are issues of misgovernance by the promoters. They're all looking at filing complaints with SEBI. They're looking at oppression, mismanagement. They're looking at how any additional proceedings can be undertaken, criminal proceedings with the SFIO or with the EOW. But class action still hasn't taken off. I think in my view, in the coming year or so, 2024, you're going to see a lot more class action. You're going to see promoters who are errant, who have caused loss to the company, having to start to bear the burden. I think somewhere the fact that NCLT was highly overburdened with all the IBC cases has also contributed to that stress. But I think that will also happen as we move along. And the last point around this is that especially in the startup space and companies which are in Series D, Series E, Series F, the venture capital investors and the private equity investors will never admit to it. But the reality is where we are representing them, inevitably, while there's a legal and a financial diligence taking place, they will also do a background and a forensic check on the founder. Right. So that's also started happening. They will share those reports on a confidential basis with their law firms to make sure that they also understand. But I think a behavioral perspective, a background check. We saw what happened in one of the large e-commerce companies which got taken over by a US giant. One of the founders ultimately had to leave on grounds of sexual harassment. We saw one or two founders of prominent tech platforms being thrown out of those companies. They're still litigating. So errant behavior of founders will happen. It is a reality. But I think it's important to have systemic checks and balances. And we're moving there slowly but surely.
That's great. And I think this directly morphs into my next question of shareholder activism, because, historically, at least shareholder activism has been generally very poor in India, 15 years back, 20 years back and all that, with all due respect, promoters could run riot, right? Because, the mutual funds would not take part, the financial institutions would not take part, a big gun like LIC would not take part. They would just go with the flow, abstain, or, go along with the promoters and things like that. But these days, because of, these proxy advisory firms and all that, shareholder activism is also on the rise. And I think this also serves as some kind of, ears to the ground exercise to people who are involved in the M&A transaction as to how shareholders are reacting. So, especially so in the case of listed companies.
That's absolutely right, Gautam. And just a very quick observation. It all stems from the actual profile of shareholders of any listed company. You look at the last 15 years, and if you were to do a comparison, you will realize that promoter holding, very crudely put, Lala holding in listed companies has significantly gone down. And all the run-up that you're seeing in the stock market is being contributed by a number of mutual funds buying. I mean, the reality is, a slight segue, FPIs and foreign institutional investors have been net sellers over the last 3 years. But the Indian markets are continuing to go up. Why? Because a lot of public money is going back into the markets through the mutual funds. And therefore, they are going to become an important voice of reason. I was also involved in the specific whistleblower report that was put together in Fortis Healthcare when the erstwhile promoters of Fortis Healthcare allegedly siphoned away money from the company. And I authored that report. And I can share with you that ultimately, when we have looked back and seen some of the conduct, what we realize is that listed companies often, and the senior management, the entire establishment, they tend to believe that if there is a promoter, he owns 70%, he's the big boss, right, and I have to follow every instruction to the T. I think look at what happened with CG Power, look at what happened with Fortis Healthcare, look at what happened with Religare, look at what happened with Unitech. I think it's an important lesson for generally the professionals and the senior management that your stakeholder, the real stakeholder, is the shareholder. You have to make sure every decision is viewed from the prism and parameter of whether it's the right decision for shareholder interest. And just because your CEO or your MD or your promoter is telling you cannot become the gospel truth. And people have learned the hard way. A lot of them have had to face SFIU investigations, pay significant penalties as part of SEBI proceedings on account of FUTP or other sort of law violations. So I think managements are also realizing that promoter is not the end all, and you do not have to hear him for every word, and you'll have to do what is the right thing for the company. So that philosophical change is happening. But of course, there will be a lot of collateral damage along the way. Some of the names that I just took. But one hopes that things will get better quickly.
Yeah, no, I get that. And I think especially with respect to mutual funds, especially, I think they're finally playing catch up when it comes to shareholder activism, and considering, how consistently they have upped their stake in Indian companies, they have realized that, they shouldn't be passive shareholders, but should actually vote for resolutions or against resolutions, as the case may be. And one certainly hopes that, this trend will continue.
So I have some thoughts on what has just been discussed. I think shareholder activism is definitely rising, but it is also linked to the governance system that we have in place. And I think my personal belief is that we are a maturing regulatory system. With every passing year, we are reaching new heights. I wouldn't say that, we are on a lopsided, regulatory mechanism. Every year, based on the experiences of the regulator, there are changes that are being brought in, and that are being brought in for the protection of the public shareholders in case of a listed company, for example. As everybody very well knows, there's a concept of independent director, and in listed companies, they're the majority in certain situations. There are committees where the independent directors are a majority. So the checks and balances are very much there in place simply by virtue of a company being a listed company. So, you can expect that there is some level of diligence by the company and the management to ensure that wrongdoings are in check. On top of that, there are also some additional, protection in the form of majority of minority approval in case of certain M&A transactions. So it's not that the promoters can take, the public shareholders or the value of the company for a ride. And that's where, in such cases, like was mentioned, proxy advisory firms play a very critical role. When it comes to majority of minority approval of public shareholders, where the promoters cannot vote, it is the external influence of these proxy advisory firms which play a very crucial role. Now, apart from the listed companies, there is also an unlisted space where, I would come back to the original question of governance. Unlisted space is where the governance system is maturing now. With investors coming in, they are putting in place the restrictions, the policies, the verifiable mechanism to ensure that no wrongdoing is happening. In many instances where the investors have not been satisfied, they have ordered their own audit on certain unlisted companies. Just to be sure that the audit reports or the financial statements that are being prepared, whether they are originally correct or not, or there's a gross deviation or not. We have seen instances where the investors have also gone for verification of, the assets of the company, that what the company is claiming is there in its financial statements is actually there on the ground or not. So a lot of activism of investors is also happening, and gradually it is increasing. And a very remarkable development is the ESG process. Like Seema mentioned initially, now the shareholders agreement for many private equity firms, they will not sign off on it unless the ESG clauses or ESG policies are ingrained into the shareholders agreement. And there is a proper reporting mechanism that is established. Now, this is gaining traction. And I think over a period of time, at least we expect that it will increase in the Indian legal system. And it will also ensure, it's also good for the public shareholders that subsequently, if any company goes on for listing, it can, at least the public shareholders can have a bit of surety that because of the ESG policies in the company, which have been enforced by the private equity investor over a period of time, the default would be very, very minimal or next to zero.
Got it.
So that's a very important development that has happened over the last decade or so.
Absolutely. And one hopes that the trend continues. But let me just move on to Diksha as well, and this is also something which arises from, protection of the shareholders itself. So what we are trying to look at is the role and the impact of competition law, in the M&A realm, because, you would have signed up the documents, you would have agreed on the documents, but you still need to get a regulatory approval to go ahead with that. That is one. And the other thing, I was just going through the latest proposed draft amendments to the competition norms itself, this whole concept of deal transaction value, which, until before was not there within the scope of the Competition Act. Do you think that, these are things which are going to impact the M&A process? And if so, is it going to only stretch the timeline, or is it going to make the M&A process so much more complex?
So I think competition, much like other regulators, is a part of that missing jigsaw puzzle. You need it for completion. Thankfully, in India, we've seen a very facilitative environment. We are not in a place where, for instance, in US, if you don't get the approval, deals are actually cancelled, and not getting the approval is fairly common. It's not that unusual. It's also fairly common now in Europe. In India, we've till date not had a single denial of approval by the Commission. So we are in a fairly facilitative space, but it's not a space free of its risks. I'll touch on the deal value first, and maybe then just a couple of other points about how it impacts the M&A landscape. Deal value is being brought in with a certain background and context to capture deals where your target might be very small in size. So it might be benefiting from that target de minimis exemption of assets and turnover.
Right.
And the value is very high. So there's a mismatch between what the target is generating, what asset base the target has, and what is the value that is being given to it by the acquirer. And this happens typically in very, very few spaces. You'll see it in the tech space. You'll probably see it in the healthcare space, which are very, innovation-driven markets. So what you're generating and what you have may not really be equal to what promise you hold.
Because of the entire discounted cash flow, and then the curve of.
So, and the deal value might reflect all of that. Right. So the deal value threshold is only to capture all of this. There's been a lot of noise around, oh my God, does it mean too many notifications? Yes, there will be an increase in notification because there's a gap the regulator is trying to capture. But I don't think that increase is going to be manifold, that all the deals that you were earlier going scot-free will suddenly get caught into the net now. It's a decent threshold. It's a threshold of 2,000 crore, very similar to the threshold that we have in Germany and Austria, which are the only two other countries that have deal value thresholds. And based on their experience, they've had probably less than 10% additional deals being notified. So I don't see a big jump.
So it's not as adverse as one makes it sound to be.
Yes, not that bad. Timelines is something you noted. Along with the deal value threshold, there was another set of amendments brought in which drastically reduced the timelines. As a regulator working with the Commission and day in and day out, we've seen fairly quick approval timelines for simple transactions. For the complex ones, I think the parties themselves are fairly prepared for the additional time that's going to take. It gets reflected in all the documentation as well. So I think in timelines, there is a stress from the regulator as well to ensure that we don't really extend the timeline. But just very quickly, I think a couple of other things from a competition perspective is early stage feasibility assessments. We've done that on big deals, where, much before you actually come into the room to negotiate the agreement, you'll probably sit down and see whether the deal is feasible from a competition perspective, or whether some changes might be directed by the regulator, which will make this non-workable. That, I think, is something we've focused in bigger transactions, but there's increasingly a need to look at it in smaller spaces as well.
Right.
Maybe you're acquiring a company because of the data that the company has. There is a need for you to examine whether that data might be siloed off, reducing the value of that company for you completely. So I think that is one aspect which, as competition and data regulations evolve, is something probably the M&A space will also have to account for.
Got it. Super helpful. So in the interest of time, I just have one set of last question. Again, from a regulatory perspective, directed at both Vaibhav and at Naveen, since I know both of you do a lot of work on the regulatory side. The biggest regulator of them all, Bharat Sarkar, right? And again, let's just go back, rewind a few years to the entire thing about, Press Note 3 of 2020 and things like that. It has had a whole bunch of, unintended consequences, right? What you were trying to restrict is, inflow of funds from a particular country, but now it's actually becoming a whole lot of issue. European companies who are looking to undertake, M&A in India, they are having issues from a PN3 perspective because, indirectly they have had some kind of inflows or shareholding from the PRC. How is that one deals with this kind of scenario? Or does it also result in a scenario where now Indian promoters have to do some kind of a basic diligence on the acquirer to see if they're in compliance with PN3?
Thanks, Gautam. That's an excellent question. Look, I think let's not beat around the bush. The reality is that in the backdrop of COVID, in the backdrop of the border conflict, India, much like Australia and some of the other countries in Europe, took a political decision
that we will not allow inflows from China without specific approval of the government of India. And that was a political decision driven by national security and other considerations, and we completely respect that. And post 2020, ever since that notification came in, true-blooded investment coming in from China into India has been a challenge, and government has put restrictions, and that's a conscious decision, and we all respect that. And there is some policy considerations that drove those deliberations, and we are not here to question it. What, however, has happened, which is unfortunate and a collateral damage and an unintended consequence, was private equity funds and venture capital funds. Right. A lot of private equity funds and venture capital funds, which are true-blooded American or true-blooded European, where the general partner of the fund is situated in Switzerland or in the US. You know, names such as those which would, in nobody's mind, leave even an iota of doubt, have no Chinese influence. And as anybody understands the fund structure, it is the general partner, it is the chief investment officer who takes all the decisions insofar as this investment is concerned. And the say of a limited partner who's putting in money is as much as you and I would have when we put in money in a mutual fund. We have no say how the manager decides where to invest, how much to invest, and when to dispose.
Pure play financial vehicles.
Pure play financial investors. So a lot of these global funds, of course, had a lot of investments from China as limited partners. But because Government of India till date, despite the fact that now the Reserve Bank of India under the KYC guidelines and under the PMLA, there's already a notification which lays down beneficial ownership to be 10%. But for various strategic security considerations and other fear of unknown, we are not willing to clarify what that beneficial ownership would be for venture capital funds and private equity funds. So true-blooded funds which are looking to invest in Indian corporates with Indian founders, with Indian management, Indian control, because they have some limited participation of a Chinese investor, those investments are now going under the approval route.
Right.
And approvals such as those are taking forever. You have an empowered group of secretaries that the government is constituted precisely for this purpose. But when these applications go to the Home Ministry for clearance, it's a bit of a black hole. And we understand those considerations, but it's taking forever for an Indian pharmaceutical company to be able to get investment from an American private equity major because there's an LP participation of 4% from China.
And in some cases, that is also resulting in collapse of the transaction itself.
That is correct.
The investor may not want to wait for indefinitely for 12 months or 18 months.
And also the converse, because Indian companies are now riding the growth wave. If I have struck a deal with you on X valuation, I will not hold that deal with you for that X valuation for the next 2 years. Because naturally I would ask for an upside because the growth is playing out right now. So that is becoming a complication. We really have been making a lot of representations to the government. We're hoping they intervene, they clarify what beneficial ownership means. But otherwise, what is happening is a European company, which at 4 layers above has a Chinese investor owning 3%. And you and I are having to now worry for our Indian client that would we end up tripping press note 3. And there have been instances where such companies have had to be told by the government that you have to take out that shareholder and go for compounding under FEMA. So that's a bit unfortunate, unintended consequence of the overall objective on which we are not debating. And we understand and we respect where the government is coming from.
Right. Naveen, quick thoughts.
Yeah, thanks, Gautam. I think Press Note 3 clearly was a political decision. And on most counts, I wouldn't say it's as bad as Vaibhav is saying. I think it was a conscious political decision not to have funds from certain jurisdictions. And it's playing out well. If you'll see the FDI trends also in India overall, it's on a rise. It's not reduced. That's one.
But it's making things
a lot more
complex,
I'll explain that.
right?
So clearly there has been complications that are there. Now the answer is, and obviously the complications cannot be sorted in 1 year or 1 day. But if the question is it resulting in a loss to India at a level? I mean, I haven't come across any client who is saying that, particularly because of Press Note 3, we will not do the deal. It has not happened so far, not in my experience.
And there are just to say what you just said. See, it is not the loss of fund really. It is also the loss of reputation and image. One stroke, you have changed the entire policy, and the beneficial issue that Vaibhav has raised. This issue was raised right there and then. in 2020, that what do you mean by, and what is the threshold of the beneficial?
So I think now, and it's not been 1 year.
No,
it's 3 years.
now there's been a lot of clarifications on what SPO is. It's not 100%, one cannot claim that there is 100% clarity on every aspect of press note 3. But if you approach the regulator, they have the principles very clear. Earlier, there was some lack of clarity around
Absolutely. In fact, Gautam, I will add to say that there has been an amendment to the standard operating protocol, which has created more confusion. Right. Because now the government is saying you will go right up till the layer top, and there is no concept of 10%. And so whatever definition of beneficial ownership my friend Naveen is talking about has not been said. They've said we are not applying this in FEMA.
Correct.
And
so, although Companies Act and PMLA are pari material legislations, correct, our understanding is that these thresholds and these interpretations are not holding good for FEMA.
I think the short point is we all support Government of India's position on PN3. We are all in respect of that. So it's not a bad thing, as I said. It's a good thing. Only problem is the unintended consequence in private equity and venture capital funds investing in India and global acquisitions where at some layer above, there might be Chinese interest because ultimately China was a far more developed country. It had far more capital. It was investing all over the world. So you will find remnants of that. Now the government will have to clarify eventually and not leave it for us to debate. And at least we have experienced deals blowing away because of the fact that there's no clarity whether government approval will come or not.
Right. Since we're short of time, last questions, Diksha. The new Digital Personal Data Protection Act, any impact or business as usual?
I think largely business as usual. You do a merger, you're doing some data acquisitions, you'll have to work around your consent mechanisms to ensure they're in line. The only thing you have to keep in mind is if data is one of the main or strategic reasons for acquisition of a company, that might have implications under data law, under the new Digital India Act, and under Competition Act. So where the data set itself is the reason why you're acquiring. Right. I think that is something that might have to be thought into, not time for us to go into it right now. So we will do for another day.
Fair enough. Thank you so much, everyone. We are unfortunately short of time. Otherwise, I think we had a lot more questions lined up. Thank you, everyone.
Could I please request you all to kindly come forward for a quick picture? Ladies and gentlemen, we are headed towards the final discussion for the day. Thank you very much. Institutional arbitrations, the way forward. Let's give it up for our panelist, Neeti Sachdeva, Secretary General and Registrar, NCIA. Thank you. Please welcome R. Sudhir, Senior Partner, Always in Fitness.
We have been discussing ESG, but there is a lot of noise pollution coming from the rear. Noise pollution at the rear. Please let us have some respect for the eminent panelists here and listen to them and learn something from them. So I don't want any noise pollution from there. Thank you.
Thank you, Dr. Hussain, for doing what I've been meaning to do and been trying away for a while now. Thank you very much. Now, ladies and gentlemen, I would like to have please welcome Neeti Sachdeva, Secretary General and Registrar, NCIA. Let's welcome R. Sudhir, Senior Partner, Always in Fitness. Let's welcome Rob Lapa, Legal Head India, and welcoming the session time, let's give it up for Kevin India, Associate Editor, NewsX.
Hello, am I audible?
Yes.
Good evening and good to see all of you once again after a year's time. I am discussing today one of the subjects which I discuss often, and it's discussed also often with so many businessmen who I talked to, the role of institution arbitration in India. Of course, we've seen the growth of ad hoc arbitration in India in the past many years, but the emergence of institutional arbitration and some good institutions have come up in the past few years. And that is something which, in a sense, is good for India, given how large a market it is, and the kind of increase in disputes that we expect with the kind of investments that are going, particularly in infrastructure. You're looking at something like $250 billion of investment in infrastructure. And we've seen infrastructure, I would like to single out, generates a lot of disputes in India. But before I move on to the questions, there has been a certain kind of unhappiness that I witness in many promoters who I talk to, where they always tell me that, Tarun, I would like to remove the arbitral clause in the contract because it takes forever, that even after I have an award, it takes forever to enforce. So we discuss both sides of the coin today, and who better than all these experts who I have today who are in the thick of it. Let us start with Neeti Sachdeva. Neeti, give me a good opening comment where you sum up the Indian arbitration scene in the past 10 years.
Thanks, Arun. And thank you everyone who has sustained an entire day and is still here to listen to institutional arbitration. We'll try and make it interesting for you. I don't think I can get a better opening place to talk about institutional arbitration, given that I represent an institution. And I'll pick it up from where Tarun left and said that he speaks to promoters who say that we want to remove an arbitration clause from a contract. I think that's the difference where it lies. And we've still not been able to differentiate the fact that when people say arbitration is not working, it's actually the ad hoc arbitration which is not working. Have they had a flavor of institutional arbitration in the last 5 years, 7 years, and 10 years? I think a lot of people in the room would have not had the same comment. Why do I talk about it? Just because I represent an institution? No, because this is how disputes have been resolved worldwide. And unfortunately, India has lagged behind for some time. So if I was to summarize how things have happened in the last 10 years in the field of arbitration and institutional arbitration, I think it speaks volume that where our courts are criticized for being interfering in the process, we now have moved, the pendulum has moved to the other side, where we see the high courts and the Supreme Court actually referring matters to institution to appoint arbitrators and to administer. Clearly, it shows that there's a confidence in the process and that the process is working. But that is not as how we will see the future of institutional arbitration. We'll have to have parties agreeing to it. But I also have a caution. There was a report by Justice B.N. Sri Krishna. I'm sure everybody has spoken about it, threadbare and all. But one point which came out for me, which was also very surprising. And when I say surprising for me, because I always candidly say that all that I have done in the last 17 years is arbitration, so I know nothing else. And I was pleasantly surprised to know that there are more than 45 arbitral institutions in India. 45 is a number which many of us would not even have heard of sitting here. So the problem is that when you have that many arbitral institutions and not regulated in terms of their quality, the experience of every individual is different. And then you paint the canvas with the same brush and say, oh, it didn't work for me. It was expensive. Arbitrator was not impartial. Arbitration doesn't work. So I think we have made quite a stride in terms of promoting institutional arbitration. Our courts have done a lot. Legislation has done a lot. But I think there is still a lot which needs to be done in terms of standardizing the process of how the arbitration should work in India.
But 45 is a number which I admit I had no idea. It is just too large a number for any country. I mean, this question is to you. Two things. We don't have a very dedicated arbitration bar in India. We don't even see elevations to the court from the arbitration bar. Thirdly, we also witness that lawyers treat it as a weekend activity or a post 5 p.m. activity. This all are impediments to the growth of arbitration in India. Given that as a fact or the base where we start, where no elevations happen, so there is no motivation many times among the arbitrators that, they say, okay, we do arbitration, they also go to court. If you're dedicating yourself to somebody, but there are no elevations happening, which means that talent goes unrecognized. a great deal of talent goes unrecognized because there is no elevation. Who gets elevated mainly is people who appear in court, mainly the arguing counsels many times is what we see. Give me a fair picture from your end of the spectrum because you come from a law firm. You also interact with clients very regularly. Where are we headed? Where are we coming from in your experience?
Hi, good evening, everyone. It's a very interesting question. In fact, just before we came in, I was talking to Nethi, Justice Som, who was on the panel of arbitrators in the Mumbai International Arbitration Center, has now become a judge. Yes. There is someone else who is a partner in one of the largest firms in Delhi. There are rumors or gossip which says that possibility of becoming a judge. So it is not as if people who are involved in arbitrations are not recognized. By and large, what happens is today the members of bar are appointed as arbitrators. They also practice in courts. So they appear before the courts under section 34 jurisdiction, 37. So they get recognized, and we are not too far away from those arbitration specialists getting recognition and also being called to the bench. So it's not a case where they're operating silos. Arbitration happens somewhere else. They're completely away from the courts. No. Arbitration courts are closely interlinked, and arbitrators, unless they are completely professional arbitrators who are doing international arbitrations and they don't want to come into the system, they may not be aware of. So it's always important that the arbitrators also make their presence felt in courts, and their ability to understand arbitration and also understand the nuances of the arbitration law will help them recognize and get recognition as a judge. So I personally feel that with these two things which are happening in the recent past, there's a trend that has started where people who are focusing in arbitration law and doing arbitrations can also be elevated as judges on the High Court.
Yes.
That's true.
And the same which you have suggested, they are not just arbitration lawyers.
True.
They are hearing
Courts regular. Yes. Bar, very true. You are absolutely right, Dr. Basin, you're right.
Can I just come in quickly? I totally agree with what Mr. Bhasin has said. And like I said, I've been now practicing arbitration for 17 years. And I think this discussion has just happened every single year. We talk about it, having an arbitration bar, why it doesn't happen. I think, Tarun, you have actually hit the nail on the head to say that you don't recognize arbitration practitioners to be elevated to be senior. You don't recognize them to be judges. It's good to have Som who's been able to do it. But as Mr. Bhasin said, he's not only an arbitration practitioner, but that's the nature of arbitration as well, right? The first reason people pick up arbitration is for its confidentiality. Yes. If you're going to be going out talking about this was my arbitrator, this was my counsel, this was my parties, then you have lost the confidentiality somewhere. I don't think it's only about becoming a senior or a judge. I think a lot of people, I can tell you, who are in the practice for about 25, 30 years now are very happy to accept appointment as arbitrators and make that course, I would say, change of course for them from being arguing counsels to now sitting as an arbitrator. So we have to build an arbitration bar. It's slowly, definitely happening. Again, institutions play an important role because I can tell you any institution appointing an arbitrator will not let that arbitrator work weekends. It's not acceptable. We take an undertaking, I can tell you, for MCI and for every other good institution. We take an undertaking from the arbitrator on the number of hours they will spend in the next 6 months and during the week. It's in writing, signed by them. So that's how you have the process slowly changing and building up that bar.
Thanks for that input. I'll go to Roop. I want to know two things from you. In India, the problem sometimes also comes after the arbitration process. So you had a good arbitration process and the parties have a good paper award which looks nice and well, but you don't get any money. Can arbitration succeed in a country where courts have a tendency to do justice in a matter? When judges sit with an attitude that, oh, I have this award, now let me do justice to it. So I'll sit in judgment over what has already been judged and adjudicated upon through the arbitration process.
What means, so now the Supreme Court, we have some good judgments coming, as Niti also said, but India is so many states, and many times attitudes across states vary. That's why you see a lot of work gravitating towards Delhi because it's qualitatively better, if I may say so. Your opinions on all of this?
Good evening, everyone. As far as arbitration to be effective, I think you
can take this.
Thank you.
Good evening, everyone. I hope I'm audible now. As far as arbitration as a process is concerned, for this to be effective and for this to be more robust, we need to kind of restrict the intervention of courts under, of course, there are grounds provided under Section 34 of the Arbitration Act, but we need to also, as a matter of procedure, restrict the intervention for this to be effective. And as far as the companies or the promoter-driven companies are concerned, for them to get confidence in the process of arbitration, that's very important. When we come to institutionalized arbitration as compared to the ad hoc arbitration, I think the delivery levels are much better. So we are going to be evolving to that stage. It's a journey right now, but we will be evolving to the stage of having a limited intervention as far as the courts are concerned. We need to look at the act where we can further limit the interventions and make it more robust and more acceptable. I think courts are already flooded with a lot of litigation, and if my vision around it is that we should be having more arbitrations and more institutionalized arbitrations, and some of the pending matters can be referred to the arbitrators. Of course, we have mediations, but then that's the way forward.
I have something to add here. My experience. See, places like Delhi, Mumbai, Chennai, Kolkata, the high courts, when they deal with 34, the attitude is different. But a lot of other places, the high court does not have original jurisdiction. Like take Allahabad for the matter. So even if you have a multi-crore award, if a 34 is filed before this district judge, they don't have, first of all, time for arbitration matters because they hear bail matters, they hear other matters, and this is way down the list. Vakil sahab ab baithiye, aapka case hear karenge. By the end of the day, they'll give another date. It's treated more like an appeal rather than an objection to an award under 34. So that system where, be it Karnataka, be it Andhra, every other state where the High Court does not have original pecuniary jurisdiction, and where 34 lies before the district court, there is still a huge challenge because the kind of awareness to the arbitral system, what we have in Delhi, Mumbai, etc., is not there at the district court levels across the country. So that's where even if you have an award within 18 months, 6 months of completion of pleadings, 1 year for closure, yet after the award is passed, that's what you said, the 34 challenge begins and it takes 3, 4, 5 years easily.
Can you hold it here for a bit? You said district courts. If high court judges are sitting, as arbitrators, and then then the appeal is heard by a district court judge, do you think there is some fallacy in that process there, or you're okay with it?
I'm okay with it. See, the issue is the district judge would not even know the background, the reputation of the retired high court judge who was an arbitrator.
Yes.
He only looks at the award as if it's an appeal against a lower court decree. The mindset, the attitude is such that, no, this is an arbitral award, this is a time-bound process, it must be resolved. That culture has to soak in.
You said culture, and I have an anecdote to share. I'll not give names. I'm very happy that institutional arbitration is succeeding in India because recently in an ad hoc arbitration where there was a single arbitrator, he came with 2 of his childhood friends who said they want to watch how I work. And one of the arguing counsels objected to it. The arguing counsel was very angry. He had coffee at the overall after this. He had an altercation with the judge. He was given. The next day, he got his son while he was presiding and said that my son is not doing well in law. The council again objected, saying that this is a confidential process. Your son can't be part of it. How can we got involved? We've seen such anecdotes, and then when we see institutional arbitration happening, the kind of standards that you bring to bear because what you're doing. Can you also speak on that? What institutional arbitration is doing for India, Neeti?
Definitely, Karan. I'll just answer your question on a district court judge looking at a matter of a high court judge. I think that's the fallacy of the thought process itself, right? When we say somebody sitting as an arbitrator, it's devoid of what their position was or is. They're just an arbitrator. And an arbitral award coming out of it needs to be looked at whatever court it is. In fact, Mr. Bhasin is here. I'm very proud to be a part of CIARB as well. And the Chartered Institute of Arbitrators is doing such a great job to have arbitrators trained. Right? So MCI now has 83 matters, and I can tell you very proudly, except for 2 matters, we have not had a retired judge in any of the matters appointed as an arbitrator. Nothing against them. They do an absolutely fantastic job. But it is not that a retired judge is always required to be sitting as an arbitrator. We get matters on shareholders' dispute. There are technical infrastructure matters. You don't always need a retired judge to be listening to it, right? You need an expert who understands the business. And with that, like I said, CIAB is doing a great job because whenever we appoint an arbitrator outside of a retired judge, it's just so easy to see that there's an FCIAB, a standard which is made, and that is where the institutions come into play as well, right? I think one of the biggest, it's a cliche, but it's true, is that your arbitration is only as good as your arbitrator. And half your battle is won if you've got a right arbitrator to manage and manage. The difference is that, and to everybody in the room here as well, we always say we're very happy to appoint new arbitrators. You may have the knowledge of the field, but having the knowledge of the field and to write an award are 2 different skill sets. What the judge sees in the court is your award. So courses like CIARB, courses like award writing practice actually prepare you from that transition of knowing the subject, knowing how to interpret the law, to making sure that you write an award which is not challenged in the court. The second point, I think, which an institution plays very important is that we are the repository for how an arbitrator has reacted. And I'll give you an anecdote here, an issue that we faced. There's a very high-profile matter which we got as an MCIA. It was a contract which had an MCI clause. And our rules say that each party can nominate an arbitrator. The presiding arbitrator is always appointed by MCIA. Now, the reason again was this because we want to come out of that pale, stale arbitrator problem, right? You need to have newer arbitrators. So claimants appointed a nominated an arbitrator and sent a disclosure form to us. As a matter of process, we reach out to the arbitrator again and ask them to disclose within the availability of time as well. The arbitrator came back and said that there is no conflict. Whereas I was well aware personally as well that the same arbitrator has been appointed by the same party at least 10 times in the last 1 year. Now, what do? I picked up the call very politely, a retired judge of Supreme Court, very politely, and I said, sir, your office may have missed it, but if you've been an arbitrator more than thrice in the last 3 years for the same party, we have a law which restricts it to doing. Would you mind just please checking and getting back? Because we don't want an embarrassment for you or for us. Within 15 minutes, we had the arbitrator recusing himself, right? Which wouldn't happen in ad hoc arbitration. So that's the institutional knowledge which comes into, and also the arbitrator's feeling that if today they don't do this, their reputation is going to be at stake. So I think that's where institutions play a very important role.
Thanks for highlighting all these points. Many I didn't know about. One thing that I want to ask of you is, the recent glaring statement was made that arbitration is seen as an extension of the litigation process in India. Because many times in disputes where banks are involved at a level, for example, infrastructure companies, where everything is financed, and the amounts are all the votes, so even a day's delay is a big number. How do we get out of that reputation? Because many times the interest cost is more than the award cost. It has now become a commonplace.
What is the way out? You are somebody who deals with this on a day-to-day basis.
See, it all depends upon how serious is the arbitrator in completing the arbitration process within a timeline. If the 6 months and 1 year timeline is adhered, then you can always wrap up the arbitration and you win or lose. The amount is known, the interest, again, how do you stop the ticking of interest? That's extremely important. In fact, recently we were doing a lot of research for a matter. There is one Supreme Court judgment, that's one stray judgment, which says that if the judgment debtor pays into the court the decretal amount, it is an amount paid on behalf of the decree holder, and therefore the interest will stop. Whereas there are several Delhi High Court judgments, Bombay High Court judgments, which say the other way, the interest continues to tick. Even if you pay the money in the court, the interest doesn't stop. So the best way forward is allow the decree holder to withdraw the money, subject to terms that he will plow it back within 15 days if he loses. That's the best way. And even the CPC says that once you deposit the money in the court and order to even you give a notice that this money stands deposited, then your interest liability stops. So interest liability stops if you give a notice after depositing the money in the court, or if the other side withdraws the money, subject to terms, then again your interest stops running. Interest alone, and when we did research, the award can be a few crores. The interest runs into 100 crores, 200 crores. So in fact, that's the best way. No one realizes that the interest is ticking. Everybody keeps fighting the Supreme Court without realizing that the cause of action started 15 years back. So the award will always say from the date of cause of action till the payment. And that becomes a huge, and that can be something which can really pull the corporate debtor down.
Yeah, this is a worrying sign for a country where a lot of infrastructure investment is happening. And a few such incidents where I see is that the bidding cost can go up as a factor because you're building in that cost into your bid, because you feel that, I may not recover money, so let's build in that cost into the L1. So your basic input goes up for every contract. That's a worrying thing. We'll be paying much more for the same infrastructure creation. That is, I think the television tells me my time is up. I would have loved to chat with you all more on this. Maybe we'll get to do that offline, but I appreciate that all of you make time, join with us, and the audience. Dr. Lalit Bhasin wants to say something.
This is one of my favorite topics because I do firmly believe that in India, arbitration has not taken off. It is mainly due to the fact, as Neeti rightly said, lack of good institutional arbitration centers. You said that many centers have come up. No. Yeah, you can count, say 45, but which are active? Which are those institutions which inspire confidence? Every institution is not like MCIA. Government has also set up, some council and all those things, but it has not taken off. We had the earlier one set up by Mr. Bhardwaj, the late law minister. The building was very good, but there was nothing inside the building. No proceedings were taking place. So MCIA is an exception. Yes. And so are a couple of other, Nani Palkiwala Center and all that, very respected. Therefore, when you have ad hoc arbitration, it is monopolized, cartelized by retired judges. The arbitration has become very, very expensive. One full day is split into 2 sessions, 2 hearings.
Double fees.
Yeah, double fee. So it is good, for the retired judges, possibly good for the lawyers also. They also earn the same fee. But is it good, for
the client?
Dispute resolution? This is not good for dispute resolution. Disputes are, pending 5 crore cases. Law minister made a statement on Friday. out of which 80,000 cases are pending in Supreme Court, 61 lakh cases pending in the high courts, and 4 crore cases pending in the district courts. Where is our system of administration of justice? Can arbitration be? No, unless you have good institution. When there is a dispute between two parties in India, they would prefer to go to Singapore or they would prefer to go to Dubai to have that. And when we talk of arbitration bar, there is no arbitration bar.
That is a worry.
No, that is not the worry. But why there should be an arbitration bar? Why? That means that only confined to lawyers. There can be other experts, as Niti rightly pointed out, who can be not only very good presenters of the cases, if technical matters, who can be very good arbitrators also.
Yeah, because recently in a sniff and tell arbitration for basmati rice, you had somebody who could sniff the rice and tell what quality it is. It was an export dispute.
So arbitration should not be just, you see, localized with the retired judges and lawyers. You have experts, bureaucrats, engineers, architects, chartered accountants. They should all form a part of this. Only then we can come to this.
In a lighter vein, can I make a comment before I end? One arbitrator once told me, Tarun, the expert is a very dangerous person. When he has to arrive at a certain figure, he says, "Aap mujhe figure dena, I'll arrive at the figure and present it before you." So, but that's a comment in lighter vein. Thank you.
Which override did you have the pocket? Override that or override? That's a joke between me and them. Very wide jurisdiction.
I'd like to thank each one of you for taking time and coming to the panel. Thank you. Thank you all.
Let me check out the time down project for a group picture. And with the same, ladies and gentlemen, continuing the evening celebrations, I welcome you all to the third edition of the World 30 Under 30 Awards. Today, we gather here to celebrate and honor the young minds who have showcased exceptional body of work very early in their legal journey and are on path to become the leaders of tomorrow. Before we move forward, I'd like to take a moment and express our deepest gratitude to our partners who helped us turning our vision into reality. Argus partners, Loctopus, The Thick Shape Factory, Troy Travels Private Limited, Royalty Plus, Exchange for Media, IWL Plus, Impact, Pitch, Foundrum, and Boonley Coffee. When we talk about awards, we cannot move any further without knowing the process. And when we talk about the process, let's quickly take a look at our jury panel who helped us arrive to this power list after an intensive jury deliberation. If I could request everybody's kind attention towards the big beautiful screen, I would like to cue the jury in for you. And also a quick reminder requesting everyone to kindly put their mobile phones on silent or vibrate only mode. Let's quickly take a look at the jury AV.
I think you'll have to run it again.
Could you please give that again? Perfect. To start the evening of celebrations, ladies and gentlemen, I invite Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Business World and Exchange for Media Group.
Good evening. It's my honor and privilege to be here at the BW Legal World 40 Under 40 Award and the BW Legal World 30 Under 30 Award. This is the fourth edition of the BW Legal World 40 Under 40 Awards, and this is the third edition of the BW Legal World 30 Under 30 Awards. All of you who are in the room are doing. Some of you can sit here. Seema, you can come up, and sir, you can also come up. All of you are distinguished. So would welcome you, but there are people who made the initiative happen. It's my duty and honor to acknowledge them and acknowledge their presence here today. First of all, Mr. Lalit Bhasin, who is the jury chair of our BW Legal World 30 Under 30. Please give Mr. Lalit Bhasin a big round of applause. I keep saying that there's a lot to learn from him. And that is, he gives whatever he does, his best. He's passionate about making a difference to what he does, and that's why he's been pioneer in many areas in law, right from setting up CIRF, and I don't have to explain. And he made that point that in India the cost, arbitration hasn't worked as a reversal mechanism, because both the cost of arbitration and the time of arbitration makes it unfriendly for the person who wants the solution. So really, mediation has to be the next course. Mr. Pramod Dubey is there, top-notch legal. Ms. Geeta Luthra is there, Mr. Sudhir Mishra, Mr. Seema Ahluwalia. Lots of jury members are here. All the GCs are the room, the speakers who've spoken in the day. There are parents, every legal functionaries here, judges.
but they're here in the capacity of being parents of some of the winners. So I've been requested not to take their names till there. So I won't take their names. So that's the only reason I'm not acknowledging some of you. I know you're in the room. My team at BW Business World, all the winners of the BW World 40 under 40, all the winners of BW World 30 under 30. We started the legal community 4 years and a month back. We completed 49 months of the BW Legal World community. We just got started, and there's a lot to do, a lot to improve. But one thing we got right is the jury process. There are friends of mine in this room. So Sundaram, thank you for being on the jury. I can forget names there, I still write down, but the first edition and they didn't win. Some of them, because like Sachin Tendulkar, like Virat Kohli, like Rohit Sharma, someday, in spite of being a great cricketer, great batsman, didn't bat well. That day he did not present well. So some of you didn't win. Some people applied for the last 3 years, 4 years to win today. I won't take their names. And, one or two of them were personally known to me. And some of them in the first list, just as somehow here we were on the text talking about such, because the jury was being run by Mr. Shardul Shroff, Mr. Ryan Karanjawala, and Mr. Rajiv Luthra, the late Mr. Rajiv Luthra. These three were really running the union, you can imagine it. And, they really took ownership of the process, and they were running the union, which we were very happy about. We liked one or two. They told me I can't be on the jury. So, of course, I was just there only and I was learning for me. There's no question. And there were one or two candidates who should have won, and me and Mr. Narasimha were exchanging tax that I hope these people win. And for some stroke of luck, those two people won. I won't go into those details. But really, we built an honest process. One of the winners was on the jury for the last 2 years of the 30 under 30. He was my good friend Siddharth Batra. He's MD as lawyer, and we share this same surname, and his family is a very preeminent family in Haryana. So really, he called me one day after the first award, and he told me that the other media company that does awards won't take. I love all media companies. I'm the founder of Exchange for Media, and I believe in abundance. Everyone should do well. But he told me they asked me 3 lakhs for 40 under 40. And of course, he said, I'm not even getting into that. So really, I just want to say that today, whoever will get awarded is through a jury process. You know it, but I want to emphasize. I have people I've known, I couldn't do anything for them in the last 4 years. Whoever has won today won through because they went through a process the jury liked them. In some cases, some of the jury members believe the plight, they recused themselves from us. Like Seema is there, and I think one or two of the colleagues applied. Seema did not participate in that process, and then we followed. And let me tell you, if the jury chair or any jury members, Weber is coming, Weber again was on the 30 under 30 jury. One jury member or the jury chair kind of veto the person, then also it becomes difficult. And typically, a lot of jury members have to agree to be able for all of them or a lot of them, right? So I want to emphasize that no process is perfect. And I'm a Hindu firm, so I believe in 2 things, sir. As I said in the morning, only Lord Shiva is perfect and my wife. These are 2 people who are perfect. Ms. Gupta is there. Welcome. Ms. Neema Gupta is also there. So thank you for being here. I don't want to, I know you're running late and Mr. Basim is always bang on time. When I grow up, I don't want to be like you, sir. But I was 3 minutes from with you. But I must say, in the last 2 months, I had, except one meeting, 20 minutes, 30 minutes, I had for every meeting. We were very conscious about that. But I was a little slow in the morning. I had an upset stomach. So I did prepare something for the winners. It's not for you. I don't know what to teach you, right? You said you're thinking, or आपको क्या बताएंगे? Lekin I did prepare something for the 30 under 30. Those of you know me, my friend Tarun, Sudhirji, Seema, I've known Sudhir for a long time. I've known Seema ji really for 25 years. She's also my law firm Exchange for Media, my law firm in business world. Tarun has been my friend for a long time. He's a young fellow. I met him when he was really young, and he's really made a mark in the legal broadcasting space. So I didn't know what I'm talking. I followed that. So I prepared in some points a common for 30 under 30. And I only want to focus on 3 points. Some I talked in the morning, so I'll keep it really short and I'll skip a lot. Like, first of all, I want to ask you, do you know this guy? Mr. Mishra? Ajit Mishra, do you know this guy? He's not a lawyer. He's not an IPL player. He's not a movie star. Does anybody know this guy except my team? Does anybody know this guy? Take a guess. Good name works. Losing. He's not blind, but you're close. So I want to a time. He's an Israeli climber who in 2012 was climbing the Mount Everest, and he was very close to the Mount Everest. He would have become the youngest Israeli to climb the Mount Everest, and it would have been a great honor for him. While he was doing it, one of his friends died, who was accompanying him. Another friend was in the World Cup. So you can't carry people on Mount Everest. Very tough for various reasons. I'm not climbing Mount Everest, but I got married, so I have some experience. The same. Getting married, I don't got a lawyer, so I'm just looking at you and jokes. But he chose to carry his friend back. He could have chosen to be the youngest climber from Israel to climb the Mount Everest. This was 2012. But he chose to come back and then climb the Mount Everest. And yes, he saved his friend's life. In the process, he had some frostbites. Two of his fingers were amputated. Why am I talking about this? You know, awards. Today we hear a lot about me. And if you apply for awards, social media program there 20 years back, there's a lot of focus on personal achievement. That's great. But I want to start by saying that saving lives, contributing to others' lives, is a bigger honor than winning a people who are 40 under 40 or winning a people who are 30 under 30. So I never Benny Hauda. He is a Israeli climber. He saved someone's life 11 years back, and that's why I'm talking about it. Do you know those two guys in this photo? Siva, you can recognize one guy. You know him for long. I used to wear a tie. Do you know the other guy in the photo? He was a famous guy, the movie star. Yes. So I was in Cafe di Paris in Monaco, and one for the advertising festival, not the film festival. And I was sitting there and I'm a cruiser. That's how I remember birthdays and almost everything. So it doesn't matter who you are, right? And I saw him and I said, he looked familiar. And a guy who knows me as well with me, you know who? Mandal Bhuvan was with me. And he said, oh, that's Sherlock Done. And we went up to him and Bhuvan, his friend, Vijay and Ashok Amritraj. So we said to them, and I met him. So this is when I was much over 40, but I want to, about 30, I was 34. This is when I was 34, many years back. This is about 30, but there was a photo which was supposed to be before him, which I think you removed that photo, right? For some reason. My cigar photo at 24 age, no? Okay, anyway, that was in my business school. But the point I was wanting to make through that first photo is that when you see we were talking in the morning about GCs, the age of GCs is coming down, right? In every time I can say the CXO's age is coming down. Whether a CHRO, a CFO, a CEO, the founders, the founder is coming down. So in every domain, the age of achievement is getting younger. That's for me. And that's where Mr. Vasim is so competitive, even at this age. I talked about the 3 C's in the morning. It's not the cinemas, it's not the big 3 C's. We should avoid none of them. But I talked about the fact that don't compare. Everyone's journey is unique because we don't compare with humans. Can you minimize that? It's not possible. Don't compare. If you're alive, if you do after COVID, I have 4 friends I lost in COVID, right? Two you know well. So we are blessed. Gita asked me how am I doing. I said, I'm doing very well. My father-in-law just turned 79. See why you know him well. My father just turned 84. So, they're fairly healthy. So what else do I need? My parents are there. criticizing. A lot of people criticize a lot of other people without knowing too much about them, or sometimes not knowing them at all. We criticize our colleagues. That's why I don't criticize somebody easily. I have to really know someone, and the persons, all of us have flaws. As I said, there's nobody who's perfect. So stop criticizing. I talked about the 3 H's in the morning. The 3 H's that matter are, they're very easy. One is, first is hope. I genuinely get up every day believing tomorrow and today will be better than yesterday, right? And I make efforts, and I really believe that. Hard work. Mr. Basini, even at this age, young age, he puts in so much hours, puts in so much effort. I know a lot of other people who put in they're so accomplished, they don't need to work, they've achieved everything, but they work hard because that's their ethic. That's it's not so much about the money, right? Tarun always keeps asking about how much money is in my bank account. So, but I explained to him, I enjoy what I do. So whatever money I make is a bonus. It doesn't matter. So hard work and humility. All the great people you meet, with a space here it's okay. Thank you. Tarun, why don't you come here? Tarun, come here, come here. Don't go. I want you to be nice, my eyesight. I will do naughty things, okay? So, humility, you won this award today. There's a lot of luck. All of you are good. People who are shortlisted, all of you are good. But be humble as you grow. The more humble you are, people will collaborate with you. I mean, people will be open to reaching out to you. If you're very, very stuck about who you are, less people will approach you. As I said, I'll keep it very short, so I'm really going. A lot of things I learned late in life. My parents are academicians, they're very frugal, they try to save every penny they can. Still now, they don't need to, they have enough money in their bank. Tarun knows my parents, so he knows my parents, right? I believe that the power of compounding. So save. I'm sure all of you save money, and in a world after COVID, which is YOLO, you only live once, so you spend all the money, right, on experiences. But I think you should start saving money, right? Also, all the habits that I have, good or bad, were formed when I was about 30. Okay, I used to work very hard even when I was in a job. Whatever you do now will impact your long-term health. I'm in my early 50s. Whatever I do in my 50s now will impact. I'm already late for whatever I should have done, but ultimately focus a lot on your health. Also, one of the things, I have mentioned in first job where they're now working in different parts of the world. They keep every 2-3 months, they will reach out to me. There's some issue, and they're all about 30. So they ask me about the bosses, colleagues. Don't spend time with people who don't treat you well. Don't do anything to them, just leave them alone. Be good to people you care about. That's your parents. As you grow old, you'll realize the most important is family. Friends are there, and I won't say friends are a source of inspiration and support, but your family needs you more. As you grow, your parents need you more. And so that's why I kept it a little broad. There may be other people. A lot of people, I will not take names. I know 2-3 winners today. They try to do too many things. If you want to do well in life, Mr. Dubey is a lawyer, but he is a top-notch criminal lawyer, right? White-collar crime. He's made that. So do 1 or 2 things that you do really well. Don't try too many things. You can't be an entrepreneur. You can't have a job. You can't have a show like Sudhir every week called the Sudhir Mishra Show. You can only do 1 or 2 things. There's that life is a trade-off. There is only that much time. And, I will move on. There are lots of things. I'll make sure the presentation is bad. But a lot of people ask me, how did I achieve whatever little I've achieved? How did I lose my hair and so on and so forth? Primarily, it's my parents' blessing. Okay, I really believe that. And I go every week. My parents live in Gurgaon, that far. It takes 1.5 hours to go, 1.5 hours to come, and only spend an hour with them. But at least twice a week, sometimes thrice a week, I go. And it takes effort. So then, second is I believe in luck. But I also believe the harder you work, the luckier you get. So I go to temples and all, but I believe how you treat your parents, how you treat your friends, how you treat people who supported you will create your career. One of the reasons I read a lot of books, I still buy a lot of books. Day before yesterday, I stole 3 books from Sudhir's office. I went to meet him. I saw some new books. He knows. I said, I'll give you 3 for the 3. But I read a lot, much lesser than I used to do in my job. Read a lot. Read about areas. Read about history. Read about philosophy. Read about business. Read about, of course, legal. But some of the books I will come on my top 50 books and top 40 books because the 2 were 30 and the 30. I'll send that, but read more. If we can play this, but this is from friends, and one of the things that people know me because I see young people glued to their phone, they're with you and they're glued to their phone. It's okay, but phone impacts your sleep. I keep my phone in a different room. I don't keep it, my friends who is a friend, they know it's in a different room in the night. Even in a hotel, I keep it a little far off from me so that I'm not tempted to go. Whatever, if you want to excel at your work, sleep is the most important thing. You'll eat better, you'll think better, take better decisions, you'll be kind to everyone. So it may sound like, what am I talking about? Sleep at a legal event. But your young people, I see a lot of young people. This is a book I read 10 years back. Why You Sleep By. Once you read this book or watch the YouTube, the TED Talk, you will never compromise on sleep. You will compromise. Like people who take late night flights, save money, I tell them, there's no point saving money. What is the point saying you're going to mess up your sleep? I go one night before, pay the hotel room, even when I had less money. Right? I don't take early morning flights. I've done my initial career of entrepreneurship. And then, I read all the Harari books, and the constant theme that human beings are mean to each other, they claw. But I read this book in March this year. It's called Humankind, A Hopeful History by Rutger Bregman. It's a young Dutch philosopher. And he basically talks about be kind to people. And human beings are basically kind. And he's done research over 150 years. So you want to grow, be kind. That same person may not be helping you, but somebody else will help you. That good will come back. So do good whenever you can. Be kind to people with your time, with your money, with your advice, with your connections, whatever it is. Mr. Basim is very kind. Whenever I've gone to him for anything, whenever I've gone to Mr. Dubey, my last thing. So I talk about sleep, I talk about kindness, and last thing. We just finished the COP28. In India's role, we can debate how good or bad it was. It could have been better. We'll leave it at that. The latest issue of Business World on Monday is about climate finance. I was sitting in the Habitat library and I was waiting for a journalist friend of mine 3 months back and read this Time magazine. It asked, what is the most important place on earth? And the most important place on earth is ironically oceans. The shrinking of oceans is very bad for us. The big mammals in the ocean and their excreta absorbs a lot of carbon dioxide. So the more the oceans shrink, it is bad for us. And like Donald Trump is wrong on lots of things, he's wrong about the fact that climate change is a hoax. It's not an hoax. Look at this. Winters are so short. The winters are not like winters 20 years back. In parts of the world, summers are coming 4 months in advance. How many months? 4 months in advance. In Africa, 5 months in advance. The wildfires in US, Europe. So really, whatever you do as leaders in your jobs, all the 40 under 40, a lot of your partners have seen your profile. You have a commitment, responsibility to the earth. It would be an overstatement to say that we will nurture the earth. We can be sensitive and respectful of the earth. So I don't want to preach too much. I wish you well. This is the latest edition of this book. I read it 2.5 months back again to reinforce. And it basically says that scientists have discovered a revolutionary new treatment that makes you live longer. Of the 3 pillars of health, first is, of course, sleep, second is nutrition, and third is movement. Right? If you get sleep right, you're getting 60% right. Of course, if your nutrition is right, you don't eat too much mutton, you don't drink too much. No, I'm not looking at you, Tarun, but you will be okay. So I just want to, with this, say that the cohort that the jury has selected today, we've looked at the cohort. It is pretty much a national cohort, both in 40 under 40 and 30 under 30. We could have done this on Zoom, but the idea to do it one day is to be able to get all of you to meet each other. So after the awards, stay back, meet each other, collaborate with each other. The relationships you may form today in this room, we carry on for a long time, both professionally and personally. That's what I'd say. Good luck to the families who are here to applaud the recognition of their family members, and the ones that didn't make today, play well. Like there are some people I met and I know them a little bit, and I asked their age, and somebody was 35. So I said, you can apply to 40 under 40 next year. There are winners who applied earlier. Some have applied for 3 years to get to the 4th year and win. Some have applied 2 of those years, and we really leave it to the jury. So my gratitude to Mr. Lalit Basin, all the jury members of the 40 under 40 and the jury members of the 30 under 30 to do a job at selection. Their time and attention are the 2 biggest things you can give anyone. And last but not the least, हिंदुस्तान में ना ताली कम बजाते हैं लोग, तो जब आप लोग आओ तो अपने दोस्तों के लिए ताली जरूर बजा देना. And clapping is good for art. So thank you, God bless you. The reason I brought this education issue is that we also ran in the top law school. It is only the 2nd year. Now the 3rd year will come, and these will not be the platform. So what you say in your receptive speeches, 2nd, definitely not more than 60. Maybe count because the videos will go. So let's speak while this award start, and that's one order for all the winners. Thank you. God bless you.
Thank you, Dr. Bharata. Ladies and gentlemen, it is my privilege now to invite our first on the stage for this address. Please welcome to Dr. Senior Management Partner, Senior Development.
Thank you, Ms. Kaur. This is the time now for celebrations, not for any speech making. Particularly after good presentation and the message which Dr. Anurag Batra has gave to our youngsters. At 40, you tend to become naughty. So professionally, you are already well entrenched. Those who have completed 30 years, they have already put in 5-6 years of practice. Those who have completed 40 years, under 40, they have completed more than 10 to 15 years in the profession. So I have no words of advice to those because you are already established lawyers. But now is the time for you also to enjoy your profession. And how can you enjoy your profession? By looking into different aspects as to what is happening globally so far as our profession is concerned. And along with enjoyment, also think of how you can give back to the society which has given you this position and status of belonging to a very, very noble profession, whether you are in litigation or whether you are a general counsel. I think each and every one of us, I think, do perform some function for the society. And Dr. Anurag Batra spoke about sleep and all that. But my advice to you, my young friends, is that sleep comes secondary. Your first priority and commitment is to your profession. I know, and particularly those who are in the law firms and those who are general counsel, they have to burn the midnight oil. They may be talking to US, they may be talking to Japan, elsewhere, anywhere in the world. Therefore, first commitment is to your profession. It's a very tough profession. And they sometimes call it as a very jealous mistress. Therefore,
Keep that priority in mind, but enjoy, your profession. You'll be very happy to know, and I'm addressing those who belong to law firms, that the Society of Indian Law Firms, since the last 12 years, we have instituted a cricket tournament. And this year, and we are just about to complete the final, which will be between, I think, Amarchand, Mangaldas, Sam, and one other law firm. 32 teams have participated, and they belong to the legal profession. 32 teams. On weekends, they spend, time on the cricket field. And today I just finished, giving the awards to many of the winners. That is one area. And on 24th and 25th of February, SILF has organized, what is called the SILF Olympics for 2 days, which will cover different areas of sports and activities and all that. And there will be huge participation by the law firms. Therefore, enjoy the profession. Just don't confine yourself, to reading the law books or the briefs and all that. Be with your family, be with your friends, and be the sporting spirit that you are supposed to be. Thank you.
Thank you, Dr. Bhasin. Ladies and gentlemen, today's award ceremony is being streamed live across all the EW Business World platforms, including our social media channels and on www.ewworld.com. For the celebration of the evening by using the hashtag BWLegal30under30. We'll start with the award ceremony. I request all the winners to get down from the left side of the stage for photos and request all the winners to stay back till the end for the group photo for the online coverage. And now it's time here to reveal the winners of the third edition of BWLegal30 under 30 awards. And presenting the awards to my colleagues, Dr. Patra, Chairman and Editor-in-Chief, PW Business World and Founder, Exchange for Media. Welcoming Dr. Laura Bhasin, Managing Partner of Bhasin Company. Let's give a big round of applause to Geeta Lee, Senior Advocate, Superintendent of India. And welcoming Honorable Justice M. Goa, Chairman, National Company, Law Tribunal. Well, before we start, I must encourage everyone in the audience to open the loudest round of applause as to everyone members on stage. So, ladies and gentlemen, the first person to join the elite club of lawyers and legal influencers is Dr. Ramshan Mishra, lawyer and Dr. Law School. Can you please stand on the back? Check.
Hello. Okay. It's definitely a big honor to stand here and receive an award from such immense, amazing jury members and amazing panel of judges out here. And
I want to express my gratitude to the jury members. I want to thank my parents. I mean, it's an award, so I want to feel like I've received an Oscar. So I'm going to thank my parents. I am going to thank my partner, my in-laws, my mentors, my organization, and thank you so much. And it has given me a motivation and an encouragement to just keep moving and making some big changes in this world. Thank you so much.
Congratulations. Well, I must request you to kindly get off of the stage from the left side for individual pictures. And ladies and gentlemen, the next person to join this elite club is let's welcome Akshat Goyal, partners Goyal and Goyal. And accepting the award on his behalf, Mr. Chandrapal Singh. Well, his father is there. I believe Mrs. Singh is here as well. My sincerest apologies. Let's welcome Mr. Chandrapal Goyal. Ladies and gentlemen, big applause.
Hello. My son Akshit is out of India, and I feel proud to receive this back from on top of this. Thanks.
Congratulations to you. And the next winner is congratulations. Let's welcome Akhil Agarwal Associates to Sagar Associates. Mr. Agarwal.
I wasn't planning on making any speeches. So I just like to thank my parents for their support, for putting up with all the crazy hours that has led to this. I want to thank the jury members for finding something in me that's worthy of this recognition. I want to thank my brothers in arms, my colleagues at the firm who are there to support me at every step of the way. And I'd like to thank my seniors at the firm, Mr. Gupta and Mr. Agarwal, without whom I wouldn't have the opportunities or guidance to get to this place. Thank you.
Congratulations. Well, I must request all our awardees to kindly stay back with us till the end of the ceremony. And the next winner is congratulations for Amitabh Bhattad, Principal Associate, Humrub and Solomon Partners. Congratulations. Well, I must encourage you to say a few words, please.
Good evening, everyone. Thank you so much. It's indeed an honor to be receiving this award. I'd like to thank the jury who found me worthy enough to be getting this award in the first place. I'd like to thank my mentors who've tolerated and guided me so far. And I would like to thank my team and my family. And last but not the least, I would also like to thank myself
for this journey. Thank you so much.
Thank you. Thank you, Dr. Vaseem, for joining us. I would like to request Dr. Batra to stay back and everybody else to be seated. Thank you very much for your time. And to present the next set of awards, ladies and gentlemen, please welcome Poetry Anand, Senior Advocate, former ESG Supreme Court of India. With a big round of applause, please welcome Kapil Bhinde, Senior Advocate, Supreme Court of India. And welcome Sridhar Kotarajan, AOR, Supreme Court of India. Saga, the next winner is Archana Yadav, Associate Satran Das Way Income.
I just would like to thank BW Legal, the jury members, Mr. Bhasin, my mentor, Mr. Siddharth Batra, and all my colleagues and my family members as well, without whose support and without whose mentorship, I would not have been able to be here. Thank you. Thank you very much.
Check, check. Thank you very much. And the next winner in the list is check. Thank you. Big congratulations to Arjun Kumar, changes of Arjun Kumar. Can you please stand up for one minute? Thank you. Under 30, what a big accomplishment. Well, we would love to hear what you have to say at this moment.
First off, I'd really like to thank Dr. Batra and the team at BW for organizing this, the honorable jury members for picking me. And most importantly, I want to dedicate this award to my parents, my partner, and to my mentors who didn't let me sleep even when I wanted to. And I think that's something I can do here.
Arias, congratulations to you. Thank you very much. Requesting you.
No, we are BW Business World and BW Legal. BW Legal. The reason I say this is one day I went, some of you heard this story, one day I went to a party and sometimes I met someone and she said to me, "What do you do?" I said, "I work at BW." She said, "I go to BW every day, but I don't see you." I said, "I also go mostly when I'm traveling. I don't go to BW, but mostly I'm every day in BW." So I kept talking to her. After a while, I realized that BW she was talking about, BW I was talking about two different. She was talking about the nightclub in Friends Colony called Black and White. And of course, I was talking about BW Business World. So we are BW Business World. Okay. BW takes me there. Okay. Where I don't go. So anyway, congratulations. Well done. We don't have enough sponsors or no stand-up comedian today, sir. So I'm trying to fill it.
And the next winner is Associate President in Company, LLP. Audience, congratulations to you.
Hi, good evening, everybody. First of all, thank you to the honorable jury for this recognition. I definitely have to thank my mentors back at Ketan, Bharat Anand, Nidhi Kilawala, who make it possible for us to do what we do so perfectly on a daily basis and allow us and give us the exposure that has made this possible. So thank you so much to both of them. And of course, my parents and family back at home who make this possible on an everyday basis and deal with the kind of hours that we pull and still love us the same. So thank you so much, everyone.
Big congratulations, big congratulations. And the next winner in the list is. With a big round of applause, ladies and gentlemen, let's welcome Rohimmal Mitra, which was SA2 SA. Ladies and gentlemen, let's offer.
Good evening, everyone. I'd like to thank the jury members, my family members, and all my colleagues over the various years who've contributed to my success over here. Thank you.
Congratulations to you. And the next winner is. So much he does with the associate Congratulations, staff.
Thank you very much, BW and members of the jury, for considering me and giving the opportunity. My journey in this field did not start off easy, to say the least, because I'm a first-gen lawyer of my family and had to navigate my way through because I'm also from a non-national law school. But this recognition today is a testament to the fact that hard work definitely pays off sooner or later. And I would like to dedicate this to my parents, my sister and husband who's here with me today for the unwavering support. And a big shout out to my team at JSA and my seniors, Jerry and Manuel, for the constant support and guidance and for who I am here where I am today. Thank you.
That's really, this is 30 and 30s. This is absolutely surreal. Big congratulations to you. Thank you. And the next winner is. Big congratulations to Krishna Agarwal, Agarwal Law Chambers. Well, as wide as the smile is, we would love to hear what you have to say at this moment.
Thank you. Good evening, one and all. I would like to thank Dr. Batra and his team, firstly, my clients who bestowed their faith in me, my parents, my wife who's here with me, and most importantly, my team. I think nothing is possible without them. Thank you so much.
Arviz, congratulations to you. Well, I would like to thank everyone for joining us on stage. Thank you very much. Requesting Dr. Batra to kindly stay back with us. And to present the next set of awards, please welcome Sudhir Sharma from Trust Legal. Please give it up for Meaning with us on our scene in Goa.
And the next winner is congratulations for Team Senior Associate Raf and Partners. Now what's best? A lucky coincidence of this time. Congratulations to you.
Yeah. Hi, thank you everyone. It's a great day and a very proud moment to finally receive this award. And I can't thank my mentors, Vaibhav, Sahil, and Stigdil, for constant support for all the years. And my parents and my life partner Avneet, who have constantly supported me and been supported me through all my difficult days. So really glad, and it's indeed a great achievement, and I believe it's a beginning of something great to come.
100% big congratulations to you. And the next winner in the list is all our winners to kindly exit the screen from next side for individual pictures. Please welcome Taylor Garner, Associate Director, Space Regulation, Nuba Space. Then gentlemen will celebrate 30 under 30. Audience, congratulations to you.
You round of applause for Kevin, yeah. Thank you.
And my days of
Seniors have gained a lot of advantage. But the thing is that I think that by simply the rest of the students. Congratulations to Congratulations to the stars who participated for the teacher conferences.
Let's put up a everything. I will say once again, let's give it up for we are Chopra. We have associated with funds and financial services. Thank you for
recognizing diversity and background. And thank you so
let's put it up Saga, founder, let's go unfortunately not that us, but it's the world and absolutely.
for such a principal associate, the congratulations to you. Let's take a vote on your behalf. Let's give it up for Shivani Chopra, Senior Associate for Granta Spray and Company.
I would like to thank the jury members for giving me this opportunity. And I would also like to thank my mentor, my colleagues, and my family for helping me and guiding me so that I could be here. Thank you, everyone.
Congratulations, Carol, and the best winner is.
Audience, congratulations to Shubham, he has ESL star.
So, firstly, I would like to thank Business World for this platform, the entire team for organizing this, Mr. Batra for encouraging us throughout. And I think for me, Vedanta is institution because they have put in their bet on me by making me the youngest head legal for their one of the businesses. So thanks to Vedanta for providing me the opportunity to learn, unlearn, and explore. All my mentors, all my colleagues, all my teammates, it's pretty difficult to work with a very young head legal. So for trusting me in all my advices and my opinion. And finally, and the most important one, my family, my sister, my husband, who's here, who encourages me, and everyone. And congratulations to all. It's an honor to be a part of such an elite club. Thank you so much.
Thank you very much, Madam. Congratulations to you. And this is
I just want to say both Siddharth and Tarun were winners of the first cohort of BW Legal World, 40 and the 40. We got them to really more than that. So this year also, some of our 40 and the 40 will request to do jury duties for the 30 and the 30. So they won in the first year, and they've done jury duties in 2 years. So I just want to say that.
Congratulations to principal associate, staff and service advocating their achievements.
Thank you.
She won't believe it. Because 20-year-old, I don't think I would have believed that I would be doing what I'm doing now and would be leading a lot of things that I'm doing now. So that 20-year-old is definitely surprised and happy and glad that what we're doing is fun now. To receive this award, it's definitely surprising. Thanks to the jury member for believing in me, in what I said in my application. And of course, I do definitely want to thank my parents for believing in my career choices when back in Bihar, UP aspirants are the major career choices we have. I would like to thank my partners, Jidesh and Rajesh Sivaswamy, for their unwavering support in all I do. Thanks to my friend who's here taking pictures for coming along. I just had her come along to support me. Thank you, everyone. And to all the awardees, congratulations. Let's continue making warriors, guys. Thank you. Well, a big shout out to all the friends and family members that will actually take pictures and it's your planning to post the posts. Social media platforms. Don't forget to use the hashtag. Could you want to that person and the developers? Social expansion law offices. Congratulations to
you for selecting me. I would also like to thank my firm, my mentors Seema, Alishan, Dimple, and Dhruv. And I would also like to thank my family as well. Thank you.
Short ones. Let's look at the transfer on senior associate of the banking company LSL. Let's look at the
Yeah, thank you so much. I am grateful to receive this award and I thank all the jury members. To see people we admire in court giving us these awards, I'm very, very grateful. Especially Pinky ma'am, I briefed her in my first year of profession and I'm very happy that I'm here in the same room as her. I thank my wife, who I feel inspired with. She's an independent counsel. She's here with me. I thank my brother and my family. Thank you so much.
Let's give it up for the Shawnee Goyal Senior Associates Ralph and Partners.
It's really humbling to have received this. I am thankful to the jury members who repose that faith in me and giving me this recognition. It really feels great to be a part of the club. And I think most of all, I'm thankful to my family, to my colleagues, seniors who have been a part of my journey and who gave me the opportunity to work and make myself grow and be here today. And thank you to BW Legal. It's highly motivating to have received this, and I aspire to do better in future. Thank you.
So that means I announce a couple of things then. Not just congratulations to you. Well, I'm never to watch the final I must say that everybody has been how strong the president and let's get it up there. So down say of song and legal counsel.
Thank you. Thank you to BW Legal. Thank you to the jury. I don't want to spend too much time talking. The idea is to move forward and do better things from here. Just one thing that I wanted to say was to be a trusted advisor, which is all of us in this room, you need to have some trust reposed upon you. And for that, I thank my mentors, Arpita Sen, Vaishali Ars, Sharleen Anaya, Mahadevan sir, and all the folks at my current investment bank where I work at Novista Capital, the managing partner, Ripunjay Mehta. I think I've been reposed with great trust, and I think that trust is something that I want to validate every single time that I get up and go to work for. I'd like to thank my parents who are the source of not just who I am, but also what I am going to be because they are such great role models. And I'd like to thank my lovely wife who isn't here and my 4-month-old who is back home.
How lovely is that?
Gonna meet them tomorrow. So thank you very much, everybody.
Audience, congratulations to you. Big congratulations. The let's not do that because it's stronger than what's right from myself.
Thanks, Vignesh. I'd firstly like to thank Business World Legal and the members of the jury. It's such a great honor and such a humbling experience to be here today. I'd like to thank my family, especially my grandfather, Mr. Elia Dakha, and my mother, Ripu Dakha. And I really hope to follow in their footsteps and uphold the integrity that they've built into the profession for their name. I'd like to thank my grandmother, Krishna Dakha, my sister, Bhavya Mehta, and my husband, Haram Mehta, whose unwavering support has been instrumental in making me reach where I have reached today. I'd also especially like to thank my in-laws, Rupa and Jayesh Mehta and Pooja and Aditya Tiwari, whose support has been so relentless. And honestly, I mean, it's such a change and such a welcoming thing to see that in-laws these days are so supportive. And I'd like to thank them for that.
Miss Neeta, how about
Congratulations. Thank you. Just another short thank yous. I can't use this opportunity and not thank my mentors at Shardul Amarchand Mangaldas, Shardul Sir, Pallavi Ma'am, Dhruv Diwan, Smarika Singh, Rohan Batra, and Reena Chaudhary, who molded me not only as a lawyer but also as a person. And I'd like to thank my teachers at National Law School, Bangalore, and Sardar Patel Vidyalaya in Delhi for making me who I am. Thank you so much.
Congratulations, Well, a big thank you to our example. Thank you for joining us. And then more out and wherein we love to call this a resting all the ways on stage with trophies.
All the jury members of the 30 and the 30 were there.
On the stage, I have to learn from the importance of the organization that you are supposed to understand.
Please. Address the young people. Other junior members, I don't know.
Some of you might.
We need one more chair. Can we get one more chair?
Yes, over here.
बार में मोदी जी 3 कंट्री हो गया whatever it is. Yes. And one
I must request all of you kindly stay while the celebration of the time. Thank you.
Congratulations once again to all of you. Thank you. Congratulations. You're very sensitive, sir. Julie, I remember. Thank you. Congratulations to all of you.
Much like the school assembly was I would like to ask everyone to kindly stay back for the celebratory networking. Audience, congratulations to you all. Thank you very much for joining. The same with when judges now it's legal influences against 2022. Celebrating the young, let's celebrate the future masters of the legal industry. I want to the field edition of the PWD that is celebrated and become the senior masters with demonstrated exceptional legal skills. I would like to take this moment and express our purpose strategy to our discoveries, documents, should factor, John Travel, great exchange in IWMs, in fact, which once again, ceremony is being streamed live across all platforms, including social media channels and once again, encouraging everyone to post, comment, event across your social media platforms. Please do not forget to use the hashtag. Again, start, I would like to best all the ways to exchange from the website and requesting a kind stay back with us till the end so, ladies and gentlemen, to the winners of the fourth edition of welcome, Dr. Adhiraj Batra, Chairman and Editor and Chief World and Founder, Exchange for Media. Welcome, Dr. Lalit Singh, it's super easy to have both the parts together. Please welcome Pinky Aaron, Senior Executive Founder, who is Super Coach of India. Chairman, ladies and gentlemen, let me and the winner is edition 40 under 40. And the winner is Rashid Awad, Deputy Vice President of HDFC Bank.
Hi, good evening, everyone. So as Dr. Batra said, I think my parents planned well in advance. They gave me a name starting with AA. So at least I come first somewhere. Jokes aside, thank you to BW Legal for this incredible honor. I'm also grateful for the support of my family members, my husband, my friends, my team members, and my mentors. This award is actually a testament to their dedication and hard work. So I would just say, let's keep working harder, inspiring others and getting inspired. Thank you.
Arushi is the first winner of the fourth edition of the BW Legal World.
Welcome to the I will not some clapping on them.
So thanks for that. Surekha, you can grab the body.
Well, I do understand that almost everybody in this room belongs to a serious profession, but tonight is about service, tonight is about hard work. Like in terms of the eldest round of this, I shall welcome all our winners. And the next winner, the 40 and the 40 is. Ladies and gentlemen, let's give it up for Abhay. Shut up, partner litigation, arbitration, and dispute resolution economy best practice.
So, a few words, please. Thank you for saying that. That's very kind. So I'm going to flip it a little bit. I'd like to actually start by thanking my team at ELP, because without them, I don't think that we'd be able to get anything done. They're very bright young lawyers who constantly support us and make sure that we look good, so we get to take all the credit. Also, I'd like to thank, of course, BW Legal, the entire jury for having faith in me, the senior leadership at ELP, my colleagues, my former partner, Harsh Kaushik, who was a mentor and taught me pretty much everything I know. And of course, my family and my dog. He's very important to me as well. So thank you so much for this, and thank you for the time.
Adios, congratulations, sir. Well, as we move forward, I must request all our winners, all the winners, for celebration. But next is and let's give it up for Abhinav Alai, the partner August.
Hi, firstly, I think thank you to the jury of BW. I think any award, at our stage is always a dedication to the team. And then the team which I've had over a very long period of time, and very thankful that they've been with me for a long time, and we've been able to do what we've been able to do. So I think this is really an award for them and the institution that we're building at Argus. Thank you very much.
Congratulations, team. Thank you very much. And the next one is ladies and gentlemen, let's give it up for Abhinav Sharma, Associate Rentals, Legal. Sharma, a few words.
Good evening, ladies and gentlemen. I'll keep this short and sweet. I'd like to thank the jury, Dr. Batra and his team, and last but definitely not the least, my wife, who nudges me to do better. Thank you.
Adios, congratulations to you from the left side, please. And also, I would like to thank Dr. Singh and Jessica Singh. Requesting Dr. Batra to kindly stand back for the rest of the next awards. welcome Mr. Amal Singh, Vice President That's one hand, that's the other one. We come together. That's an applause. Love her. And here's a welcome, Linda. It's over. And the next winner is let's give it for Agaraj Singh, Associate General Counsel of my church.
Thank you so much, everyone, for coming out this evening, and thank you so much for taking time out to encourage everyone in this room to do better and to achieve better. My full gratitude to everyone. Thank you. Only 60% off for all winners. But we have availability. Thank you so much, Ajay. We are grateful. 10% तो दे दो यार. So आप ऑफ दोगे बताओ.
Whatever you.
Adios, congratulations to everybody. The next award winner. Let's make it a louder round of applause. Give it up for our secret Captain Dua, partner, SOG, and parties. That a lot of serious, nice, lived out functions of loved ones, and whatnot, birthday parties. This is what all the things to must request you to also understand everyone.
Thank you. I remember watching an old video of Mr. Karanjawala, sir. He was introducing the awards, and what he said was that this does not promise to make you richer if you make it to the list or give you a bigger practice, but it will give you serious bragging rights. So, congratulations to all the winners tonight. And lastly, I believe that this award is not for me, but for the ecosystem because of which I exist. My parents, my beautiful wife Asta. It's a birthday tomorrow, so happy birthday, and this is for you. And lastly, my mentors Amit Agarwal and Devyani Dhan. Amit Agarwal is here. His wife is recovering from medical surgery, and he's still there only to cheer for me. Thank you so much, sir. Whatever I've done, crawl, walk, run, it's all because of you. Thank you so much.
Adios, congratulations to you and the next winner is let's give it to Mr. Arnold.
Thank you for this incredible honor. I'm truly humbled to be recognized among such accomplished peers. I would like to thank God, my family, my incredible team, my mentors, and my friends and family. Family, I say twice because their role is incredible in where I am today. I am grateful for the opportunities to make a positive impact through law, and I'm excited for what lies ahead. Thank you.
Let's put it up for partner artist partners, and accepting the award on this one. And still, even though Ankit is not here, but so let's just bring one up. Thank you. And the next one is expecting another people at the back. Ladies and gentlemen, let's give it up for Aruna Burhan, partner executives at our Adios, congratulations.
Thank you. Again, thank you to the members of the jury and BW for organizing this and for this great award. I am really grateful for the support and guidance of my mentors, my family, and my colleagues for putting up with me and for helping me reach this milestone, and looking forward to many more milestones in the future. Thank you.
Thank you very much. Congratulations. And also, I'd like to thank Ms. Lupa and Mr. Kumar for joining us. Thank you very much. Requesting Dr. Batra to kindly stand back and to present the preset awards from Subcommittee Vice President Leader and CSTC Administrator. Let's welcome the now attending the first winner is Audience, congratulations to Rupad Ajay Vadani, partner, Atena, Practices. Congratulations.
Thank you so much. I'm deeply honored and humbled for this award, and a special mention to my family, my wife, and my son, 4-year-old son. His encouraging word has helped me to get this award. Thank you so much.
Once again, the question is the stage from the website of the and the question is let's give it up for Doctor Abhishek Sinha, Associate and Professor in the School of Law. Let's clap first.
That's perfectly fine. Thank you. It's a difficult task, calling a law professor on the podium with a room full of people and then handing over the mic. And also saying that, 60 seconds of the time. But jokes apart, heartfelt gratitude and thanks to BW World, the jury, my family and friends. Now that I have exchanged the pleasantries, its acceptance speech will not be complete without an appeal. I take this opportunity because this world is full of top legal experts and the field of legal education needs each one of you. I know all of you have a busy schedule, but please, it's a request with folded hands. It's an humble request. Please take out time, some time, even if it is like a few hours in the entire year. Please go and visit law schools. The law student needs you. Please do that. It's not that you should only come to my law school, which is UPS, go to any law school. But please do that. So see you soon at law schools. Thank you very much.
Yes, legal world can help you with that job.
Yes, thank you.
So talk to Garvin, she'll help you. Whoever you want to bring.
The last one celebrates. The last is the future. How about monsters of the as well? And the next list is and let's give it up for the doctor. Shashwat Rajpai from the background our expert on this. Let's have a gentleman.
So it's doctor, that's why they started. I have to thank the entire BW legal team and, of course, the brilliant jury committee members that they were there. It's a privilege to receive this award. Obviously, I wouldn't be here if it wasn't for my parents and, of course, my wife and sister. And I'm not going to give any acceptance speech, but I just want to say one thing, and it's actually to take a leaf out of Dr. Batra's books that he was narrating. There's a book, Atomic Habits. It basically says that you make small changes in habits, good habits, of course, every morning, the moment you get up. And that actually gets you down the line on a much better platform. So that's it. Thank you, everyone. And thank you to all the awardees as well. Thank you.
Marius, congratulations. Well, then I got the morning to skip the shot. We have to the next winner. Marius, congratulations to Extra, one of the chairs of Extra.
Thank you so much. First of all, I would like to thank the Almighty through my parents who are with me here. And I hope this award pushes me forth to take forward what I'm trying to achieve through the legal profession, that is helping everybody reach their legal services in the best possible manner, so that compassion is what wins at the end through this legal profession. And I hope I'm able to fulfill that duty towards this profession. And thank you so much, Mr. Batra and the jury, for recognizing me so that I am motivated further to take it forward. Thank you so much.
Congratulations. Well, say that this is a regulated profession and definitely emotions around it. Congratulations to you. I have seen the actual Mr. and Mr. for joining us on stage. And of course, requesting Dr. Batra to kindly stand back. And to begin the next set of events, ladies and gentlemen, please welcome that back. Trust I think it's welcome Ajit Mishra. I think.
And the winner is. Let's give it up for Gagan Sharma, Vice President Legal, M&A Corporate Strategy, Palladium Small Vessel.
Uh, Thank you, BW Legal, and the jury for giving me this award. I would also like to thank my parents, my family, and my wife. And I would like to thank my mentors in all the law firms that I've worked and my seniors at my current organization. Thank you so much.
Congratulations, sir. Well, I must request you to analyze the start from the next slide. And the next one is. And the next winner is the bottom large, bottom front
Thank you, everyone. Thank you, BW Legal. Thank you for the jury members for giving me this award. It means a lot to me. Really want to take out, a few seconds to thank my partners at work, my team at work, who help me out every day, who push me to do better. Being in a small law firm in Bangalore, I've had a lot of support from an amazing set of colleagues, peers, sometimes even counterparties on the transaction, which obviously, means a lot to me, people who, helped me, who supported me in this particular process. Lastly, most importantly, I would like to also to thank my family members, including my parents, my wife, and my kid. Thank you all. And congratulations to all the other winners.
Thank you very much. Big congratulations, Sarah, and as well. And the next one is. Let's give it up for Jagrat Singh Pindra, partner civil amateur evidence. Thank you very much. You guys are amazing.
Thank you, Dr. Batra, and the JD, and congratulations to our co-recipients tonight. And what's people.
Thank you.
Everyone keeps thanking me, but really this is Garima's show. So please give a big round of applause to Garima. There's another guy called now, it's just then there is the BW team on the audience side, Akash, and there is the marketing team, Karthik, Shweta. There are lots of people that work with us, but thank you.
Jen Partner GSA.
Yeah. Good evening, everyone. Winning an award is always satisfying and encouraging, and thanks for that. Thanking the BW team for doing that and recognizing the hard work that we do. Congratulations to everyone in this room, and look forward to have a lovely evening with you guys.
Beautiful, sir. Thank you very much. And with the same, I would like to thank our presenters for joining us. Thank you very much. Thank you. And to going back to what on social media, next 30 minutes. Let's welcome our General Counsel. Thanks, your excellence. Thank you so much. And the winner is I said something that I'm pronouncing my surname correctly. Please give it up for Krishna. Advocate and independent practitioner, lecturers of KKO. My goodness, look at your gorgeous.
I first of all would like to thank the jury members and the BW legal team. And what a coincidence it could be that it's my son's 3rd birthday today. So I would take this opportunity to wish him a very happy birthday. Prithvi, I love you, and this is for you. And I really am very grateful for my family, my husband Prateek, who's here to support me, and my parents and the entire family. I'm so thankful and so grateful. Thank you.
First of all, watching the 30 under 13 and 40 under 40, I observed. One, why is also being supported by him on himself. No, that's what we have. Second, I saw a lot of 30 under 13 only. We observed just the same. But I say, no, tongue. And he had no sponsoring. I'm doing the filling job for the stand-up committee. And next time you are when you need one, tell your boss, I'll come free. I'll even pay you money.
Congratulations, I believe Dr. Batra is taking this on behalf of all the participants around. And the next winner is ladies and gentlemen, let's give for the loudest round of applause Trophy Arjun Alani, General Manager, Service, which are scientific. Well, except
I would like to dedicate my award to all the winners here by quoting the following lines. असफलता एक चुनौती है, उसे स्वीकार करो. क्या कमी रह गई, उसे देखो और सुधार करो.
जब तक ना सफल हो नींद चैन को त्यागो तुम, संघर्ष का मैदान छोड़कर मत भागो तुम, कुछ किए बगैर ही जय जयकार नहीं होती, कोशिश करने वालों की कभी हार नहीं होती। Thank you. I think I am backed by very strong women in my life, my mom and my mom-in-law. I represent them. I want this video to be seen by my daughter, who knows that she is backed up by a very strong mom. So she represents me in future. Thank you.
How wonderful this thing. Thank you so very much, and all the very best. And the next winner is counting on the methods for this package, and let's give it up for Priti Sharma, external senior counsel, senior technical advisor. Sharma. Sharma, you would like to right. Heartiest congratulations on your please.
Hi everyone, thank you so much. This award means a lot because I am one of those examples which Dr. Batra was quoting. कि कुछ लोग 3 साल से लगे हुए हैं पर award नहीं मिल रहा है. So this was my last chance because I just turned 40, and thank you so much for this. My dearest Judy, I owe you a big one, and last 2 years have been a big transition because I transitioned from a private equity and funds lawyer into an AI and emerging technologies lawyer. It was not easy. It has been a tough path, but to whoever who is watching this, remember that success is not final, failure is not fatal. It's the courage to continue which counts. And I owe a big one to all the friends, philosophers, and guide. So thank you so much.
Well, last this, I will towards the celebratory meeting. I will get together and tell you about this. That's amazing. Congratulations.
I think so many of you are going to never ask me about my script.
And the next event is let's give it up for nothing such as our partner Lutra and Lutra Law Offices India.
That's fine. I can. So I would just want to thank BW Legal, the jury, for this award, and I would actually want to dedicate this award to our founding partner, Mr. Rajiv Luthra. This is for him. Thank you.
I just want to say 2 things. I met Mr. Rajiv Luthra sometime, 15 years back, and I can say 10 years back he became my friend. He even helped me in something personal. You know, he was in the board of the company. I got a refund from that company. Like he not the funds, but I got my money back. So he's a very kind man. He's every time he sees me, he'll say, "Chal samosa khane chalte hain." I don't know what. मैं samosa ही खाता हूँ. और भी खाता हूँ. Right, but he's a very kind man. God bless his soul. I can say. I remember one of my birthdays 3 years back. He came in, and there were like 250 people, and he entered the bar. And he looked at the whiskey and he knew blue label guy. I remember when 2 bottles of blue label were given, which between Rajiv Luthra and one more person here, they finished. You can guess which person. But he was a lovely, never a dull moment when he was around. And he was an institution, he built an institution, and he was very affectionate. He was giving, and I've had the good pleasure of meeting him on multiple occasions and always had a good laugh with him. Even in the junior, he made us laugh after every. We would, in the first year, he was, as I said, Mr. Karanjawala, Mr. Luthra, and Mr. Shardul Shroff were running the first year jury. There were other members, including Mr. Mishra, including Justice Nassima, but they were really running the jury. We were all, and he made it so much fun. The school, 10 years in the jury, 3 years. It was the first time he was not in the jury. It was so much fun. So really, we miss him. God bless him, and hope Luthra and Luthra continues to do well because it is an institution that he built. So wish you luck. I'm happy that you won.
Thank you, Dr. Gopal. And the film, I would like to Mr. Anika and Mr. Stage. And the results of the set of the answer. We also saw the instruction on the trust and the start. One was my chance of the and please welcome Mr. Amar Kubar Senior Vice President of the Corporation. The next winner is please give it up for Fire Dayal, partner corporate of HOS Partners. Well, I do understand that each and every one of my sort of family, but still, they have hard workers who achieved this. Congratulations.
Thank you. Thank you, BW legal team, the entire team. Thank you, everybody here. The esteemed jury who had the hardest role to play in selecting the deserving few. I must thank my parents and my in-laws who are watching me right now online, and my husband who's rooting for me there. Special thanks to my daughter, 6.5 years old daughter Kiara, who is also watching me online. And at that tender age, she understands as to why my mother comes late from work. And tirelessly, she waits every single day for me. And she's more than happy, most happiest to have received this award. And I can say that on her behalf. Before I go, I would like to just say one more thing, a very private conversation between my father and myself about 2 decades back. This was when I started law school, and my father was oblivious to the fact that I was very happy. So he asked me that, darling, I hope we've done justice to you by putting you in a law college. I hope you didn't want to do anything else. So, Dad, I waited so long to answer this by yet another question that I hope I've done justice to the good education that you've given to me. So thank you.
My goodness, my goodness. Absolutely inspirational. Congratulations. Last one, I must request all the winners to kindly stay back till the end. That's what my husband. Moving on, the next winner is. Ladies and gentlemen, let's give it up for Rohit Gujranwala, partner, Sarafin Partners.
I'd like to thank all of you all for standing for this long and patiently giving away all the awards. I'd like to really thank my first boss, Vijaya Rao, who saw something in me and reposed faith in me and made me believe that I could survive in this profession. And of course, I'd like to thank the senior leadership of our firm, Mr. Saraf, my boss, Bekash, my team who's worked with me over all these years from time to time, my current team. And last but not least, my family, my parents, my wife who's here, and my children who inspire me every day to work hard and, do something that, they'll be proud of. So, yeah, this is for them. Thanks.
Congratulations to you. Next, Dr. Sahil Arora, partner, Serap's office. I don't think congratulations, but not about saying few things.
Thanks. Thanks so very much. Thank you, BW Legal and everyone here. The jury, thanks so much. Must have been intense work. Could not thank my team enough. They work hard, and because of them, we look good. So thank you so very much, everyone. I do want to thank Mr. Saraf. I want to thank Vaibhav. My team's here. Snigdhanil Keshav's here. But more than anybody, want to thank Sandeep Dudeja. God bless his soul. He touched our lives and just made it beautiful. I can't thank him enough. Last but not the least, my family. Thanks. They tolerate the crazy hours, and my 8-month-old. Looking at him, all the time away. His time away from him. So this is absolutely for my family, my wife, and my 8-month-old son. Thank you so very much.
Congratulations to you. Let's give it up for Samantha Fernandez. Thank you very much. Congratulations, Samantha.
Thank you. Good evening, everyone. It's an absolute honor and privilege to receive this award, and I would like to thank the eminent jury members and Dr. Batra and the entire BW legal world. Many thanks and many congratulations to all the winners here tonight.
Congratulations to you as well. And the next is congratulations to Sanjay Prakash Advocate Supreme Court of India. Well, I think that would be the last one of the win.
Firstly, to the jury, of course, the esteemed people who thought I ought to deserve this recognition. Of course, BW Legal. Secondly, moving on, can't go without mentioning my mother. It's quite fortuitous that she's here
Um, she operates at a different level. She has and she continues to operate at a different level. If I'm perhaps able to achieve a fraction of that, I would reach quite. Actually, I would not get more personal belief. My father, my sisters here, of course, my seniors and senior advocates. There are quite a few actually, since I've had the privilege of working around the country. There are quite a few. I'm not going to go down that road, at least not now. And of course, I can't close it without giving thanks to my juniors over the years. So I'm grateful for their help over the years as well to reach where I am. Thanks. Thanks.
Well, that was the first. And with the same, thank you, gentlemen. Thank you for joining us on stage. And to present the next set of awards, please welcome Sri EOR Supreme Court of India. Let's give it up for Ajit Mishra, partner in Knights PLC. Next winner is addressing the elephant category. We are heading towards the final two awards. The next give it up for Shilpa Notyal, Vice President Legal, HDFC Bank Limited.
Loving it. Thank you. Well, I'm getting this award for the category of 40 under 40, but the rush and thrill I have is for 20-year-old. Takes me back to my college days. Thank you, BW Legal. Happy to be part of your family. Thank you to the jury for recognizing my contributions. Well, success in corporate world is not a solitary journey. I owe immense gratitude to my family, my friends, my peers, my seniors, and my team. I would not have done it without them. They believed in me, especially during times of self-doubt. And this is a shared victory. This award is as much theirs as it's mine. Thank you so much. Thank you.
Well said. Congratulations. And the next award goes to ladies and gentlemen, let's give it up for belonging to Dr. CSE Advocate Service.
Good evening, everyone. Thank you, BW Legal, as well as the jury members for this recognition. Of course, this would not have been possible without my family's support and my colleagues in JSA, and I thank each and every one of them. Thank you again.
Let's get up first. When you start the partners are up departments.
I think let's start with sitting on a subject. Thank you so much for that. Thank you for that. I think it's just
So, I will this is last one, we started off as a first year associate as the first year of my work, I started working with him and I still continue. It's because of him. Second, Saurabh Tiwari, he's also out there. He's been a wonderful leader to me. I've learned a lot of leadership. So, friend, it's not this is the laws of Joyce mistress, and I spent a lot of time in work. So I have to thank my family for everything. I thank my wife for putting up with all of this. And thanks to all of you, I'm so proud and honored to be part of such beautiful and illustrious people. Thank you. Let's give it up for super products, partner difference. And Kasuba advocates and attorneys.
Thank you so much. Needless to say, this is a tribute to the entire team that backs me up. And of course, to the leadership at KSK as well, Mr. Jadesh Kumar and Mr. Rajesh Sivaswamy. Thank you for letting me do what I do the way I do it and for trusting me with the same. For all the clients, of course, for imposing their trust in me also. For my team, who relentlessly works, is even working right now, for that matter, on a Sunday evening. So a big thanks for that. And of course, to my parents and my parents-in-law, whom I don't think I thank enough, and to my wife, Apeksha, who I cannot thank enough for that matter. Thank you so much, everyone.
Congratulations. The last word of the final few words of the event, so we're requesting all the witnesses for 2020 Congress and the next few minutes. Let's get ready to get applause for Philip Agarwal, founder and managing partner, Next Week Law Advisors. And we have Ravisha Agarwal Associate joining us on his behalf to accept the award.
Good evening, everybody. First of all, I begin with extending my deepest gratitude to the BW Legal World team and the esteemed jury who is gathered here and presenting the award. Sumit sir couldn't be here, but he wishes to express his greatest appreciation for recognizing him on the 40 under 40 Legal World Award. So before I accept the award and sit back, it would be only fair that I just touch base upon how incredible and remarkable his journey has been. It began 2 decades ago when he joined SEBI as the youngest SEBI officer, and then went ahead and authored the only commentary on SEBI Act. and later on established Reg Street Law Advisors, a regulatory law firm of India. And perhaps this firm has obtained the highest amount of exonerations for not only mutual funds, but also insider trading cases, and as well as people who have been charged with insider trading, such as Arshad Warsi or the late Mr. Rakesh Jhunjhunwala. It has been a pleasure representing the regulators as well as the regulating entities. I extend my deepest gratitude to the BW team, not to mention Ms. Garima and Dr. Batra for his insights. Thank you.
Sumit, and you should get the best award for marketing of legal services. It's not allowed, but you will add to the category. Thank you.
Congratulations. Thank you very much. Thank you, gentlemen, for joining us. Thank you very much. Requesting Dr. Batra to guide us back and to present the final set of awards, ladies and gentlemen. Please welcome Mr. Kevin Media, Associate Editor Sex. Around the responsibility member. Welcome one of the young director leader flashbacks. And I'm saying this for the last. Please welcome Karina and Richard as he's here to build up the world. And the award goes on. Audience, congratulations to Swati Mitchell, Senior Associate in Service.
Thank you, everyone. I would like to extend my thanks to BW Legal team and esteemed jury for recognizing my contributions and to consider me deserving for this award. And I would like to express my gratitude to both mentors in my profession, as in my law professors, as well as in my faith. And the biggest thank you to my family, my parents, my brother, and my friends, one of whom was sitting here and has been waiting for recording this video. Thank you, everyone, so much. Thank you.
Congratulations. It's congratulations to founder and COO of this.
Good evening, everyone. Immense gratitude to my parents, my wife, my in-laws who are watching this online, and also to law students who have shown trust in Loctopus Law School over the last 13 years now. And immense gratitude to late Professor Shamnad Bashir, who kickstarted my entrepreneurial journey in sorts. Okay, thanks a lot. Thank you.
And the next one is Sharma, partner, Visa and Visa offices, India. Congratulations, Mr. Shani.
Thank you, everyone. Good evening, and thanks for waiting. Thank you, Dr. Batra, BW Legal team, and the esteemed jury. I dedicate this award to my family, my firm, all my seniors, my team members, my mentor, my teachers, and my support staff. Thank you very much.
And the final award that we expected, Mr. Panish, Mr. Panish, and the winner is the congratulations to the Bobby partners that are partners. We have the significant award accepting the award.
So, waiting for the support of communication. Would like to thank all the partners, senior leadership at the firm, and all of the team that works with, and of course his wife and his lovely little kid Wade. And yeah, he's really happy to receive this award, and unfortunately couldn't be here.
So I'm listening on the stage as it's time for the central that request all the winners for the 40 and the 40 to join us on the stage. And requesting the jury to join us on stage for the winner photo. All the journalists on stage. Once again, big congratulations to all the winners for the 40 under and 40 under 40. I must request everyone to guide so hard for the celebratory requesting the jury to guide us on stage. And the call on the